We have created a unit and called the specialized unit that is trying to absorb some of the cases. We've been around now for a little over a year, but the way things are set up right now, my name starts out as a placeholder. And then depending on what other lawyers we have available, I assign those cases to other lawyers. So yes, my name is on quite a few cases. I do not intend for it to remain that way. And my jurisdiction is statewide. I was in Screven County yesterday and Ware County the day before that. And
so not sustainable for you personally, which is why the placeholder Regis will become Smith, Jones, whatever the replacement, the substitute counsel will be.
Yes, Your Honor. And we have a new contractor and we have another lawyer starting December 16th. But yes, it is not sustainable for me personally to be in multiple places at the same time.
Sure. Is there a vision, either yours or management's at GPDC, as to where you personally will be focusing? And it may be that you're a supervisor, and so 99% of the cases that currently say Regis will say Smith or Jones or another name.
I tend to travel the state trying murder cases.
Okay.
So if that is a specialty or some sort of exclusive type thing, but that is the way things are shaping out now. I travel the state trying mostly murder cases.
Okay.
And I have some in Fulton as well. But
sure. So as I'm working with my colleagues, if we see your name, like Mr. Robinson's case, not a murder charge, the allegation is a single home invasion with several victims of an armed robbery, but a single incident, one house, no one's dead. That doesn't sound like the kind of case that ultimately you would keep, but that you would delegate or assign, or someone from GPDC would assign to people joining your team.
To the extent that's possible. I have personally talked to Mr. Robinson and I told him that I would be representing him, and that's based on our interaction. Now, also an investigator from my unit also spoke with him. So if I make a representation of somebody that I intend to represent them, it is my preference to honor that representation. So I intend to represent Mr. Robinson. If that changes, of course, we'll file the proper paperwork. But as things stand right now, I intend to represent him. And I think I filed a motion for bond as well on his behalf. Not to be heard today, of course. But
No. Look at that. You did. So your entry of appearance is there. And then a few days later, you did file something. And no, it won't be heard today because, of course, we're trying to find a prosecutor to connect with you so that we can move this case in particular. Mr. Robinson and one of his co-defendants have been in custody for a long time. The co-defendant is serving a many year revocation. Mr. Robinson, this is the only thing holding him in. He was on the eve of trial and the attorney he retained withdrew, which was a crushing setback for him. We were ready to try it. And that was most unfortunate. And I feel for Mr. Robinson. And I'm asking you more questions than I normally would with a new attorney parachuting in, not because of you personally. You sound like you have an exciting docket that takes you around the state. I'm trying to better understand GPDC's approach. And I'm reassured now that I understand it won't be Mr. Regis needing to be in 16 different courtrooms just in Fulton County on a bunch of different cases. And then I heard Screven and these other places, but that some of these cases will be spun off.
That is that is the plan. And as far as Mr. Robinson,
can they hear me?
We can hear you.
Oh, okay.
I'm going to mute you for right now. Okay. There we go.
And Mr. Robinson, and I feel awful, and that's why I personally went to see him a couple of weeks, well, two Sundays ago, because he'd had two private attorneys, and then our office initially had a conflict because of a previous attorney representing a co-defendant, but that co-defendant and our attorney never, based on our interaction with the co-defendant, I think his name is Mr. Pritchett, there does not appear to be any imminent conflict. So that's why I felt confident enough that we can file an insurance on Mr. Robinson's behalf.
Okay. And do you think so his case is one once we establish counsel, which we have, that we will fast track back to a trial calendar. Obviously, you need to get prepared, so it won't be fast track. And I'm not interested in your level of preparedness. I'm interested in that. But once you tell me I am ready to move forward, and the good news is Mr. Hiles has been very open to working with the various defense attorneys to say, discovery is so large, let me help you focus on, these are the phone calls and this that the state will be relying on. It has helped streamline things for other defense attorneys. But to get to the point, assuming in 2 months you say, I'm ready, I'm familiar enough with the case, I'm ready, do we then need to get in line behind Chatham County and Houston County because of your other obligations? Or how do you, as you look out across the next 6 months of your professional life, do you already know, hey, I'm specially set in every other county between now and July?
And I tend to see things in terms of what's specially set, rightly or wrongly.
Mm-hmm.
I have a specially set murder trial in Emmanuel County, that's Swainsboro, that is starting on December 12th. And I have a specially set trial in Fulton in February. As far as I know, as I stand here, those are the only 2 specially set trials I have.
Okay.
So anytime other than December 12th, and that trial is expected to last 2 weeks.
And this won't happen this calendar year. So it would more be the February one we need to be looking out for. What's the best way for Ms. Nelson, who's seated right here, my litigation manager and sort of the pulsing heartbeat of making sure criminal cases are moving along? What's the best way for her to stay in touch with you? Is it email or phone, or what do you find most readily?
Email. I would imagine there is a phone number on that motion, but I would not say that is the best way.
Okay.
I am absolutely amenable to giving her my cell number, which is in my pocket almost always.
Okay.
I'm amenable to doing that as well.
Great. I'll have her ask you for that via email, or you can jot it down and leave it with her before you go. And I will be sure to share with my colleagues that you're going to clone yourself, so to speak, because we actually did a query on your name in our case management system, because each judge was saying, well, wait a minute, no, I've got cases with Mr. Regas. No, I've got cases with Mr. Regas. And it just wasn't going to be something that was sustainable for you or for the judges. But I'll let them know that the plan is fairly soon to have folks come behind you to say, well, I'm going to offload this one from Mr. Regas and I'll take that case.
And we are doing everything in our power to add more attorneys. It is not happening as readily as none of us would like, and I apologize for that.
So first of all, it's not on you. I'm happy to see you in person. There will be maybe some frustration that you hear because we, Superior Court, have stood up with generous funding from the county, a parallel C3 program that we talked about with Ms. Ali. This isn't news to her, just to help fill the void because of the hiring issues. And we actually got it up and running and had begun to assign unrepresented C3 defendants to defense attorneys who've said, I'm willing to take a case or two, not contract, but I'll just on a client by client basis. And we were starting to assign them. And all of a sudden this Regas name kept showing up on all the cases. And so it's good that GPDC is stepping up, but it may be, and I don't want you to be surprised by it if it happens, it may be that we reach out to GPDC management to say, if you know you're not going to be able to remove some of these from Mr. Regas in the next 3 months, we could, because we have lawyers who have said, I'm willing to take qualified lawyers, because I'm willing to take some C3 cases, because they were ready. And we literally were in the process of assigning them. But the instruction was like, well, just one last check in the docket to make sure, for example, Mr. Robinson had said, I might try to hire someone if I can afford someone. He can't. They spent all his money on the previous 2. And so Mr. Robinson was being assigned to Attorney X. And then I got a call from our administrator saying, Mr. Regas has filed, I never heard of you. And I looked it up like, oh, GPDC. But then, as I said, you kept popping up everywhere. So we may discuss with management whether there's a way to say some of the cases, instead of waiting and hoping, that you're able to fill some of the positions you've described, because we've got attorneys on the ready that we might be able to do that. But that would have to be a collaborative venture, because you are counsel of record and no one's going to remove you from that representation. It would need to be something where GPDC said, look, we've done a little triage and we're not going to be able to staff these other than having your name on it for the next X months. And we'll say, all right, then with your permission, you personally and GPDC's, maybe there could be a withdrawal and we slot in one of the lawyers who has said, I'm willing to take a couple cases. And the focus there is simply to get lawyers to these unrepresented, incarcerated defendants. It's the same passion you've got for it. And I have the same concern you have for Mr. Robinson. I don't know if he did it or not. That's not the point. The point is we can't get him to trial because he didn't have a lawyer or his lawyer withdrew. So I'm glad you're here. And I'm hearing you say, as to Robinson, at least you're sticking with it as best you can.
I personally made that representation to him 2 Sundays ago, and I intend to honor it, Your Honor.
Okay. This has been a real helpful conversation. I'm glad I can put a face to the name now. I will let my colleagues know the situation you find yourself in, which is your name is on everything, but it may not end up being you in the end. And that's a dynamic situation. I wish you luck with that.
Thank you, Your Honor.
All right. You have any questions about anything we talked about?
I do not, Your Honor.
What's the report on Mr. Hiles? Because I want to make sure he gets to Mr. Regis as a kind of Thanksgiving treat discovery in this case.
Yes, Judge. I spoke to Mr. Hiles, EDA Hiles, and he stated that he did see the entry of appearance from Mr. Regis, and he is turning over discovery as soon as he can to him. He thought this hearing was at 9:30 instead of 9. So he's at a 9 a.m. hearing in front of Judge Drake. And so
Okay.
he couldn't come up here.
Judge Drake. Okay. Well, I don't mind that he's
coming after his hearing.
got it. All right. Well, his 9 a.m. is now at 9:30. Mr. Regis, I guess you already have at least one Fulton case you're active on because it's specially set. Mr. Hiles will be sending you likely some links and then the discovery you download, as opposed to the good old days where you'd get a thumb drive or a thick manila envelope. This case, I know because it was one of the reasons we had to continue Mr. Robinson's trial at least once, involves a bunch of, I don't know if it's Instagram, but there's some social media that's available in digital format. Mr. Hiles has been very open to saying, let me help you navigate it based on the way the DA's office was able to harvest it. So you may get what looks like 40 gigabytes of data and despair. When am I ever going to be able to look at that? That's where Mr. Hiles can and will let you know, here are the things that you're free to look at all of it, but here's the part that appears to be relevant to this alleged home invasion. So we'll keep in touch with you on this case in particular. It's one of my older unrepresented inmate cases, now represented. So we'll be nudging it more than some of the others. And we'll take it from there. Okay.
Thank you, Your Honor.
All right. Thank you for being here.
May I be excused?
I think so, because the next case is not yours. Is that the only one you think you had on these calendars?
And I appreciate you using the word think. That is my understanding, Your Honor.
All right. Well, get out while you can until we find, hey, this guy doesn't have a lawyer. Then you're stuck.
All right. Thank you, sir.
All right. Take care. Positions 2 through 4 are Mr. Walker. Mr. Walker, everyone else on planet Earth believes is deceased. What does the DA's office have to say about that?
Judge, that's our belief as well.
All right. We can null pros positions 2, 3, and 4.
Yes, Judge.
All right.
I will send over a draft order to Ms. Nelson today.
Thank you. That clears up one calendar, gets us to our plea and arraignment calendar. Our first position is Jose Hernandez Sabino. Deputy Gordon. Yeah, please. Is that the magic number?
A number.
A number. Okay. Is Mr. Hernandez Sabino here? He's here. Okay.
Your Honor, his attorney is John Sperling. And,
Okay.
His associate, Mr. Lauren Brown, who's been before you before,
Yes.
is going to be here. He's in an 8 a.m. City of Atlanta court appearance right now.
We'll hold for Mr. Brown's arrival.
Thank you.
Okay. Mr. Hernandez Sabino, do you need an interpreter? Or are you able to have a conversation with me?
Translator, please.
Translator. Okay, we'll order one up. Your lawyer is running a little bit late. So if you'd stay here, we'll get a translator, okay? Thanks. How did you know all this, Ms. Feely?
Mr. Brown and I are good friends from DeKalb.
Okay.
He texted me.
All right, so we'll hold for Mr. Brown. We'll order up an interpreter and note that Mr. Hernandez Sabino is not in custody anymore. Giovanni Walker. Mr. Walker, which attorney was trying to contact Ms. Wood? This was your, okay. And this is your case, or it would be if he qualifies?
Yes, Judge, and this is the gentleman who had the Nebraska address. This is his last one. I called a couple of different numbers and none of them are still working.
Okay, let me look up. So this is an incident from September 2019, over 3 years ago. And Ms. Wood, you've tried whatever numbers, addresses you could find in the system for Mr. Walker.
Yes, Judge.
All right. All right, Mr. Hand, your thoughts about Mr. Walker's situation?
Judge, the state would request a bench warrant for Mr. Walker.
Have you tried contacting the alleged victim in the case to see if she has any contact information for this person?
I have not, Judge. This is Mr. Whitenauer's case, and I'm.
Okay.
confirmed with that.
If you would pass on to him the request that he do so, and if he documents that, then I'll think about doing a bench warrant. So for now, we're going to move Mr. Walker's case to judicial hold, and I will add a bench warrant if Mr. Whitenauer can document that he successfully made contact with Ms. Citizen.
And Judge, I'll add to that. I'm showing that there was an attempt made yesterday. It wasn't successful, but
Okay.
I just want to note that.
Got it. No, I appreciate that an attempt was made, but if your office establishes contact with Ms. Citizen and she indicates this is something she remembers and wants to move forward on, then we'll do the bench warrant.
Got it, Judge.
Okay. Mr. Brown, how are you, sir? Good to see you. We have ordered up an interpreter, and once we get him or her, we can do the, all Mr. Hernandez Sabino is here for is plea and arraignment.
I get that this is funky, and so if you give me a chance to speak with him, I think I can maybe do, well, try to achieve more than maybe just that.
Fantastic. Will this be your case, Mr. Hand? All right, we've got all the pieces we need. Other than the interpreter, you're free to chat with your client. We just can't do anything official till we get an interpreter here.
Thank you for holding.
Not a problem. Christopher Getter, and I apologize if I mispronounce your name. This looks like a public defender case?
Judge, I spoke with him yesterday. I'm not sure if he wants to stick with the public defender, but I did pass him the Zoom login information.
All right. Mr. Getter, are you here? Not seeing him. And this would be who's Ms. Charles's case. Hello, Ms. Charles. Let me look. So it's an older alleged incident, but we know Mr. Getter is out and about because Ms. Wood just talked to him. So I'll call for him one more time, either, and he can appear virtually or in person. Otherwise, we'll do a bench warrant. And Ms. Wood, Mr. Getter's ambivalence was he thinks he might be able to afford an attorney, or he qualifies for your services, or where did you find him to be?
I think he probably would qualify based on my conversation with him. I just know that he's very unhappy with our office, currently.
From past experience?
Yes.
Okay.
From the pre-indictment phase, the fact that this case is 3 years old is.
Somehow your fault.
Yes.
Okay. All right. Well, hopefully he shows up. Quentin McCoy.
Mr. McCoy is,
He's at Washington.
yes, Your Honor, and that would be mine. I need to Zoom with him in a breakout session or call him briefly this morning. during the
Okay.
break.
Washington State Prison, you guys still there? It's now an empty chair, unfortunately. We won't let him go. We'll ask to unmute and wait to hear from them. All right, we'll come back to that. But that's your matter, Ms. Feely?
Yes, Your Honor.
Okay. Oh, he's got two cases. And Mr. Hand, do you have number 5 and not number 4, or what? How is this dividing up in your office?
Both are Mr. Whitenhour's, Judge.
Okay. And where might he be?
He is sick, Judge.
Okay, so who's covering for him today?
Myself, Judge.
Okay. Michael Palmer.
Judge, he's present. He has indicated that he's hired Ed Adams and that Mr. Adams is going to be late this morning. He's in
Okay.
the courtroom.
How you doing, Mr. Palmer?
All right.
It's been a minute. So Mr. Adams is coming? All right. Great. We will hold for Mr. Adams. You've got 2 cases and we'll wait for him to show up. Tavante Williams. Hey, Mr. Williams, how are you? Good. Who is representing Mr. Williams?
I will speak with him this morning, Your Honor. I was not able to speak with him before the call of the calendar, but I'll see if he qualifies.
Great. Mr. Williams, I'm going to ask you in a few minutes to speak with Ms. Feely about representation. And if she is going to represent you, then we can go forward with what we need to today. If not, I'll give you a little time to hire a lawyer and be back here with a lawyer, okay? So please don't leave till we talk again, but in a little bit, you're going to be speaking with Ms. Feely. Leonard Jackson. All right. Who represents Mr. Jackson?
Will be mine, Judge. I went ahead and filed a waiver, but if we could come back to this one, I would like to see if we can work this one out today.
Okay, so we'll hold off on bringing Mr. Jackson out. Your case, Mr. Hand?
Yes, Judge.
Great. Kenley Horton. We got someone back at Washington. Hold on, Mr. Render. I know that's your case, but let's go back. Who do we have on the screen from Washington State Prison?
Quentin McCoy.
Quentin McCoy. Excellent. How you doing, Mr. McCoy?
I'm doing all right.
You got a bad connection right now. Can you hear us?
Yes, I can hear it clear.
Great. Mr. McCoy, your lawyer here in Fulton County, Ms. Feely, wants to speak with you privately about your situation. So we're going to figure out a way for her to call you down there so you two can have a conversation where the whole courtroom and more importantly, the prosecutor doesn't hear it all. Is there a phone number Ms. Feely can call or Ms. Feely, are you able, if you go into the jury room, to join Zoom and I can move Mr. McCoy into a breakout room?
Either one is fine.
Okay. Mr. McCoy, do you know which is better? I don't know if there's someone from Washington State there with you.
I think it'd be better for a breakout room because I don't know any number down here and she just walked out.
Okay, we'll do the breakout room. I'm going to wait for Ms. Feely to join the Zoom session, and then I'll move you and Ms. Feely into that private breakout room, okay?
Okay, thank you.
All right, sit tight. Ms. Feely, if
Sir.
you'll hold on 1 second, we're almost done with the plea and arraignment calendar, and we'll come back to getting you with Mr. McCoy. So Kenley Horton, is Kenley Horton here or online?
He's online, Judge.
Yes, I'm here.
All right, let me do a couple things here. Remove that spotlight. Are you Mr. Horton?
Yes, sir, I am.
Excellent. And let me get your lawyer with us. There we go. We've got everyone we need. And oh, funny reverb. Mr. Render, we are here. This was on an inquiry calendar a couple months ago. Tell me where we are in moving Mr. Horton's case along.
Yes, Your Honor. At that time, I did file for a mental health eval. I believe it was a week following that court date, and we are currently awaiting the finalization of that evaluation.
Tell me what that means. Has Mr. Horton been evaluated, but there's not a written report, or he has not yet been evaluated?
From my understanding, he has not yet been evaluated, Judge.
And Mr. Horton is out. He's not in custody. So is this something that you are arranging, Mr. Render, or what can I do to move this along? This is a case from March of last year.
Yes, Your Honor. I can follow up with the court. I was unaware that I don't want to get the name wrong, DBHDD. I was unaware that they would not reach out to schedule something to start the process. What I can do is I can begin that process immediately. I can spearhead the beginning of the process and get Mr. Horton evaluated as soon as possible. Again, I had no idea that it would be incumbent upon me to get the process started. I thought once I filed the paperwork, it's usually a situation where they begin.
So you say file the paperwork. I'm looking in the docket. There's nothing in the docket. What paperwork did you file and where did you file it?
We filed the motion for the comprehensive eval to the Fulton County docket. The clerk. Let me see 1 second, Judge. I can pull it up.
I'm looking in the docket and you filed a leave of absence in August, but there's nothing that's been filed since August.
That's got to be incorrect, Judge. I'm not saying that you're wrong, Judge. But I know for a fact you were very direct about the filing of this motion following the court date, and so that is exactly what my office completed. I mean. Give me 1 second, Judge. I apologize.
Okay. While you're looking, is Carrie Henderson here?
She's on Zoom.
She's on Zoom. Okay. Hold off, Ms. Henderson. Just wanting to make sure we got right folks here.
Yes, sir.
Mr. Abate, is the Phillips and Parks case yours? Okay. Ms. Feely, if you don't have any of the other, I guess you've got Ms. Henderson, so we need to, why don't we handle that while Mr. Render's trying to figure this stuff out?
Yes, sir. Thank you, Judge. Give me 1 second.
All right, so Ms. Henderson is iPhone Carrie. There she is. All right, can you hear us, Ms. Henderson?
Yes, sir.
Great. Ms. Feely, what are we doing today with Ms. Henderson's case? Did you get discovery?
I need to follow up with Mr. Abate about the Dropbox that I know was served on my office at one.
Oh, I'm sorry. This is a co-defendant. I didn't notice the indictment number. So this is a co-defendant to Phillips and Parks. So we're bleeding into that case now, but let's focus on Ms. Henderson and then we can move on to the other two. So I interrupted you.
So I need to follow up with Mr. Abate about the Dropbox link, but as the court can see from this calendar, she's a minor player in a much bigger situation here.
Agreed. But I want to make sure we can move it along. So you don't have discovery yet, or it was sent, but you didn't click on the link, or the link isn't working, or what? To what does Mr. Abate need to respond?
I just need his assistant to send the Dropbox link again. It was served on Ms. Patel, I think, and I just don't have the appropriate credentials to.
Okay. Great. All right. Ms. Henderson, have you and Ms. Henderson met before, or are you a new name and face to her?
We have been in contact. Yes.
Okay. So Ms. Feely, who replaced Ms. Patel at that firm, is your lawyer now. It sounds like you all have at least spoken on the phone or exchanged emails or texts or something. And she's going to get the discovery from the prosecutor, and then she's going to need to meet with you, probably in person, to talk about what's in that discovery so that you and Ms. Feely can figure out how best to move forward in the case, okay?
Yes, sir.
Do you have any questions about any of that?
No, sir.
All right. Ms. Feely, do you need Ms. Henderson to stick around anymore?
No.
Any reason Ms. Henderson's case shouldn't keep pace with Mr. Phillips and Mr. Parks?
No.
Okay. All right. Ms. Henderson, you're free to go. What, do you have good contact information for her? Okay. Ms. Henderson, you're free to go. Thank you.
All right, thank you.
Bet. All right. So if I see you've logged on, I'm going to put you and your client, Mr. McCoy, into a breakout room. Okay. All right, Mr. McCoy, you are about to go in the breakout room. And
Sure.
when Ms. Feely comes back, I'll try to pull you out of the breakout room, okay?
Yes, Your Honor.
And you may need to press some button. Maybe it's happening, Mr. McCoy. There he goes. Excellent. All right, so we've called an interpreter.
Yes.
We're waiting on that. Excellent. Then, Mr. Render, you have an update for me, or should I keep moving on?
You can keep moving on, Judge. I'm on the phone with my paralegal now. She does indicate that she was filing it, so she's pulling up information now off of Odyssey, Judge.
Okay, you keep looking and yep, we'll move on. We only got a couple cases left. Demario Phillips. Ms. Upshaw was a C3 lawyer, is that? I think so. And did Mr. Regis join this one too, or is this one we could use our C3 program to get someone for?
I haven't received a new entry, so I don't think.
Let me look. That's Phillips.
Yes, there's a new
My duty is number one.
There's a Ferlaria Hemingway who has filed an entry about a week ago, 10 days ago. Yeah. Okay. Okay. And then Mr. Johnson, I don't think has dialed in, but his request was simply if you could send the same discovery. I'm sure you got it to Gladys or whoever preceded Mr. Johnson, but Mr. Parks has the conflict defender. So I guess if you're pushing out the link to Ms. Feely, I'll just push it to Ms. Hemingway, who's info. I can give you her email address if you need it. You'll find it. Okay. I mean, it's in the docket now. And then Mr. Johnson. And I guess what we'll do is put it on a status calendar for January. Nothing's going to happen in December. So we'll put a status calendar in January that will have given these lawyers over a month to look over discovery and figure out what they're going to do. All right.
And Judge, we've gotten to the bottom of the situation.
Okay. Give me 1 second.
It's what I'm gonna do. Right. Right. See it.
Okay. Yes, sir, Mr. Render.
Yes, sir. I did have to speak with my paralegal, and she indicated that she received an email. We filed on September 16th. On September 19th, we received a email indicating that the judge's signature is rejected because the judge's signature isn't attached. I was confused by this. And honestly, we dropped the ball after the warrant was reissued. So what it says here is I can email you the link. This indicates that the judge's signature is missing. And from my understanding, your signature is needed on my filing for this. But it was rejected and we did not refile. Do the chain of emails, Your Honor. So I believe that is my fault, that it was rejected and I did not refile.
Okay. I don't know what it was you tried to file. Typically, when we're going to have a forensic examination of someone, the unsigned paperwork, the order, you actually send to Ms. Nelson, my litigation manager, and then I'll sign it. And sometimes some of that's under seal. That's really a decision that you and your client will make, whether you want any of that under seal. That also requires it to flow through me because you can't e-file something that's going to be filed under seal. What I'm going to ask you to do is coordinate with Ms. Nelson today through email or however you want to do it. It'll be easier to connect with her via email because she's going to be stuck in court much of the day. But today, November 17th, we need to get from you whatever proposed order you want me to sign that would get the process moving. The other assignment I'm going to give you is that you ought to follow up with DBHDD in a few weeks to make sure they got the paperwork and that Mr. Horton is in line to get an evaluation. I don't want this to linger more. I know that it takes a while to get an evaluation, and it turns out we didn't even get in line for that because of the little slip up with the e-filing, and then you guys didn't circle back around, okay?
Yeah, Your Honor, I can have that order to you within 5 minutes, and I apologize. It has been done differently in other counties. This is my first eval in Fulton, so I did not know that that is the way that it's to be done in Fulton. But we have everything together. I can have it sent within 5 minutes, Judge, no problem.
Okay, sounds like a plan. Mr. Hand, anything else on Mr. Horton's case?
No, Judge.
All right, so Mr. Render, you've got discovery. Really what we're holding on is getting that evaluation of Mr. Horton so that you and he have full information on that front.
Correct, Judge.
Okay. Mr. Horton, do you have any questions about any of the things we just talked about?
No, Your Honor.
Okay, thank you for dialing in. Mr. Render will let you know when we need to see you again, okay?
Thank
Yes,
you
sir.
so much, Judge, and I apologize for the confusion.
No problem. You two are free to go.
Thank you.
All right. Thank you.
All right, so if we recap, we're waiting on an interpreter for Mr. Hernandez Sabino, Giovanni Walker, last call, Mr. Brown.
If possible, whenever convening the court, Mr. Hand and I approach to set the case something outside of the arraignment.
Sure, we can do that, but I assume we still need an interpreter? Maybe not? Okay,
Depending on what you think about what it is, we have to bring to your attention.
okay. No, Mr. Walker. And Mr. Hand, you'll let Mr. Whitenauer know his assignment on that one.
Yes, sir.
Mr. Gutter.
Oh, he may be joining the call on Zoom. That's what Ms. Hansberry's.
Got it. Okay. He has not so far. Mr. McCoy is with Ms. Feely right now. Michael Palmer, we're waiting on Ed Adams. Tavante Williams. You need to talk with Ms. Feely about representation. Leonard Jackson, Ms. Wood, you want to talk with him and Mr. Hand. And that takes care of this calendar. So in a moment, I think we pivot to the motions hearing on Mr. Norris. I see Mr. Tolles here. I know Mr. Abate is here. You all can get situated in a minute. Was there anyone else here who had a case this morning and they didn't hear their name called?
Kimberly Saxon.
Can you say your last name again?
Saxon, Kimberly Saxon.
I know who you are, Ms. Saxon. You're on our trial calendar.
Yes, Judge, we have a plea at some point.
Excellent.
We're ready.
Okay, we'll do that this morning. And you, sir? Yes, this is the walk-in, I think.
I'm not sure which attorney will be handling it.
Okay, when we take a quick break while we're transitioning to the Norris matter, if you speak, it may be Ms. Feely's case, but he's a walk-in. I think there was maybe a bench warrant, something, but if you talk with him about that. So Mr. Yes, ma'am.
As far as status for the Mario Phillips, where are we?
Great question. So Mr. Phillips has a new lawyer. Her name is Ms. Hemingway. She's with it says she's with the Stone Mountain Public Defender, but she has filed an entry of appearance on behalf of Mr. Phillips. And so Mr. Abate, the prosecutor, gentleman sitting over by the wall there, is going to get discovery to her. She will then be in a position to meet with, how are you connected to Mr. Phillips?
I'm his mother.
So she will meet with your son to talk about the evidence that the state has to figure out what are the right next steps, whether it's to file a motion, maybe a motion to suppress, maybe to start talking with the state to see if it's something that can be resolved through negotiations. And if it's neither of those, to get ready for trial. And my goal is to keep things moving towards that. And it either will be resolved because there's a plea, or Mr. Phillips gets his day in court and we get a jury in here and the jury hears whatever evidence the state has. And this case is old. Your son's been in jail for over a year. And through no fault of his own, there's been a cycling through of lawyers. I don't know how early you got here, but if you were here, you heard me talking with Mr. Regis, where they are trying their hardest. The state is to hire people. People keep leaving, and they're trying to line folks up. Ms. Hemingway is currently the lawyer who have said, I've got Mr. Phillips's case, your son's case. So hopefully, once she gets this discovery, she will meet with your son soon. I've asked my staff to put this back on a calendar for early January so that we can have what I call a status conference, which is to get the final word. Hey, is this going to be a trial or is it going to be resolved some way short of trial? And if the answer is trial, then we look for when could we have that trial?
Do you have contact information for Ms. Hemingway?
I can give you. I'm told you got it yesterday. I've got an address, like a mailing address. I don't know how helpful that would be, and an email address. There's not a phone number on this entry of appearance.
Phone number that I was given by Ms. Nelson. It says not working, out of order.
Okay.
So is there maybe an email?
Yeah, there's an email address. I'll tell you what, I'm gonna print out this one piece of paper and then a deputy will get it to you and that'll be as good as I've got. You will have, you're very welcome. Okay, well, you can provide the phone number. I'm gonna get the email and we'll call that complete. Thank you. Mr. Brown and Mr. Ham, let's talk for a sec, and then we're going to take like a 3-minute break while we transition. Mr. Tolles, you ready to go on Mr. Norris? Great. So you can ease your way up to the driver's seat on the defense side, and Mr. Abate can slide over, and we'll go from there. How about you come around that side, so you're both on the same side?
Step out of your way.
Yeah.
Brother, he is a victim of use my class and we were able to confirm that he's true. To the jail staff, hours of the jail staff and booking. They actually went back and did a fingerprint comparison, photo comparison.
So someone got booked in because I had down, and that was his brother. But did the wrong person get arrested? And this is the person who ought to have been indicted, or the person who got arrested is the person who should have been indicted using his real name and not his brother's name?
The latter.
The latter.
Got arrested on scene or right thereafter.
Okay.
Uses my client's name.
So the state's theory, I'm going to repeat myself, the state's theory is the correct guy got arrested, who then used your client's name, who happen, they're brothers. It's not nice.
At all.
Somehow.
Okay. And so how did your client know to be here?
Because when he got arrested.
Your client got arrested also?
No, my client got arrested.
Okay. He got stopped. Okay. Okay.
We represented him on some traffic matters. So he took that up to us and said,
Okay, what's up, guys? So you don't want to arraign?
Don't want it to rain, and I would like to be able to get a legal chance on me confirm that the warrant with my client's name has been dismissed.
Let's just clear all that up. And if that's true, then we shouldn't arraign, and we may need to do a AKA so he doesn't get scooped up again.
Yeah, that's just my main concern. I want to eager to,
Right.
if I want to check that.
Okay.
And because that's all of us.
Oh my gosh, I didn't even look. It's an 03 indictment. Was he like 5 years old at the time?
We would have
Possibly, I don't know how it is.
Okay.
been maybe 20.
Okay. So how do we leave this? You're gonna get you will confirm with Ms. Nelson that there is a warrant in the system with this name, but also the actual name of the alleged offender.
So I reached out to Ms. Nelson and reissued.
Okay. Yeah.
So that should be out already.
All right.
But I need to confirm, so my office, how do we handle that?
Okay, got it.
And I'm just trying to confirm with the warrant with my guy's name.
Is gone so that he can circulate without worrying.
Correct.
Okay. So Abel.
The last name is the same, Sabina Hernandez. In the jail for consistency as one person for these.
Okay. So we don't need the interpreter. We can cancel the interpreter. And you can explain your client what's going on, and then you and Ms. Nelson will just need to.
I think we did do that for already. Yeah,
Right.
we did it.
Okay. All right. So then you'll work with Mr. Brown to get and you'll sort out, what do you do with it? Do you do a new indictment with it's going to look weird because it'll say 2022 for it, but you're going to navigate that one.
But
Okay.
I did confirm it because it was closed by arrest, so it's closed now.
Okay, great. Well, I'll be back in about 3 minutes and we'll start the Norris stuff. Ms. Charles, was there something I was making you wait on? He did not show bench warrant for, does that mean you'll get rolling on that? Okay. Sure, thanks for being here. Thanks for the plants.
If it's okay, I'm gonna step out and sign up some of my walking piece.
Fantastic. Thank you. I'll be right back.
So I'm just trying to see if there's.
Oh, but you're not going to them?
Yes,
Okay.
yes, no, I don't even know. Government is-
You can come around to yeah, I thought we did it last week, but
I knew it was sent over, I just didn't follow up with you.
well, and the way we've been doing it.
Oh, yeah, with it showing on one side and on the other.
Yeah. It's Jose, right? This is
Yes, Jose is mine.
Just your name that they didn't connect it somehow.
Or do we want, you know, what one was it?
No.
Okay, so then,
In the,
so
in the human that I sent over,
was it under the same case number?
it should have been, I did, yeah. So it should have come out there. And when I said should have, I mean, legal assistance. I just tell them which case that got to.
Well, then it doesn't look like it is. Oh, well, you know what? We have to search by it. We have to do find more. Because they're putting them under. Yes.
The last thing I think is. It's the
Well,
way they have it.
I didn't know if I put it
Yeah,
in there, if it
Sabina.
was gonna be in there.
Yeah.
The other way?
Yes, so you know.
That's okay.
I mean, if we can't find it here. But you make sure it's. No, that's good.
Yeah, it looks like. Maybe just Sabina, but sometimes they do it. That's it, Sabina.
All the eight.
Hey. Got the wrong follow.
Okay.
I was just saying it's about older, or as soon as she feels.
Oh.
She's not here yet, but she's en route.
It's not coming up at all.
All right. Well, I'll take that as a positive for today.
Yeah.
I got you. Sure. Sure, I got you. Thank you.
Now you have Uncle Cedar, right? Is that yours?
I do, she has not been produced to Fulton yet. I saw that there was a production, well. I
Yeah,
guess
that's for
there's
the
a-
22nd.
Right, I'm hoping she'll get here by the 22nd, and then
I
I
was
can go
hoping
meet with
that-
her and then get it resolved
Okay,
prior to the 28th. So
okay.
she's not being produced, she's being produced at the courtroom on the 22nd. Just that's the production order, bring her to the jail.
Bring it to the jail.
Okay.
If you need it sooner, not sooner, but if.
That's Tuesday.
Ooh, I'll check to see. I'll see.
Yeah, I've been checking every day. As soon as she's there, I'll go see her. I'll let her know.
So if I get it transported to the, I want to say tomorrow.
Yeah, I put it on my calendar for 9 a.m., you know, with the
Okay,
expectation
cool.
that I would be here,
Okay,
you know, in the hopes of getting.
okay, so that's about what I'll tell you. And then figure it out.
Okay, sounds good.
Uh-huh.
Mr. Abate, are you ready?
Yes, Your Honor.
Mr. Tolles, are you ready for us to bring Mr. Norris out?
Yes, I am, Judge.
Great. That was fast. 3 months later. Yeah. I don't think it's a Fulton thing. I just think it is a not common. Yeah. Right.
That was
Miss-
mine. That's fine.
That's okay. Ms. Feely, we've still got Washington State on, and I don't want to keep them going. So we'll have Mr. Norris take a seat, but then I want to sort out what we should with Mr. McCoy so we can let him and Washington State go.
Yes, Your Honor, I do have an updated announcement. I was able to check with Mr. McCoy and I filed waivers on those cases. So I will discover from Mr. Whitehour and another appointment.
Okay. Mr. McCoy, can you hear me? Oh, you're on mute. I don't know if there's a way to unmute.
Yes, Your Honor, I can hear you.
Great. Mr. McCoy, how much longer are you supposed to be at Washington State or in DOC custody?
Well, I have a parole date for next year, April, but I max out in 2025.
Okay, but the parole date would be April 2023?
Yes, next year.
Okay, got it. I'm asking only because we want to make sure your cases move along. And it's tricky for Ms. Feely to meet with you when you are there and she is here, but you may be out soon enough. All right, so these were on for both were on for plea and arraignment. There are notes for the trafficking case, but you've entered on behalf of Mr. McCoy for both and you've waived arraignment for both. You'll get discovery from Mr. Whitehour for both and we'll see where we get with that. Okay. Mr. McCoy, any questions about any of that?
No, Your Honor.
All right, Ms. Feely will be in touch with you after she gets discovery. There may be some things she can send to you. It's a little more complicated because you are a bit more remote than if you were in the jail here in Fulton, but she will certainly be in touch with you and we'll set your case down for a status calendar early next year, okay?
Okay, thank you.
All right, thank you, and thanks to the folks at Washington State. You're free to go.
All right. Good. I need, you got some, if you order.
So Ms. Henderson is still on. She can hang up.
She may be interested in what's happening with the 30 minutes, but I'm.
We're done with that. I mean, she can welcome to stay on, but we've wrapped that case up for now. Okay. Let's turn to Mr. Norris. Ms. Rivers, you ready? This is 21 SC 179262, State versus Amarius Norris. Mr. Norris is here. Good morning, sir.
Good morning.
He is here with his lawyer, Mr. Tolles. The state is represented by Mr. Abate. Mr. Norris has a couple cases, at least two, maybe three. Actually, it looks like three that are indicted. The one we're focused on is the one with the most serious charge, is a murder charge in this case. And we're here to work through at least two motions that I'm aware of. Mr. Tolles in August filed a motion to suppress, it says statements and evidence. And I'm going to have him articulate what specifically he's seeking to suppress in a moment. And then we also have a 404B notice / motion from the state that we'll work through as well. Mr. Tolles, was there anything else you thought we were covering today, or is that your understanding?
That's my understanding, Judge.
Great. Mr. Abate, same understanding?
That's correct, Judge.
And you've got the witnesses here you need?
Yes, Detective Egan is sitting behind me.
Okay, excellent. Mr. Tolles, I've got your motion and I've read it. Share with me, please, what specifically you are trying to suppress. A statement your client gave in May of 2020, and what else?
Yes, Judge. First of all, good morning, Judge.
Morning.
And yes, on behalf of Mr. Norris, Judge, we are here to suppress any statements that he made to law enforcement and any evidence that was seized at that meeting. Just a background, Judge, my client was a suspect from a homicide that happened on May 4th, 2020. There was some fingerprints left on a car outside of the apartment of the victim's car. That's in the motion. And essentially, he was ordered to come to his probation office. He wasn't voluntary or anything like that. And then when he was there, he was basically ambushed by his probation officer and a police officer that he was not told that he was going to meet. Immediately, without reading his rights, without telling him he had a right to it was voluntary or anything, they just started asking him questions about a homicide investigation. We're moving to suppress all of that because his rights should have been read. He was not free to leave. He was in custody, not free to go. These questions were asked to elicit an incriminating response about his whereabouts of a homicide. Also there, Judge, now, even though he didn't specifically incriminating evidence, he had denied it, but we want the denials admitted because we don't want that in there as well, because again, if he had been advised of his rights, he could have just remained silent, but he was never advised. There was also a phone, he had a phone on him. And we're also asking for the contents of that phone to be suppressed due to the fact that, again, he was ambushed to bring it. It wasn't voluntary. There was no search warrant for this phone presented. And they relied on a Fourth Amendment waiver, which was never shown to Mr. Norris. It was seized without his consent. And on this phone, Judge, there was evidence, two particular areas. There was these phones, I guess, can give off location data. We're asking for that to be suppressed because that should not have been seized. And also we're asking, there was also, my client had Googled a homicide that happened in his neighborhood that related back to this particular homicide, where he was asking about, was there any information on Maxwell? we believe that the state would use this evidence at trial to show that he somehow is the perpetrator of this crime. And so we're asking for all of that to be received, all of his statements and any evidence that the police found in the phone for illegal search and seizure.
Got it. So I was mistaken. May 4th is the date of the killing. Subsequent to that, your client is ordered, invited, we'll learn more about it, down to probation. And it was there that he met with a probation officer and police, and flowing from that interview interrogation, again, we'll get the evidence on that, was the seizure of the phone. And then you believe there was evidence taken from that phone that the state might want to use. And so it's suppressed statement and suppressed phone and any fruits from the search of that phone.
Yes, sir.
Understood. Okay. Mr. Abate, before you call your first witness, do you intend to use either the statement that was obtained when Mr. Norris was meeting with probation and Atlanta police, or anything from the phone that was seized, if in fact that's how things happened?
Yes, Judge.
Yes, you use both.
Yes.
Okay, then we ought to move forward. So if you want to provide your own narrative, you can, but we're going to get it from the witnesses anyway. So why don't you call, unless there was something factually different about how you think it went down. I don't mean your spin on it. No, it was voluntary or not, but it wasn't the probation office. It was the police station or something like that. If there's something you think I ought not to labor under before you call a witness, you're welcome to share that. Otherwise, call your first witness.
State would call Detective Danny Agan.
Great. Detective Agan, come on up, please.
Go ahead and have a seat. Say your spelling name for the record.
First name is Danny. D-A-N-N-Y, Agan, A-G-A-N.
Judge, you don't mind if I stay seated?
I don't. So both Mr. Abate and Mr. Tolles, you are welcome to remain at council table while you're asking questions, as long as you're speaking into the microphone and I don't hear from Ms. Rivers that she cannot hear you. You're also welcome to be at the podium. You can be wherever is easiest for you, as long as witness and Ms. Rivers can hear you.
Thank you, Judge.
Sure.
Good morning, Detective Agan. Can you tell the judge how you are currently employed?
I work for the City of Atlanta Police Department as an investigator. I'm post-certified.
Okay. And do you currently, do you work in a specific zone or area within the Atlanta Police Department?
I do. I work in the homicide unit.
Okay. And can you tell the judge how long you've been assigned as an investigator with the homicide unit?
Well, I've been there approximately 6 years. I've been an investigator since 2004.
Okay. And back in May, specifically May 4th of 2020, were you assigned to the homicide unit?
Yes.
And were you assigned to a case that occurred on May 4th as the lead investigator over at 2125 Southwood Cove, Atlanta, Georgia?
I was.
Okay. And as the lead detective on the case, did you begin to, I guess, investigate not only the circumstances which you encountered when you arrived to the scene, but any circumstances that led you outside of that Southwood Cove apartment complex?
I did.
Okay. And can you tell the court, when you arrived on scene, was there a vehicle of interest that became part of or central part of your investigation?
Yes.
And can you tell the court a little bit about that vehicle and who the vehicle belonged to?
The vehicle was a 2011 black Jeep Cherokee. It belonged to Donovan Maxwell, which is the victim in this case. It was inside the apartment complex. It actually was backed up just over the curb in one of the parking spaces. The vehicle, according to witnesses, had collided with another car after being involved in an accident.
Okay. And speaking to some of the witnesses on scene, whether it was yourself and other members of the homicide unit who were assisting, were they able to identify witnesses who, I guess, witnessed the crash or heard the crash from the apartment complex?
Yes.
And in doing your investigation, were the witnesses able to provide you with a general description of anyone they saw running or fleeing from the crashed vehicle?
They did.
Okay. And do you recall for the court, or can you recall for the court, the general description that was provided?
They said that there was two, after the vehicle crash, there were two black males that fled from the car on foot.
Fled from the Jeep?
Correct.
And was that, I guess, upon your arrival, did, I guess, the crime scene unit also arrive?
They did.
And was that vehicle, whether it was processed at the Southwood Cove apartment complex and then transported to the APD Evidence Center, was it processed there as well?
Yes, it was.
And in the processing, was the vehicle, the inside and outside, I guess, dusted for any fingerprints?
Yes.
And based on your investigation, were they successful in locating or lifting any latent prints from the vehicle?
They were.
Okay. And then can you tell the court, after the latent prints were lifted from the 2011 Jeep Cherokee, what happened next?
So the identification unit processed the fingerprints that were lifted and provided a report based off the GBI saying that those fingerprints belong to an Amarius Norris.
Okay. And once you got the match for the fingerprints from the vehicle, can you tell the court where were the fingerprints located?
There was a left-hand palm print on the front driver, or the front front passenger door of the car. So the front right side of the car. Outside.
Outside?
Yep.
Okay.
A left palm print.
Okay. And to your knowledge, was that the only print that was successfully lifted from the vehicle?
Yes.
And upon, I guess, getting the information or learning the identity of the person who the print belonged to, did you then, I guess, attempt to locate Mr. Amarius Norris?
I did.
And can you tell the court kind of the steps you took in locating Mr. Norris?
I did. I checked on Mr. Norris's name and learned that he was on probation. And I was able to contact an Officer Kelly from community probation. And he confirmed that, in fact, Mr. Norris was under his supervision and was on probation.
Okay. And can you tell the court when you are contacting Officer Kelly and when you get Mr. Norris's name from the matching of the print, why are you trying to locate him?
Because since Mr. Norris's fingerprint was on the car, obviously I wanted to speak to Mr. Norris as to why his fingerprint would be on the car and if he knew anything about the situation.
Okay. So at this point of your investigation, when you are attempting to speak with Mr. Norris, is he a suspect? Is he a person of interest? Do you know?
I don't know at that point.
And is that why you wanted to speak with him?
That's correct.
Okay. And when you contacted his probation officer, Officer Kelly, were you then able to set up, I guess, a meeting?
Yes.
And can you tell the court where that meeting occurred?
It was at the probation office, and I don't know the exact address, but it's right at Peachtree and Memorial Drive. There's I'm assuming it's a state probation office. I just don't know the exact address, but that's where we met. And Mr. Kelly and I met with Mr. Norris there and Detective Bent.
Okay, the office that's not far from where we are here today, here in the
Correct.
court. Okay.
Correct.
Your voice trailed off at the end. You, Officer Kelly, Mr. Norris, and did you say, and Detective Benton? What was the last piece?
Yes, that's what I said.
And Detective Benton. Okay.
And did this occur on May 18th of 2020?
Yes.
And when you arrived to the probation office, can you tell the court kind of what happened next? What were the first steps that were taken?
Made contact with Officer Kelly. Mr. Norris was there. Officer Kelly showed us to, it was just like a conference room type area, table and chairs. We met in there, and then Officer Kelly brought Mr. Norris in there for us to speak with him.
Now, when you arrived, when you were brought into, you said it was a conference room?
Yes.
Was Mr. Norris at all under arrest?
No.
Were you detaining him at all?
No.
And when you walked into the conference room, did you introduce yourself as, an Atlanta police detective with the homicide unit?
I did.
Okay. And were you, I guess, were you audio or video recording this interview?
I did. It was an audio recording.
Okay. And I want to show you what's been marked as State's Exhibit 1. Let me show it to the council. Your Honor, may I approach the witness?
You may, both you and Mr. Tolles are free to approach witnesses.
Do you recognize State's Exhibit 1?
Yes, I do.
Okay. And what is State's Exhibit 1?
That's a thumb drive. It should contain the interview with Amaris Norris.
And have you had an opportunity to recently review the audio interview with Mr. Norris from May 18th that's contained on that jump drive?
I did.
And is State's Exhibit 1 a fair and accurate recording of the interview that you had with Mr. Norris on the 18th? Right?
Yeah, it is.
Your Honor, at this time, the state lieutenant must State's Exhibit 1.
For purposes of this hearing, any objection, Mr. Tolles, to States 1?
No objection.
It's admitted.
Thank you, Judge. Now, you said during this interview, Mr. Norris was present, and then you said Officer Kelly and Detective Benton.
During the interview itself, it was just myself and Detective Benton. Officer Norris was outside the room.
Officer Kelly?
I'm sorry, Officer Kelly was outside the room.
And at any point during this interview, was Mr. Norris restrained in any way?
No.
Was he placed in handcuffs?
No.
Was the door unlocked?
Yes.
And you said this was just a casual type conference room?
Yes.
And during that interview, did Mr. Norris ever ask to leave?
No.
Okay. And after the interview was complete, did you place Mr. Norris under arrest?
I did not.
Did he go home? Or did he leave the probation office without any charges related to the case that you were investigating?
He did leave without any charges.
Okay. Your Honor, at this time, the state's going to publish State's Exhibit 1 for the court. It's about 20 minutes.
Okay, we can do that in just a moment. So Detective Egan, it was you and Detective Benton and Mr. Norris in the room, and we've covered no handcuffs, et cetera. At any point, and I guess we're about to listen to it, but at any point did Mr. Norris say, I don't want to talk to you anymore? And you said, that's interesting, but you're going to keep answering my questions.
Yes, sir.
And those are obviously my words, but was there an exchange like that?
No.
Again, we'll hear it in just a moment, but best of your recollection, how was it that the interview came to a close? Because Mr. Norris said, I'm done with this, or you and Detective Benton got what you were going to get and you ended it?
So when I showed him the report that was issued by the ID tech with the fingerprint with his name on it, and I actually showed it to him and I said, your name is on, your fingerprints have come back. This is the report was issued. He said that I was lying, that his fingerprint could be on the car. So at that point, when he said that, you know, he had never been there before, he'd never been in the apartment complex, he'd never seen the car, we stopped.
Okay. All right. Mr. Bate, you may publish when ready.
Thank you, Judge.
And it's Southwest Cove Apartments?
Southwood.
It's Southwood.
Cove Apartments.
Yes.
Okay.
I think it's Southwood Vista Apartments, if they're correct.
Okay.
I think I called it Villa when I was speaking to Mr. Norris, but I think it's actually Vista.
Okay.
Of course, that shit doesn't work. I mean, this is just my life.
Thank you, Deputy Gordon. I was going to ask if we could just get that out of the way.
How you doing?
Hi. Good, how are you?
Okay, cool. Thank you.
Thank you.
Yeah, do you want one? That's cool. That's why I brought one. Yeah, you got to pull it over.
So the silver part goes on the nose part. So put, yeah, so put that there, and then that one. Well, first I'll put the.
Yeah, this thing's are
Comes down.
very user friendly.
And then you can,
You put it over your ear like that.
the nose.
You got it.
If you want to, you'll have to just take the
All right, so this is Detective Benton. I'm Detective Egan. We're from Atlanta Police. First of all, let me get your name, if you don't mind. How do you spell that?
A-M-A-R-I-U-S.
And there's a Norris, you said?
N-O-R-R-I-S.
Okay. And Mr. Norris, what's your date of birth?
10-9-97.
Okay. What's your address?
3901 Camden Road, apartment G, no, my bad, V8.
V8.
V as in boy or V as in
V as in
V as in Victor?
Yeah.
Okay. Do you have a phone number?
Yeah, 678
Uh-huh.
613 9783.
Okay. How long you lived out there?
Not that long, because I've been back for in our jail, but I stayed with my mom, so she's been there about 4 years now.
Okay. You always lived in V8?
G10 and G11.
G11. Okay. How long you been in V8?
About a week now.
Okay. And when you say you're in and out,
Like, I was in jail a lot. I did a lot of time in jail, so I wasn't never out.
when did you get out of jail?
This year, February 13th.
What were you in for?
My co-defendant, I was with an older guy, did some stuff. Right now I'm in the process, I got to testify against him.
Oh, really?
Yeah.
Is anybody that, where was that? Where did that happen?
They say he was, the detective told me they got him all on camera, they got him all over camera, so everything looking good on my end. But the thing is, he's telling them that he want me to take his charges, and I don't understand why. He was just in my car. When they caught him with me, but they didn't catch him. They didn't catch him with nothing on him, but they knew they was looking for him. So when they caught him with me, what do you think? They assumed that we were together all day.
Okay.
Right.
Okay. So is there somebody at the DA's office? Is that Fulton County or is that Cobb County?
That's
Clay County?
Fulton.
It's Fulton. Is there somebody at the DA's office you're talking to?
I talked to the best of the, I can't remember his name, but it's some skinny, tall guy. I can't remember his name.
Oh,
but
an investigator?
yeah, I'll be talking to him and stuff.
Okay. You don't know his name? Okay. Well, let me give you a little background on why we're here. We work homicide. Okay. So, kind of curious, try to get some background information. We had a homicide on May the 4th. Okay. Pretty close to 3901 Campbellton Road. You hear anything about that?
I don't go outside. I be in the house. I work at Fresh Express. I don't go outside. I work every day.
You work at Fresh Express?
Yeah, my probation officer know. I work.
Okay.
Weekends, 7 days a week.
What's your...
Yeah, they still work Fresh Express. Y'all know what Fresh Express is? It's a big salad company.
I've heard it.
In Morrow, Georgia.
Yeah, I think they sell that stuff at Kroger. Salad, yeah.
Yeah,
Yeah, I've seen it. It's in the salad section.
Oh, I thought it was like a store, sorry.
Yeah.
I thought it was like
Nah,
a
it's a
restaurant,
warehouse.
sorry, okay.
So what hours do you work?
I work from, I have to be there at 6, but I get there at 5 or 5 to 3 in the morning.
Okay.
5 p.m.
Yeah, 5 p.m. to 3 in the morning.
And how many days a week? What days do you work?
I try to go 7 days a week.
7 days?
You can work 7 days a week, so
Mhm.
yeah, I try to go 7 days a week.
Okay. Because when I talked to Officer Kelly the other day, I thought he said that you got in a car wreck or something. You weren't working.
No, that was like months ago. That was months ago. I was in a car wreck. I was in a serious car wreck right on I-20.
Oh, really? What happened?
Well, I don't know if y'all know the radio guy, Stewie Rock. Y'all ever heard him? He worked for 107.9.
Mm-mm.
Well, he smashed into my car.
Oh, really?
Into my car and knocked me into the wall and made 5 other cars smash me from my car. And they totaled my car.
Ouch.
And that was like 2-3 months ago, though.
Okay.
Okay. Yeah, my neck and my back messed up. That's why I'm leaning forward like this, because when I lean back like that, it hurts.
Mm-hmm. So how long have you been back at work?
I've been at work for like a week now, a week or two.
A week or two. And you said your hours are what?
4 to 1. Got to be there at 6, but I get there at 4, between 4 and 5, because they have to put you on count. They have to count.
What was your first day back at work, do you remember?
Say it again.
Do you remember what day was your first day back at work?
I didn't know. I've been there about 2 weeks. I've been out there 2 weeks now.
Okay. What's your, is there a, where are they located? You said Mora?
Mora.
Well, if you don't, did you have to did you get a new car? Did you get a new car? You said your car was covered.
Oh, yes, my fiance did. We had got a new car.
Oh, okay.
Who's your fiance?
Chanel Murray.
Does she live with you too?
Yeah, she lives.
You said Chanel?
Yes. Yes, you see it on my forehead.
Oh, okay.
Chanel, yeah.
You must really love her, right?
That's my wife. Well, we got 2 kids together and got a baby on the way right
Did you say
now.
fiance or wife? You say
It's my wife.
I mean, I get it, but y'all not.
Yeah, but she's my wife.
Legally not married, but common, okay, gotcha.
Y'all got 2 kids?
We got a baby on the way right now, and well, we got 3 kids. She got her son, I got a little girl by her, and then we got a little boy on the way right now.
Okay.
Congratulations.
Thank you.
When's he?
I'm working.
When does she do?
Probably in November.
Okay. Crazy time to be having a baby right now, isn't it? Considering all the.
And then they playing with these stimulus checks.
Yeah, I know. So, so were you working May the 4th? That's a Monday.
I probably went. What time? Like around what time was it?
Well, I mean, I'm saying, were you working May the 4th?
No, I was with my wife all day. You can call her right now. She'll tell you I was with her all day that day.
Okay. What's her phone number?
678-508-6963.
Do you know what case we're talking about?
I don't even know what y'all talking about because I don't be outside.
Okay.
I don't hang with these crazy folks out here crazy. I ain't trying to go to jail. Y'all don't see my record. I already got enough stuff on my way. I got a lot of stuff going on right now. I ain't trying to get in no trouble. I ain't trying to be around no people that doing no crazy stuff, no type of crimes. I got kids to live for. My mama sick. My mama got cancer. I ain't got time for that. I don't know what y'all talking about. But Campbellton, I do know that's a bad area though. That's a gang infested area. It really is. So ain't no telling. That's a gang infested area. Like it's a real gang infested area. That's why I'm trying to get my mama from over there.
Now, how long have you lived out at Campbellton?
When I came home from jail from Carl, my mom was already staying there. I told her not to move over there because my cousin stayed over there, and I told her about that area. That area is bad. That area is very violent. It's a blood area. I know y'all know what blood is. Yeah, it's a blood area. So I had a problem with it. I got jumped there. When I first came home, and I got out, they jumped me in the apartment because they didn't know me. So I'm not from that area. So I wasn't over there that long.
Where's your cousin live?
He live on Camp Creek now. He moved. He got up out of there too. That's how bad it is over there.
What's your cousin's name?
Dominique Clark. He a rapper. He a rapper.
So you're saying that blood jumped you when you got out this year?
Got out. No, that was last year. Like when my mom first moved out there. Yeah, they did because they didn't know me.
Okay.
Somebody wanted me to be in a gang. I'm not joining no gang. I'm Muslim, so we don't. My religion, we don't gang bang. We believe in peace.
Well, that's a good thing to go by. So, do you have any friends or anything out at 3901 or 39?
I don't like them guys.
I'm saying, but do you have any people that you hang out with?
My family. That's it.
That's
my
it.
cousin, my mom, and my kids, and my wife. I don't know.
What about anywhere around?
Yeah.
Not necessarily the complex, but anywhere around. Was there anybody that?
Campbellton been here? No, I'm not messing with none of them guys. All them young guys out there ain't nothing but trouble.
No. Sorry, that's not what I was trying to say. Is there anybody that you would visit on a regular basis, whether it was for, I don't know, they would make meals or give you a haircut?
No, I don't go to nobody's house. I don't go to nobody's house.
Okay.
If I go to somebody's house, it's going to be in Cobb County because my other baby mom's still out there. And I got a couple homeboys out there. I got a couple Muslim brothers out there.
Okay.
So that's it.
Okay. So, being out in 3901, so how familiar are you with that area?
I'm not from there, so I'm really not familiar with that area.
Where are you from?
I'm from the west side of MLK, Martin Luther King.
Okay. All right. So you already said, you don't go out, you don't hang with anybody, right? So there's an apartment complex behind 3901, because 3901 has two addresses, 3901 and 3909. Like there's a there's like an A building at 3901, and there's like an A building at 3909. Like when you pull into the apartment complex, like one half is 3901, even though it's all the same complex, and then the other half is like 3909. You know what I'm saying?
I ain't never knew it was 3901.
Okay. Well, you gave me 3901.
I'm not 3901, the other one.
You didn't know about 39. So there are two addresses there. There's also, if you're saying you're not familiar with it, there's another apartment complex behind 3909. There's train tracks that run through there.
The only thing I know behind them apartments is Fickett Elementary.
Yep, there's that.
That's the only thing I know.
So in between, you said Fickett? Fickett.
Yeah,
in between.
My son went to that school.
So in between Fickett and the backside of 3901 or 3909 Camelton Road is another apartment complex. You know which one I'm talking about? It's called Southwood Villa, I think.
No, I never heard of that.
Never heard of it?
Mm-mm.
Never
been there?
No. I don't know what y'all talking about.
Okay. All right. Well, you all seem to know a lot about the area or what we're talking about. So we'll just tell you what we're talking about. So there's a homicide that happened over there on May the 4th, which is Monday.
Right.
All right. The police were called out there, and a person had been murdered.
Mm-hmm.
So your name came up.
Why my name come up?
Well, that's what we're trying to figure out. That's why we're here to talk to you.
That's why we're here talking to you.
Nah. Hell no.
Is it Amaris? Is that how you say it correctly?
Amarius.
Amarius.
Yeah.
Amarius, nobody's sitting here trying to trick you or anything, but we wouldn't be here asking questions.
I know.
Okay, you understand. So,
Yeah.
and I'm not.
I have a background too, so I went shit like stuff like that. That a detective told me, like every time if something happened because of my background, if something happened on Camerton, I'm gonna get questioned. A detective told me that before. He said because of my background so long, if something happened in that area, they gonna always question me. That's what a detective told me.
Well, he may have told you that. I don't necessarily go by that philosophy where I'm just gonna go find just because somebody has a record. Well, I automatically need to look at that person. That's not how we operate. That's not how we operate. How we operate is we gather information, we gather facts, and then we work with those facts that we collect. And we have stuff that we've collected. So that's why I'm asking you the questions.
You call my wife. You call her right now and say, she'll tell you. I don't do shit.
Okay. The apartment complex that I'm describing at Southwood Villa Apartments.
Mm-hmm.
Do you know which one I'm talking about?
I never heard of them.
Okay, so you never heard of it?
No.
Okay.
Have you ever been here?
No.
Okay.
I can't be somewhere I never heard of it.
No, I just want to make it clear that you're saying that you're not familiar with it, never been there. Okay.
My family will tell you that I'm not from Camerton. I don't know too much about. I know about Cascade Glen. That's it.
Okay. Would there be any reason why any DNA from you would be at that apartment complex?
Nope.
So
definitely not.
So what if I told you there was?
Definitely you're lying.
I'm lying?
Yeah, most definitely.
Okay.
Because I ain't never been to them apartments.
Never been?
Ever.
Okay.
I look in your eye and tell you that never been there. I know this for a fact. Never been there. And I wouldn't even kill nobody. I'm Muslim. We don't kill people.
Right.
Yeah, I don't know people.
And I understand. Nobody said you killed anybody.
I'm just telling you my religion, what my religion
No, I
is.
got
We
you.
don't do that type of stuff. We don't be around them type of people. So I would never be put in that category. That's all I'm saying.
Okay. So, never been over there?
No, sir.
Okay.
Have you ever, so you don't recognize this complex here?
Hell no.
Okay. Do you recognize the car?
No. I know it's a Jeep. I can still look at it and tell it's a Jeep.
Okay. Have you ever driven a car like that before?
Mm-mm.
So you've never been around a Jeep like this?
Never seen it? Okay. You said, yeah, I'm trying to be honest with you, okay? And you say, well, I'll be lying from what I'm telling you, right?
Right.
All right. So I'm not going to be one of those ones that's going to sit here and tap dance around like I want to tell you anything. So I'll let you read this for yourself, okay? No, it's not, I didn't draw up the report. Do you see, what do you see on there?
I don't understand.
Okay.
Right here it says Georgia Bureau of Investigation. So the GBI is the one that helped us with this report. Okay. Right here is name, date of birth, and that's just a number that the state gave you probably the first time you were ever arrested.
What?
Hold on a second.
So we're going to explain.
So what happened is we took time of the crime scene. Like you've seen on CSI, prints were taken everywhere. Prints were taken from inside, outside the apartment complex, vehicles, stuff like that. All the normal, I'm not saying this particular one, but prints were taken on this crime scene. And what does that say right there?
Left palm?
Left palm came back to.
On what though?
On the vehicle we just showed you that you said that
No,
you've never
that's
driven.
negative. That's not. That's
Well,
not.
no, I'm not, we're not trying to.
I ain't never ever seen this vehicle or nor touched that vehicle. I know this for a
So
fact.
you can't explain why your palm print would be on that vehicle.
My palm print's not on that vehicle.
According to the GBI, it is.
So the crime scene, so we have a crime scene here. You've probably seen people come out, they take photographs, collect evidence, take fingerprints, stuff like that. You've seen, like they see on TV and stuff. Crime scene comes out, somebody processes the crime scene.
I have proof that I was with my wife all that day.
Okay. What I'm telling you is that somebody came out. I didn't process the crime scene. I was there, but somebody came out and took fingerprints off of that car, right? They dusted for fingerprints. They then took those fingerprints and turned those in to be examined, and your palm print came back to the front driver's side door of this car. Now understand, like I said, nobody said you killed anybody, but I'm saying, how does your fingerprint get on this car that you've never seen in an apartment complex that you said you've never been to? We're not trying to trick you. I'm just saying.
You can call my wife right now.
I will call her, but right now.
I'm telling you, sir, that's the God honest truth. That's on my kids. I never ever touched that vehicle and never seen that vehicle. Ever.
Okay.
I wouldn't need to touch it.
Okay. I can't.
I got verification. I got witnesses and settled things, all that. I got witnesses to verify where I was.
All right.
I would talk to y'all. Come on, y'all should have knew then. I wouldn't even talk to y'all if I did something wrong, right? Most criminals who know they did something, they not gonna talk to y'all. Come on now, y'all know that, right? Y'all been doing. I'm pretty sure y'all been doing this for a long time.
Well, everybody's different. No, I wouldn't say that.
Y'all been doing it.
I've been doing this homicide for 12 years, he's right at 10, so.
Y'all about to retire, ain't you?
No.
Nah, not no time soon.
So we've been doing homicide a lot longer, probably.
Yeah, there's no rhyme or reason. There's some people love to talk. Some people, like you said, they won't say one word, but that's hard to explain.
Right.
So that's why we had to come and talk to you.
I understand.
Because that's
understand
an
that,
issue.
I understand that.
So.
All right, sit tight.
Can I go get my phone?
Yeah, give us. No, you stay still. We'll get your phone to you. Yeah.
Is there anybody in the car with you? We have to.
Yeah, just sit. Yeah, or somewhere.
We're not allowed to.
I'm good though.
For the moment, just sit tight. Where?
I don't know where. You want me to sit here?
There. Just you can come in. You just sit tight with him for a minute. Sure. Yeah. All right. We'll be back in. Can we step outside and get back in and out?
Yes, just let the,
Okay.
Now, Detective Hagan, after you finished speaking with Mr. Norris, where did you and Detective Benton go from the conference room?
I think we stepped outside to the parking lot.
Okay. And had you had discussions prior to and after that interview with Officer Kelly about the special conditions of Amarius Norris probation for his Cobb County conviction?
Yes.
Okay. And was one of those special conditions that Officer Kelly talked to you about was a Fourth Amendment waiver?
Yes, it was.
And as a condition of his guilty plea, he was waiving his Fourth Amendment right?
Yes.
Okay. And did you actually see a copy of, I guess, the sentencing sheet or the plea form?
I did.
Okay. And I want to show you what's been marked as State's Exhibit 2. You recognize State's Exhibit 2?
I do.
And how do you recognize State's Exhibit 2?
This has the state versus Amarius Norris on the front of it. This is the document that Officer Kelly provided to me concerning Mr. Norris's Fourth Amendment waiver.
And is State's Exhibit 2 a fair and accurate copy of the document that you saw with Officer Kelly about the special conditions of the plea in which Mr. Norris took in the Cobb County burglary case?
It is.
This superintendent with the mark of State's Exhibit 2 attendance.
Any objection, Mr. Tolles, to the entry of Exhibit 2 for this hearing?
No objection.
It's admitted? Is that a Fulton County set of documents, different county? Cobb County. Thank you.
Now, after you and Detective Benton stepped outside, what you hear on the recording, the defendant asked about his phone. Do you remember that?
Yes.
And did you physically have custody of his phone?
Yes, at that point, we made contact with Officer Kelly and then we took custody of his phone, Mr. Norris's phone.
And after taking custody of his phone, did yourself and Officer Kelly have a discussion with the defendant concerning the special conditions of his probation?
Yes.
And did you and or Officer Kelly explain to the defendant, I guess review with him, I guess the special conditions of the plea that he took for his Cobb County burglary?
We did.
Okay. And was he then asked to provide a passcode for his phone based on one of the special conditions of his probation, which was that he waived his Fourth Amendment right?
Yes, he was asked.
And did he provide you with these passcode?
He did not.
Okay.
I'm going to pause for 1 second because I was jotting down the case number from this Cobb case. And so I just missed one of Mr. Abate's questions. So Detective Hagan, you and Detective Benton spoke after this recording was over with Mr. Norris with basically this document or a copy of it in hand saying, hey, Fourth Amendment waiver, we've got your phone. My words, not yours, but basically we're entitled to it. Law enforcement is, would you give us the passcode?
Right.
That's a summary of basically the exchange you had with Mr. Norris. His response was to not give you the passcode.
That's correct.
Okay.
And upon, I guess, him not providing you with the passcode, can you tell the court kind of what you did next?
So the phone was seized at that point. And then when I returned to the homicide office, I made contact with investigator Leon Packer, and then he completed a forensic analysis on the phone at a later date.
Okay. And I should have been more specific, so I apologize. After you asked for the passcode and Mr. Norris didn't provide it to you, did you leave by yourself? Did you leave Mr. Norris? Did you guys part ways?
Yes, we parted ways. Detective Benton and I left the location, and that was it.
And so you nor Detective Benton or Officer Kelly placed Mr. Norris under arrest for anything at that time, correct?
When I left, I don't know what Officer Kelly did at that point. I just know that Detective Benton and I did not have any charges on Mr. Norris. We left, and that concluded our interaction with him.
And based on your interview with Mr. Norris and his denial of being anywhere near Southwood, the Southwood Cove address or the apartment complex, him never seeing that car before, and him basically telling you that it wasn't his handprint on the car, you guys were obviously lying. Was all of that, I guess, reasons why you collected his cell phone to do an extraction?
Yes.
And in your experience with the police department, particularly with the homicide unit, can you tell the court when a phone is submitted for an extraction, does it sometimes provide you with locations of where the phone is at a specific time?
Yes, it does.
And was that one of the reasons why you were seizing the phone?
Correct.
And also, based on your training and experience, and the many times that you've reviewed cell phone extractions, does the cell phone itself, the text messages, photographs, things of that nature, does it contain, I guess, evidence of the crime in which you were investigating?
Yes.
Okay. And based on your understanding of, I guess, the special conditions of the plea in which Mr. Norris was on probation for, the reason you took a phone and an extraction was done without a warrant, is that because you were under the belief that he had waived his Fourth Amendment right?
That is correct.
Can we pause for 1 second?
Yes, Judge.
Mr. Dorsey, it's the witness stand. If you'll come look at any monitor, you'll see poor Detective Hagan, well, he keeps going big, small, choppy, because it's saying the bandwidth is poor from that device. So whatever magic you can work. Detective Hagan, I've got a question while we're doing this. Is it not plugged into? You're trying to find its home? Is that not? I don't know how that. Oh, you're hard. It wasn't hardwired? Oh, okay. I'll hold my question. Sure. Okay, but it's showing, I mean, if you look on any monitor, it's small and it says bandwidth is low. So I don't know if we need to reset it to get it to off of Wi-Fi or. Okay, yeah, it's not on anymore. Okay. Do you want me to, I can do it. Yeah, let me see if I can take care of that.
Yeah, but they didn't find any evidence. It doesn't matter. Right. But they're gonna use the Fourth Amendment waiver so they can search your.
All right, it should be on. That looks much better. That's how it ought to be. Okay, excellent. Thank you, sir. This seems like a temporary fix, though, having this wire like that. We'll revisit. Okay, that's less urgent now. We'll make it through the hearing with this. Thank you so much. All right, sorry about that, everyone. My question for you, Detective, the Fourth Amendment waivers language is that the defendant, so in this case, Mr. Norris, shall, so must, submit to a search of person, et cetera, down to effects. So that would include phone at any time without a search warrant, whenever requested to do so by probation or law enforcement, that's you, without probable cause, articulable suspicion, or reasonable grounds. So really whenever you want, except the clause goes on to say, you actually do have to have a belief, it doesn't have to be reasonable, but you have to have a belief that Mr. Norris is either in violation of probation or somehow acting in violation of the law. So what was it that you believed about Mr. Norris at the close of your interview with him that would satisfy he was in violation of probation or otherwise acting in violation of the law?
Oh, at that point, I believe that he was involved in the homicide.
Because of the left palm print on the front driver's side door.
And actually, so in the interview, I did say the front driver's side door, but the report is it's the left. I mean, it is the passenger door, the front passenger door. So
I'm sorry, I meant passenger side if I said driver's side.
I said driver's side in the interview, but the report saying that his left palm print was on the front door.
Okay.
So that led me to believe that he was there during the time of the murder.
Okay. All right.
And Detective Hagan, you said the vehicle when it was found, it was crashed in the apartment complex, correct?
Yes.
And you're speaking with the witnesses. Did they articulate that the car, how the crash happened?
Some witnesses said they heard the crash and the victim's car, the black Jeep Cherokee, hit two other cars in the parking lot, and then two males exited the black Jeep Cherokee and fled on foot. And then that's where the car was found when police arrived.
And when police arrived and the car was crashed, was the victim, I guess, found inside the vehicle?
No.
Where was the victim found?
The victim, the victim was eventually found inside of his apartment, deceased, had been shot in the head.
Shot in the head?
Yes.
And did you speak with the victim's significant other on scene and thereafter as you did your investigation?
Yes.
And based on your speakings with his significant other, as well as your investigation, did anyone other than Mr. Maxwell at that time have authority to drive that vehicle?
No.
And no further questions, Your Honor.
Mr. Tolles, questions for Detective Hagan?
Yes, thank you, Judge. Detective Hagan, you indicated that your ID technicians found a fingerprint on the passenger side of the vehicle, correct?
Yes.
That fingerprint could have been imprinted at any time, days before, weeks before, correct?
I'm not sure.
But that is possible, correct?
Right.
Okay. So when you stated that to the court that you believe that he was at the scene of the crime, that's just a possibility that it could have been at the time, correct?
Certainly.
But it also could have been days or weeks before, correct?
I don't know how long fingerprints last on cars, so I don't know what the weather was before then, so I don't know if it weeks before. I'm not sure.
You don't, as a homicide detective, you don't know how long fingerprints can be on items?
I do not know.
Okay. Also, you stated that there was a number of witnesses. In fact, you weren't brought to the scene initially because of a homicide. You were brought to the scene because there was a car crash in the apartment complex, correct?
I was requested to the scene because it was a homicide.
Okay.
The initial officers that responded out there did respond to the apartment complex because there had been a car crash. That's
Okay.
correct.
But that was the first call. That was a car crash?
Correct.
Okay. And there was 2 individuals in that car, correct?
Yes.
And they were described as dark-skinned juveniles, correct?
Yes.
Okay. And you've actually had the opportunity to show Mr. Norris's picture around and photo IDs and things of that nature, and no witnesses put him at the scene during the time of the crime, correct?
That's correct.
The interview that took place at the, I guess it's the probation office at the Peachtree Memorial Drive, was Mr. Norris informed that homicide detectives would be there to talk to him?
I don't know what Officer Kelly told Mr. Norris about that meeting, so I don't know. I don't know if he told him that homicide detectives were going to be there.
Okay, but you did not specifically tell him yourself
Officer
that
Kelly.
we need to speak to you about a homicide,
Oh, did I
correct?
tell Mr. Norris that?
Yes.
No, I did not.
Okay. And so Mr. Norris was there because he was required to be there by his probation officer. He was required to go down there, correct?
Correct.
Okay. To do whatever they do, drug testing or whatever things for probation, correct?
Correct.
Okay. However, you were there because you weren't there interested in Mr. Norris's probation. You were there because you were investigating a homicide, correct?
Correct.
And when he was turned over to you from the probation, did he initially meet with the probation officer? Or did he initially meet with you?
I think I think he had to sign in to probation office. So I think he made contact with Officer Kelly first. And then we were presented the conference room to speak in. And then Mr. Norris came in there with Mr. Kelly to the room.
Okay. And at some point, Mr. Kelly left, correct?
Correct.
Okay. Now, at any time, did you or Mr. Kelly tell Mr. Norris that this was a voluntary interview?
No.
At any time, did you tell Mr. Norris that he was free to leave at any time?
I did not tell him that.
At any time, did you tell him that if he wanted to stop answering questions, he could get up and walk outside the room?
I did not.
And his interview room was done inside of you said a meeting room, a conference room, correct?
Correct.
Behind the closed door, correct?
Yes.
Okay. At any time, did you read Mr. Norris his rights, correct?
I did not.
I'm sorry. Did you read him his rights?
I did not.
You did not. So if you didn't tell Mr. Norris that he was free to leave, that he didn't have to answer your questions, that he could stop questioning at any time, how would Mr. Norris know that this was a voluntary interview and he could leave if you didn't tell him that?
I'm going to object to calls for speculation.
I'll allow it in this setting of a suppression hearing.
How was Mr. Norris to know that he could get up at any time or stop answering questions or do anything if you didn't specifically tell him that he could?
I don't know. I explained the situation as to why we were there, and the details that we knew at that point. And I think I even told him in the interview that we're here to find out why your fingerprint was here. I did not accuse him of a crime. I was simply trying to understand why his fingerprint would be found.
Correct. And we understand that. But prior to trying to gather that information, you never advised Mr. Norris that he did not have to answer your questions and could leave. You could leave right now.
That's correct.
You relied on what you would call a Fourth Amendment waiver to take his phone. You actually did seize his phone that was on his person, correct?
Yes.
Okay. And that was done without his consent or anything like that, correct?
Yes.
In fact, he didn't want to even give you the passcode, correct?
Correct.
So he definitely was refusing consent at that time, correct?
That's correct.
Okay. So he wasn't allowed to leave at that time, correct? When he's refusing to give you the passcode to his phone, he wasn't allowed to walk out with his cell phone at that time, correct?
Well, it's two different things. It sounds like he was always free to go. He wasn't free to go with his phone. He would leave empty-handed.
I was not going to restrain him from leaving, but the phone was going to be seized, yes.
Okay. Can you tell the court how the phone exactly was seized?
I'll be honest with you, I don't recall if Mr. Norris had his phone in his possession at that time when we were talking, or if Officer Kelly had his phone prior to. I don't remember. I just remember when we were asking Mr. Norris, Officer Kelly asked him to open the phone with the passcode and he denied it. So he had to have possession of his phone because we were asking for the passcode. So does that answer your question?
Yes, it does.
Do you recall, ultimately, you got the phone, but do you recall some physical struggle where Officer Kelly had to pry it out of his hands? Or it just, when told to hand it over, he handed it over?
I believe that when he was told to hand over the phone was handed over. His objection came when we asked for the phone to be opened and he refused.
Okay.
The waiver that you relied upon, and it's part of state's exhibit now, never specifically references a phone, correct? Or a cell phone.
If you need it, it's not a quiz.
No, it doesn't say phone specifically, no.
Okay. It talks about your house, correct?
Yes.
Your papers, correct?
Correct.
A vehicle, correct?
Yes.
And your person, correct?
Well, there's one more word in there. Don't skip them.
I'm not.
Okay.
Person, yes,
Okay.
correct.
And then it says effects.
That's correct.
Okay. So the word effects, what is the definition of that? What is your effects?
Well, I mean, I would take that to be his other effects, meaning belongings.
Okay. Like a backpack?
Well, a backpack, yes, could be that, yes.
Okay. But nowhere in there does the waiver state specifically that we can seize your cell phone, use a data extraction device to get information out of it. That doesn't say anything about that in the waiver, correct?
It does not say that in the waiver.
Okay. And at the time that you stated that the belief, you said the defendant is in violation of probation. The only evidence that at that time that you took his phone was that there was this fingerprint on the passenger side of a car, correct?
Yes, it's palm print, correct.
Although Mr. Norris does not match the description of a dark-skinned juvenile, correct?
Correct.
So in effect, you had no reasonable belief or even unreasonable belief that Mr. Norris was in violation of probation because he didn't fit the description of the suspect seen fleeing the car, correct?
I disagree.
Why is that?
The fact that his fingerprint was on the car, of the victim's car, and two people were seen, yes, the description is off on the physical description, but to me, the fact that his palm print was on the car seems suspicious to me that it would be on the victim's car. Meaning the victim had just been murdered and somebody attempted to take his car and crash the car, and Mr. Norris's palm print is on the car. That seemed suspicious to me.
Can you may have already said this, so remind me or tell me for the first time. The deceased is actually not in the car. He's in his apartment, which was where in relation to where the Jeep was crashed. We've heard a lot about Southwood Vista. That's where the Jeep was. Where's the deceased?
So
In the same apartment complex?
Yes. So
Okay.
the Jeep is in front of the apartment building. I don't know if it's the victim's direct building or right next door to it, but the victim's apartment is down some stairs at the bottom.
Okay.
And when the officers attempted to make contact with the victim, they had
Because they ran the tag and it says it belongs to Donovan Mitchell, whatever the name was. I'm sorry, I don't remember it. Donovan Maxwell. Oh, look at that. It's right near here. Let's go knock on the apartment door.
Right.
These are the officers who respond to the initial call, as Mr. Tolles pointed out, which is not a homicide, car crash. Huh, this is Mr. Maxwell's car. He lives right here. Knock, knock, knock. No answer. Welfare check. He's dead inside. Okay.
any fingerprints of Mr. Norris was found inside the home?
No, sir.
Do you ever find the gun that was used to kill him?
No.
1 second, Josh. Okay. That's all the questions I have for Detective A.
Any redirect?
No, Your Honor.
Okay, Detective, thank you for your time. Mr. Abate, any other witnesses?
No, Judge.
All right, the evidence is closed as to the suppression, I'm gonna call it suppression motion. I appreciate it's two things, its statement and phone and its contents, but one motion, clearly interconnected here. Is there any argument you want to make, Mr. Abate, or do you want to rest on the record?
I'll make a very brief argument, but I rest on the record.
Okay.
I'll rest on the evidence.
All right, Mr. Tolles, any argument you want to make, or do you want to rest on the record?
I do want to make an argument, Judge, as it relates to several issues here. First, Judge, we find that the Fourth Amendment waiver that's being used here is truly overly broad, and does not put the defendant on any notice that a cell phone can not only be seized, but also searched by some type of electronic device where they can get your photographs, location of where you've been, your Google searches and things of that nature. It doesn't talk anything about that. So in as much as the court may rely on the waiver and it says the words effects, it's just overly broad, Judge, and it does not put my client on any notice. And we would say that that it would be unconstitutional. It would be unfair and a violation of anybody's rights to have any of their amendments taken just because they're placed on probation. Can they take your Fifth Amendment right to remain silent? Is that something they could put in this order? Can they take your Sixth Amendment right to an attorney, say you can't have an attorney? Could they take your 13th Amendment right and say you're going to work for free for the rest of your life? No. So why would the court be allowed to, just being placed on probation, be allowed to say that we don't have to basically have any reason, we can search your phone, your car, your anything, and not specifically, not without that specific saying. Effects, Judge, is just too general. Judge, another reason why this should be suppressed is that there was no real evidence against Mr. Norris. A fingerprint on side of a car, not the home, not inside the homicide scene, but just on the car. Well, that might have been relevant if Mr. Norris was actually seen jumping out of that car, or seen in that car, crashing that car. But the suspect, what was given was two dark-skinned juveniles, and the officer admitted that he does not fit that description. So now we don't, none of us have to be detectives, but I think common sense, we know that fingerprints could be there at the time of the time. Yes, it could be. That's one option. But it could have been days, it could have been weeks, it could have been who knows when that fingerprint kind of got there. That alone, Judge, is insufficient. But then when you get down to the actual interview, where we get to the actual motion, Judge, my client was there for probation. He had to be there. I mean, it's not voluntary. You got to go. So we're already in an involuntary state, and he's being turned over to police officers, and he's acquiescing to their commands. He's not free to leave. He's not been told he's free to leave. He's not told he doesn't answer any questions. So how could my client, who's not a lawyer, who's being basically ambushed, know?
He's sitting in a room. Be pretty savvy about things. He critiqued these detectives on their own work. Like, come on, you guys know better than that. So I don't know it's fair to characterize your client as unfamiliar with police interactions. I'm not disagreeing with your description of the setting And certainly Detective Hagan was candid about it. I didn't say it was voluntary. I didn't say he was free to go. But your client professed to be more knowledgeable about how interviews go than the detectives were.
And Judge, we know that's absolute nonsense. And Judge, and if he was that savvy, then imagine if the detectives had done what they should have done and told Mr. Norris from the outset that we're here to interview a murder, a homicide at a court of this complex. Your fingerprints were found on the car. We'd like to speak with you. It's a voluntary interview. You do not have to speak to us. You can end the interview at any time and you can walk away at any time. What would have been the savvy Mr. Norris's decision at that point?
According to him, he talked to them because he didn't know anything about it. That's why he was talking to them. So I don't think you get it both ways, but I also don't think that the proper analysis is Mr. Norris's perspective on this. So that's not how I'm going to analyze it. I'm just pushing back a little bit. That
and I would ask that not, because Mr. Norris and all these defendants, everybody thinks they can out slick the police or out talk the police or whatever. That's not relevant. What's relevant is the police actions and the police putting Mr. Norris in a position where he actually feels voluntarily and being forced to sit in a room without being asked, do you want to sit in a room? Do you want to talk to us? Is in effect being in custody. And at a minimum, Judge, even if we're not to the point of Miranda, if we're really going to say that this word, if it's a voluntary, then the word voluntary needs to at least come up one time, which it never did. The words that you are free to leave needs to at least come up for at least one time. It never did. And you could cease questioning at time, which never did. So him being placed in that situation where you're basically being ambushed, if given a choice, a fair choice, a voluntary choice, and he could continue to talk, then I obviously would not have an argument. But since they never gave Mr. Norris any real choices, of course, he's going to sit in that room, acquiesce to police questions and things of that nature, and probably tell some things that aren't very true in that interview. And now going before a jury, my client doesn't look in a very good light, because now they're going to say he's a liar. You lied to the police, so you must have killed him. So, but if he was given an opportunity not to even go in that interview, then they wouldn't be able to say that. So again, just to kind of sum up, Judge, it wasn't a voluntary interview because there's no questions. We believe that the Fourth Amendment waiver is overly broad, and the court should not be taking constitutional rights from you just because you're on probation. And if they do, it needs to be laid out in a more specific broad where, yes, we can take your cell phone, open it up and look where you are, which is in the waiver. And also that look at my motion. So we're asking the court to seize the entire questionnaire, because again, even though he doesn't make any admissions, misleading the police, or the state could argue that he's misleading or lying to the police, would not look good for him at trial. We're asking that the whole question and answer be done for failure to really have a true voluntary interview. We're also asking, Judge, that the phone and its contents not be, because if we're looking at the case, Judge, other than if they don't have the putting him at the location, the phone, that's the key, because with just the fingerprint, they don't have. So we really need this evidence suppressed, because they really don't have anything beyond, he's not identified. There's no identification here. And him searching, for a homicide in that area, the state's also going to argue that looks suspicious and that makes him look guilty. That needs to be, and because the effects isn't worded, Judge. I doubt that my client, if knowing that the detectives were going to be there to seize his phone, I don't think he would have even came. So based on that, Judge, we're just asking you to consider all that in your ruling.
Got it. I will do just that.
Judge, for the record, can I just give you some case law?
Yes, I was going to ask the two areas where case law would be most helpful for me. I don't think I've had a Fourth Amendment waiver suppression hearing before. It's easy to look up, so I can find some, but that would be helpful. And then the other area that I'm going to poke around in online about would be how talismanic the word voluntary is. I mean, it's more than that, because it wasn't you're free to go, but there wasn't the exchange that would have made plain, but it also wasn't an overtly custodial interview. It's in that in between. And my guess is I'm going to find cases that say that wasn't okay, and there are going to be cases that say it was okay. There were no handcuffs, there was nothing like that. But it also wasn't, hey, we'd love to talk to you, but if you want to leave, you're free to leave. Had that been said, I think Mr. Tolles would have had much less to stand on in terms of the statement. He'd still have the whole argument about the Fourth Amendment waiver. So anything you want to share in either of those areas would be great.
You want it now, or do you want us to email it to you?
It'd be fine, and just email it. If you'll email it, Mr. Tolles, I'll give you 24 or 48 hours to email something else. Don't brief anything. Just say, hey, these 3 cases I think are the ones you really should be looking at. Okay, great. Thank you. If you are both ready, because we've got Mr. Norris here and it's part 2, I don't think it will take as long. I'd love to talk about the 404B motion as well. Are you in a position to do that, Mr. Abate?
Yes, Judge.
Great. Let me send one email and then we can do that.
And Judge, I wanted to also put on the record that we're going to object to the state using a proffer for a 404B. We believe that the state should call witnesses so the court can have a full fleshing out of whether or not those particular incidents meet the threshold, because just using a proffer, that would be, I guess, in their what they believe it is, but it would not be enough for the court to determine whether or not this meets the similarity requirements. So we're objecting to a proffer.
Okay. That's on the record. Let's not talk about 404B yet. Beyond that, let me send this email and we can do it.
Thank you.
Okay, Ms. Rivers, you good if we do this motion and then take a quick pause? I think we've got a couple pleas we could take right after that. Okay, so we are still on the record in Mr. Norris's case, and the state in September filed a motion to introduce some 404B or other acts evidence. And it is a single, make sure it's 2 different transactions. There is an alleged aggravated assault from 2019 in Atlanta, and then another alleged aggravated assault from 2019 also in Atlanta. So Mr. Abate, if you want to, what would help me the most would be to have you proffer up. I understand the objection, it's on the record, but I'm generally comfortable with initial proffers, given that the burden of proof for a 404B matter is preponderance and not reasonable doubt. But I am also sensitive to the concern that Mr. Tolles raised, which is if the only way the state's going to prove up a 404B matter, if it's coming in, would be through the testimony of an eyewitness or something like that. We may need to have that person testify outside the presence of the jury first. But I don't need it right now to get a general sense of what the state is trying to do.
Yes.
So with that.
So just because you want to proffer of the 2.
Oh, so sometimes when you or your colleagues present, tell me all 3 purposes and the background. I'm pretty fluent in 404B. So we can streamline it. If you would let me know a little bit about the facts and circumstances of this case.
Yes.
And then what these other 2 incidents are and why you think there is a proper purpose that would allow those other two to come in.
Yes, Judge.
Great.
So the incident that we are here before the court today was a May 4th, 2020 incident that involved the assault, armed robbery, and death of Donovan Maxwell at 2125 Southwood Cove, Atlanta, Georgia. What I would submit to the court is that the evidence would show that two individuals were seen fleeing from the victim's vehicle on foot after the vehicle was crashed and running in a direction towards 3109 Camilton Road. They were running in, there's a cut or a pathway where they were seen literally running from the Southwood Cove apartment complex all the way to 3109 Camilton Road, which was right behind the apartment complex in which the death had occurred. What I would submit to the court is that on February 5th of 2019 at 7:20 p.m. and then at 11:50 p.m., the first incident occurring at 4210 Notting Hill Drive, Atlanta, Georgia, involved Miss Jessica Smith, where she was held at gunpoint again by two armed robbers who were described as younger Black males. And that incident location is 1.3 miles from the actual incident that we are here before today for the homicide involving Mr. Maxwell. The second transaction, like I said, occurred on the same day, February 5th, 2019, but at 11:50 p.m. at 518 Peg Road, also here in Southwest Atlanta, Georgia, involving victims Antoinette Frazier and Darius Bussey, Bussey. Same set of kind of scenario facts. Two people jump out of a car, hold them at gunpoint, take their belongings, and later, after the armed robbery is complete of Miss Frazier and Mr. Bussey, in both instances, Miss Smith as well as, again, Ms. Frazier and Miss Bussey were able to describe a vehicle which the two individuals jumped out of. When they did that, Atlanta police were able to look at LPRs and look through the area to find cars that fit the general description of a black sedan with a spoiler is what the description was. From there, they were able to locate a car that was very similar to that, and the apartment complex 3109 Camilton Road. At that point, they stopped the vehicle and spoke with the defendant and his co-defendant in the second transaction. Excuse me. And when they did that, they were able to see that both the defendants met the description clothing-wise and physical appearance of the defendant and his co-defendant. But what was interesting is inside the vehicle, which belonged to the defendant's girlfriend, Chanel Murray, were bank cards and I believe an identification or an ID that belonged to Mr. Bussey, tying them to the armed robbery, as well as a firearm that met the description of what both Miss Smith, Miss Frazier, and Mr. Bussey described as the firearm that they were held at gunpoint. With all of that said, the state's purpose for bringing in or requesting that these two transactions be allowed or admitted into the trial of this case is for one, intent, two, plan and common scheme. When dealing with intent, as the court is well versed, that because we're dealing with in each instance, there is an armed robbery. So an armed robbery is a specific intent crime. So here in each of the armed robberies, the specific intent is obviously to commit a theft, which makes intent.
What's the armed robbery in Mr. Maxwell's case? I understand his Jeep is rolling away. Is that what is allegedly taken, is his Jeep?
That's correct. I apologize, Your Honor. So Mr. Maxwell's keys were actually taken from his home and used obviously to steal his vehicle. So that would be the basis for the armed robbery.
So there's evidence that of other people were inside Mr. Maxwell's apartment where he's found dead and they leave with his keys? Or he was in the Jeep also and then he's brought inside, or that's all unknown? Just someone had to have taken his keys because the keys are in the ignition of his Jeep. And of course, he's not, he's in his apartment.
Correct. So the evidence that would, I guess, the circumstantially show that his vehicle or his keys were stolen, which were used to start his vehicle and attempt to steal it, is from as he was pulling into park at the apartment complex, I think around noon, he was literally passing his partner. And there was about a 10-minute in between when the homicide occurred and when he had last seen Mr. Maxwell. He said Mr. Maxwell literally got out of his vehicle. He heard him lock the vehicle and they said their goodbyes. And his partner left and went to his appointment. And he watched in the rearview mirror. He literally saw Mr. Maxwell, after he locked his car, go into his apartment or go down towards his apartment.
Got it. So the last sighting of Mr. Maxwell is his roommate partner seeing him get out of the Jeep, get in the apartment, and then Mr. Maxwell's found dead in the apartment.
Correct.
Okay.
The second purpose would be a plan or common scheme. In each instance, it's very similar. They're all in the city of Atlanta. They're all instances where the defendant is not alone. He's with a second individual where they jump out and hold someone at gunpoint. And the only difference in this case is that in the first two cases that the defendant was on bond for when this homicide occurred was that those victims lived. Other than that, the way in which the armed robbery was committed was very similar. No one said that the defendant was wearing masks, things of that nature. He was showing his face, asked or demanded their items, and then after got the items, immediately ran.
So the two other acts involve people who were walking on the street, or like Mr. Maxwell, it's we don't know how people got inside Mr. Maxwell's apartment, but that armed robbery occurred in his residence. My understanding of the two February ones is that people were pedestrians and a car rolls up, a black sedan with a spoiler that sounds like it was registered to Mr. Norris's girlfriend, fiance, wife, and ultimately had one of the victim's property in it. But it was, we roll up on you, get out of the car and accost you.
Correct, Your Honor. Ms. Smith, I would say is a factually kind of in between the transaction involving Ms. Frazier and Mr. Bussey and then Mr. Maxwell, as she was walking and the car kind of followed her to where she actually resided at the Notting Hill address.
Okay.
So right before she was able to enter into her home is when she was held at gunpoint. So it's similar in that instances, but she just wasn't able to actually get into her apartment.
Okay.
So that would be the state's intent or reasoning that we believe the transactions would be admissible during the trial of this case for the purposes of intent and then plan, Your Honor.
Okay. Mr. Tolles, apart from your request to have, one more question. Both of these February robberies have been indicted?
Yes.
They're the other two cases that I've got for Mr. Norris.
Yes, Your Honor.
Okay. And they simply haven't been tried because they got in line behind the murder.
That's correct, Judge. If you need the case numbers, I can provide them to you.
No, I've got them on the calendar. Okay. Mr. Tolles, tell me your thoughts about why these two other acts would not qualify as 404B evidence.
Well, Judge, I think the first thing that the state has to show is that my client actually committed the crime. So if there was a conviction, that would be more persuasive, I think, to this court than two pending charges.
Well, so you don't spend too much time on it. Pretty persuasive to court / jury / most people would be your client driving a car with Mr. Bussey's stuff in it. So at least one of these doesn't sound like the state would have to stretch very hard to connect your client to the armed robbery. The other one, I don't know, I may have missed it. Maybe there was a photo ID, but no, there's not a conviction yet.
Yes, and but nevertheless, he's not been convicted and was never identified as participating. He's never, just like in this case, no identification. So even though his car might be linked, there's nothing to say that he was actually there pulling a gun on anyone. Also, Judge, the state doesn't need this for intent. The intent of the similar transactions is pretty clear. I mean, people got robbed. Like you said, it's specific intent. However, in the Maxwell case, the case that we're here on the homicide, we really don't know. There may have been a robbery, but we don't know if that was the initial intent of the parties, because what the state didn't tell you that there was that, you remember those two young Black juveniles that were seen, dark-skinned juveniles were seen. Actually, one had come forward and said that with another, person, that he and him were in Mr. Bussey's apartment, and there was something about Grindr.
Mr. Maxwell?
Mr. Maxwell, yes. There was a Grindr in the app, where I guess the social meeting app where people guys hook up like that. Like, it's not even like they need to get to know each other. And so that there was and Mr. Maxwell had tried to grab this other guy named Tootsie or something like that. And Tootsie got mad and killed Mr. Maxwell, and they both ran out, tried to jump in the car. And the juvenile who actually admitted this actually was able to put a what is it called, the hookah. Because they asked him like what's in the house, and he actually was able to say hookah. And they tried to discount it because he said that he saw TV when there was no TV. But I think it was very interesting that he said that there was a hookah in there. How could he not know that if it was already there? And so there's the motive and the circumstances surrounding Mr. Maxwell death are a little bit more murkier than the two similar transactions. We believe that what the state is intending to do with these two similar transactions is basically say, well, Mr. Norris, because you're involved in these two other cases, then you must have done this other case. And that's the only thing, because they've even said it a common scheme. And what is, usually forbidden in court is, person's character. And so to say that Mr. Norris is a robber, and so he must have had to do this, is just the kind of evidence that this court doesn't. And so are the similar transactions helping the jury with some particular purpose? Intent is not, and in the other cases, there was no homicide, the pedestrian. And again, there's the state can't prove that this was really an armed robbery, other than the fact that they're saying, well, the keys were taken from Mr. So that must have been the intent. We don't know if that was the intent. That we don't know what the intent of that was. That could have been something that would have started off just after the fact. Maybe they're trying to move his car so nobody would do like the police did and go inside and look. So we don't know. But I think that it would be highly prejudicial. That's another thing that I think the court needs to look at. Highly prejudicial, especially in a case such as this, Judge, where you have it's very circumstantial case against Mr. Norris. To put those type of similar transactions, Mr. Norris may be convicted, not because the state actually proved its case in chief, but because the jury felt like, oh, if your name keeps coming up here and your name keeps coming up there, then you must have done this as well, because your fingerprint was there. And you perhaps if the court granted a motion, you looked him up on the internet and your cell phone puts you in the area. So you must have done this too. And I think that's what we want to try to prohibit. If the state has a good case, Judge, if Mr. Maxwell was just simply walking around like the other ones, and a black car with a spoiler on it pulled up to Mr. Maxwell, that would be fairly similar, and I would have a less of an argument. But here we have his lover saying that he was not robbed as a pedestrian, that everything was great. I left the scene, and Mr. Maxwell, and after that, there's Grindr stuff going on and everything else on his phone. There could be another motive for this particular situation that does not have anything to do with the first two. So I'm asking the court, in light of the proffer that's been given, which is not supported by any evidence from the stand, to deny using this motion, and that we try this case. If he's guilty of the other two, whatever, just like you said, if they're gonna, if they connect him to the other, there's a penalty for that. But to kind of convict him by associations and names, Judge, I just feel like with the circumstantial nature of this case, that it's just not, it doesn't meet the similarity requirements and the strength of evidence requirements needed to that. They don't need this to prove intent or common scheme. They're just trying to put Mr. Norris on trial as a career criminal that, had previous armed robberies, and now this armed robbery ended up in a murder. So I would ask the court to deny the 404B in this particular case because it's not similar.
All right, thank you. Mr. Abate, one question, and then you're welcome as the movant to add anything else you want. As I'm reading your filing, the Fraser Bussey armed robbery at Peg Road was almost midnight, so definitely nighttime. It's dark out. Ms. Smith was robbed right outside her home on Notting Hill around 7:30, so nighttime. The Mr. Maxwell situation, though, was, we'll call it broad daylight. It sounds like it was a little after noon. Is that a fair, am I getting the times right, or do I have that wrong?
Times are correct, Your Honor.
Okay, all right. Anything else you want to say in support of your motion?
In support of my motion, I guess to respond to defense counsel's, claims that the juvenile who confessed will go with his initials JB. JB, we have recently spoken with him, and there will be a supplemental report done by Investigator Rickman. He made clear that he was told by the defendant and his mother to say the things that he said, which that he was there with some guy named Tootie. He made very clear that was only said because the defendant told him to say it and said he wouldn't get in trouble, and paid him $40 and gave him some marijuana. So, and there was marijuana found in the black vehicle when he was arrested. So it's
when
Mr. Norris was arrested in the Bussey Frazier case, he had marijuana on his person. But it was made clear that the mother of Mr. Norris is actually the person who brought this juvenile to Detective Agan to be interviewed. And it was represented to Detective Agan that Mr. Norris's mother, who brought this juvenile to confess as to what he had allegedly seen and about the sexual acts that were supposed to take place, was because the defendant told him to say it. And Detective Agan was actually under the impression, based on what Mr. Norris's mother provided, is that she was related to Mr. JB. There's also a jail call after the defendant is arrested and extradited from Minnesota, where he fled, and then was extradited back here to Atlanta. There's a three-way call between JB, Mr. Norris's mother, and Mr. Norris, who's in custody, where Mr. Norris is telling the JB, you remember what you need to say, and this is it. So,
okay. The plot thickens for the case in chief. I'm not sure how all that feeds into the 404B, but that's interesting. Thank you for sharing that. Sounds like, Mr. Tolles, you're going to be getting a little more information about that set of circumstances you shared with me. I will take under advisement both of these, and I'll hold off for a few days on the motion to suppress, so that Mr. Abate, you can shoot an email to me and Mr. Tolles with any case law you want me to consider in connection with Fourth Amendment waiver, or how to work through the voluntariness of what appears to be a non-custodial interview, but the word voluntary or phrase free to leave isn't used. And then, Mr. Tolles, you're welcome independently to share case law, or you can do it on a reactive basis if you want to see what Mr. Abate sends. But if enough time goes by and I haven't heard anything from either of you, that's not a problem. It just means I'm going to start working on it anyway. I am anxious, as I am sure Mr. Norris is, to get him into court for whatever the final resolution is going to be of not one, not two, but all three of his cases. So I need to get rulings on these two before that can happen so that everyone knows what the landscape is. Will there be evidence of other acts or not? Is the contents of the cell phone coming in or not? And the statement made to Agan and Benton. So I appreciate everyone's work today on this. Mr. Norris, do you have any questions about what's coming next? No? Okay. Mr. Tolles, anything else?
No, Judge, thank you for your time.
All right. Mr. Abate, anything else?
Just, Your Honor, there was a motion that was recently filed by JB, the juvenile's lawyer, trying to quash the subpoena. So I just wanted to put that on the court's radar. He was subpoenaed for trial. And upon him being subpoenaed for trial, his lawyer, it was back in when it was originally set for trial a few months ago.
Okay.
I just wanted to bring that to the court's attention because that'll likely be an issue.
That we'll need to work through, certainly. Look at that. Because Mr. Norris was originally on a trial calendar, but Mr. Tolles had a conflict, and so it's not on that trial calendar. I know it's coming back up for January, and I've got my eyes firmly on it as one that we ought to try.
I bring it to the court's attention because I suspect
It will be renewed.
yes.
Okay.
The
Got it.
subpoena would still be valid since we haven't had the trial yet, and it says until released, and I believe it's still within the appropriate terms of court. But if we were to re-subpoena him, I don't think he would file an additional motion.
Okay, we will need to work through that. All right, thank you. He, the attorney, refers to the child as JC. Is that the same person? Is there only one juvenile you're aware of, or do we have two? Because we heard about two young black males supposedly running from the Jeep.
Only one juvenile. I think that's a misprint on his. They call him JB.
Okay, either way, you think it's the same person?
It is, yes, Your Honor.
Thank you for flagging that. Mr. Norris, we will get you back here for the call of the January calendar. I don't know if we're calling it. I think it must be called in early January, and then the trial weeks may be in mid and later January. But that'll be the next time you come back over here, unless Mr. Tolles brings something up in the next few weeks. But December is kind of consumed by other trials we're doing. So my guess is that you'll be back here in early January. Okay. All right. Thank you.
Judge, may I be excused?
Yes, sir. Thank you for being here.
Thank you, Judge.
Thank you. Ms. Rivers, are you able to do a couple pleas before we break, or do you want to take a break first? Why don't you do that? I'll figure out what we're doing next. Ms. Wood, do we have, I know you have a couple folks. We've had Ms. Saxon here a long time. Mr. Hawk has been online. I think we have Mr. Adams. He is on. So why don't we, let me just get things organized here. So much paperwork. Where's our big calendar? All right, Mr. Adams, can you hear us?
Yes, Your Honor.
Mr. Palmer, why don't you come on up to the podium, please? We don't need a court reporter for this. Place spotlight. There's Mr. Adams. Mr. Palmer is going to be up at the podium. Mr. Adams, Mr. Palmer has informed me that you are handling his 2 cases. Is that correct?
That's correct, John.
He's on for plea and arraignment today. So the question is whether you are going to waive arraignment for Mr. Palmer on his 2 cases, and then we'll enter a scheduling order, or if you want him to be formally arraigned.
We will waive arraignment, John.
Okay. Mr. Palmer, Mr. Adams is going to be filing a document that enters your plea of not guilty in the 2 cases, makes plain he's your lawyer in those 2 cases. And then the prosecutor, Mr. Hand, who's seated behind you, will get discovery to Mr. Adams so that you and Mr. Adams can talk about these 2 cases and what makes the most sense in terms of resolving them, whether it's a plea or maybe there's a diversionary disposition. I don't know. That's a conversation for you and Mr. Adams, and then Mr. Adams and Mr. Hand. But what we'll do today is get things rolling. I'll get a scheduling order out that will have a deadline for Mr. Hand to get discovery to your lawyer, deadline for your lawyer to file any motions, if there are motions we need to work through. And then I'll see you next, either because you all have sorted it out, or what we have is called a status hearing, where I confirm all the discovery's been provided. That's the last day you can enter a plea and have the right to withdraw that plea if you don't like the sentence you get. And after the status hearing comes a trial date. Any questions about any of that?
No, sir, Mr. McBurney.
All right, Mr. Adams, any questions or anything else we need to cover on behalf of Mr. Palmer?
No, John.
All right, will you get one of the waiver of arraignment forms for both these cases and file those?
I will do that today, yes.
Great, fantastic. If you do that, that'll get the ball rolling. Mr. Palmer, you know how to reach Mr. Adams?
Yes, sir.
Great, then you're free to go.
Sir.
All right.
See you too.
Same. Mr. Adams, you're free to go.
Thank you.
All right. Ms. Wood, tell me what you would like to do, or Ms. Feely, whoever's got something. We got Ms. Rivers back, and we've got some time to move some of these cases.
Yes, Your Honor, I have position 8, Mr. Williams. I filed a waiver.
Tavante Williams. Okay, he's going to waive arraignment.
Yes.
Oh, right, and he qualifies, so you will represent him. Great.
Got contact information for him, so with the court's permission, we're asking for him to be excused.
Yes, and this will be whose case, Mr. Hand?
Judge, this will be Mr. Shapiro, I believe. Let me double check. Yes, Mr. Shapiro, Judge.
Great. So if you could let him know that Ms. Feely has waived arraignment and that he should be getting discovered. Well, a scheduling order will go out, so he'll know what to do with that. So Ms. Feely, you'll file that waiver, and maybe, I don't know if it's a change of address form, whatever we need to get Mr. Williams current.
He's good.
Good, he is good. Okay. Mr. Williams, appreciate your patience today. Ms. Feely is going to be your point of contact. Do you have a good phone number for her? Excellent. I don't remember what the conditions of your bond are, but continue to comply with those. If you're supposed to stay away from someone, stay away from that person. And if you've got questions about what's going on with your case, you reach out to Ms. Feely. I'll see you next for a status conference, okay? You bet. You're free to go. All right. Next.
Judge, position 9, Richard Jackson.
Yes.
Unfortunately, we're not gonna be able to resolve that today. I have spoken to Mr. Hand, so we'll just keep working. I've already filed a waiver in the substitution of counsel. If we could just bring him to the door real quick so we can see you.
You bet.
He's good to go down.
Okay, we'll do that. So when you're ready, Mr. Jackson, just right to the, you got to get another donut before you do that? No? Okay. And after we do Mr. Jackson, what are we going to do?
Judge, I'm prepared to talk about Mr. Robinson, the walk-in bench warrant set aside, and then Ms. Saxon's ready to plead, and then Mr. Clark as well.
Great. We can go in whatever order you want. I guess we should start with Mr. Robinson because that'll be quicker. Can I have his case number, please?
It is 22 SC 184 289.
289?
Yes.
Thanks. Hey, are you Mr. Jackson? Hey, Mr. Jackson, I'm Judge McBurney. It's nice to meet you. You can stay right there. This will be quick. I'm just finding your case here. Leonard Jackson. All right, Mr. Jackson, Ms. Wood told me she was hoping maybe your case would work out today. Didn't quite get there. She's going to continue moving in that direction. I wanted to introduce myself, let you know that Ms. Wood's going to file some papers on your behalf that will get all the discovery in the case. So police reports or whatever it is that the prosecutor has will get to Ms. Wood so she can share that with you. And then she's going to keep talking with the prosecutor about possibly resolving your case short of trial. But if we need to have a trial, that's where the case is moving now. Okay? Any questions about that?
Hope for the best.
Okay, we've got a good lawyer working for you. She's going to aim for the best. And as long as you partner with her, when she comes to talk with you, talk with her, read over the discovery, then we'll see where it goes. Okay? Well, it depends. The status conference, which would be me confirming that everyone's got discovery and your case isn't working out, but maybe you're going to go to trial, that'd be sometime next year. But if Ms. Wood is able to make progress in resolving the case short of trial, before trial, we can bring you back whenever. We have court all the time. So I can't give you a specific answer other than Ms. Wood's going to be working to sort it out. She thought initially, not knowing enough about the case, that maybe today we could work something out, but that's not how it played out. I don't know what the negotiations are, just that it didn't work out today. But I'm available should you and Ms. Wood work something out, okay? Ms. Wood will talk to you about that, and if she thinks that it's appropriate to have a bond hearing, we can do that too. We don't need to wait till next year to do that, all right?
Mr. Jackson already saw the bond, which I'm gonna have, so we'll talk about that after today, okay? Thank you, Judge.
Great, thank you, guys. All right, let's talk about Mr. Robinson. Let me see his case. You are James Robinson?
Yes, Your Honor.
All right. And you were indicted in September. And you missed court 10 days ago.
Yes, the letter didn't come to Friday.
Okay. Let me just check a couple things here.
And may I ask what's this case about?
Yep. So you are indicted for allegedly on July 28th of this year, engaging in reckless conduct because you waved and pointed a gun in the direction of a car that had people in it. And that you did that somehow in connection with being in a gang. I'd love to tell you more, but I can't tell more than that by looking at the indictment. And let me see what else happened. And then you missed court on the 7th. You're saying you did get a letter, but it came
Friday.
Okay. Friday, which would have been the Friday the 4th?
No, this Friday.
This is past Friday. So it came several days after you're supposed to come to court. Okay. Let me see what we've got here for you. An address on Fisher Road.
Yes, 1940 Fisher Road.
69C?
Yes.
So that's you?
Yes.
All right. Just the letter didn't get to you in time.
No.
Okay. Ms. Wood, will you be handling Mr. Richardson's case?
I think he's actually gonna be Miss Feely's, but I will.
Right now, you're going to manage it. Okay. So you could do a waiver of arraignment, et cetera, for Mr. Robinson. We've got the right address. It's just a question of, do I lift the bench warrant, given that Mr. Robinson has walked into court and the nature of his charge, which is reckless conduct, turned into a gang indictment.
Judge, I would ask that you lift the bench warrant and set it aside, given that he was proactive in reaching out to your chambers once he realized he had missed court. And I have gotten good numbers for him, so hopefully we won't have any more issues contacting him moving forward.
Okay.
Your Honor, I had one on the steady song that like I ain't like trying to miss no court purpose. I'm on a whole ankle monitor. So
what are you on the ankle monitor for? A different case?
Like when I got
Nah, this for this case.
Your
Like
bond?
when I got, nah, they ain't my bond. Like when they put them gang charge on me. I ain't get charged with them until I got in the jail, like at 10 o'clock. After I went to court, the next day they put a gang charge on me. I ain't get booked no gang charge.
Okay. I don't have any paperwork about your bond. This is a funny looking case from the docket side. There's no CP number, just a DA number. Okay, so you're wearing an ankle monitor right now.
Yeah.
Interesting. Does the county pay for it or do you pay for it?
The county.
Okay. All right. Well, you should be extra easy to find. I'd love to see your bond, but it's not in the system. At least where I can find it.
Right on a $50,000 bond.
I believe you there's a bond. If you got an ankle monitor, you're on a bond. And I'm not real smooth with the system, so the bond is in there somewhere. It's just not easy for someone with my skill set to find. Mr. Hand, you're going to be speaking for Mr. Hiles, since he's still in his 9 o'clock. And this wasn't on his, he didn't know to be here for this. I don't know. What are your thoughts about lifting the bench warrant based on what you've heard?
Judge, the state does not oppose. I did find the bond order.
What's it under?
It's under CP. It's 22 CP 211039.
Huh.
So the different chart, not completely different, but different charges than what was indicted.
211039.
Total bond is 45,000.
There he is. Whoa, aggravated assault strangulation. That went away. Okay. I interrupted you. You're talking about the $15,000 bond? Or you see a different
I'm
one?
saying the total was 45,000. So I'm seeing 15 for count 1, 15 for count 2, and then 15 for count 3.
That's interesting. There was a bond, maybe the judge messed up because there was a bond order for 15,000 that was entered one day, and then the very next day.
The gang charge carried a $30,000 bond. That would change my bond.
Okay, interesting. This is got paperwork I've never seen before. Okay. Anyway, you got your ankle monitor. Maybe we can connect the systems, the CP case with the indictment. More important, I will lift the bench warrant, and you need to be in touch with your lawyer, who will probably be Ms. Feely, who is not in here right now, but is a colleague of Ms. Woods. And if you move for any reason from that apartment, make sure you let your lawyer know, because you need to change some paperwork. Otherwise, things will keep coming to you at that address.
I got you.
Okay. All right. Anything else, Ms. Wood?
No, Your Honor, we have updated contact information for him.
Great. You'll file a waiver of arraignment?
Yes, Judge.
Excellent. That'll move the case along. Thank you.
Thanks.
You're free to go, okay? Have a good day.
So Ms. Wood, do we want to do Ms. Saxon now? Mr. Hawk, how do you want to go forward?
Judge, Mr. Hawk had asked to go first since he's working today, but I had told them to log off during the motion, so I'm not sure I haven't had a chance to. Oh, there they are.
All right, you gonna put a shirt on?
Yes, sir. I'm sorry. He was asleep. He just got off work.
Okay. Shirt would be good.
I'm sorry. He just got off this morning.
All right, is this from the trial calendar? Should I go grab, let me go grab the trial calendar. Don't go anywhere. You can put a shirt on while I get this.
Just insurance. Taking.
Okay, I was gonna ask you what it was.
2 to 20, that's the range I have.
Okay.
Oh, you had to put on a Lakers shirt of all the things you put on? How about Warriors? About the Hawks. Yeah. How about the Celtics? Oh my gosh, that was an ugly game last night. What did they make, like 500 3-pointers against the Hawks?
Yeah. The way you said it sounds like it's 3.5, just 60 serve.
Okay.
3. Is that the way? I want to make sure we have the same meaning.
So 3 years probation and served, 6 months reduced to time served.
Right.
Yes, that's right.
Golden State coming here this year?
But the balance.
Hey, they play everyone. They'll come at some. Oh, yes, there's usually one home and away. I said there's usually one home and away. I don't know.
I think I like start talking in circles.
Okay.
Yeah, they may have switched it up.
Thank you, Pierce.
But Golden State can't win on the road right now, so I don't want them coming here. It'll be ugly.
Well, we'll make them look good.
Yeah.
We'll make Golden State look real good.
All right. Are we ready to go with Mr. Hawk?
We're ready, Judge.
Yes, Judge.
Great. Let's do it. Mr. Hawk, can you hear me?
Yes, sir.
Great. It's my understanding from Ms. Wood that you are prepared to enter a plea in your case. And you are, I'm going to find you on our trial calendar here. I think you're the very last position. You're position 28 on the trial calendar. It's 22 SC 182581. And it is fine for you to be appearing from your home where you need to install a new battery in your fire alarm. But I need to make sure that you are waiving your right to be here in court. Are you comfortable proceeding from there?
Yes, sir.
Okay. You also have a right to have Ms. Wood by your side during this plea, but you can waive that right and have her be here in court where she is while you are at home. Do you waive your right to have Ms. Wood by your side?
Yes, sir.
You understand that if you want to speak with her privately, it's very easy to do. I'll move you into a breakout room. Ms. Wood will get into a breakout room. And once you're there, what you say is confidential. Will you let me know if you need to have a private conversation with her?
Yes, sir.
Okay, great. Then in a moment, Mr. Hand is going to put you under oath. When you're under oath, it's important that you answer all his questions and mine truthfully and completely, okay?
Okay.
Mr. Hand.
Thank you, Judge. Mr. Hawk, can you raise your right hand so that I can see it in the camera? Thank you. Do you swear or affirm that the statements that you shall give the court regarding the matter currently before the court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can lower your hand. Please state your true and correct name for the court, please.
Jeremiah Hawk.
And Mr. Hawk, are you currently taking or under the influence of any medicine, drugs, or alcohol?
No, sir.
Are there any medications that you would normally take that you have not been given or taken yourself?
No, sir.
I'm sorry, I spoke when you spoke. What was your response?
Repeat.
No, sir.
Okay. How old are you, Mr. Hawk?
18.
And how far have you gone in school?
11th grade.
Can you read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged in the indictment 22 SC 182581 with the following charges? These are not the charges you'll be pleading guilty to, but I just want to recite the charges for the record. Count 1, hijacking a motor vehicle in the first degree. Count 2, possession of firearm during the commission of a felony. And count 3, entering auto or other motor vehicle with the intent to commit a theft or felony.
Yes, sir.
And Judge, I'll state for the court that it's the state's intent to downgrade the first count to theft by taking under OCGA 16-8-2. And then the state will no pros count 2 and count 3.
And is count 1 a felony or a misdemeanor?
It's a felony still, Judge.
Okay, so count 1 is being reduced to theft by taking, 16-8-2, counts 2 and 3, null pros.
Yes, Judge. And the basis for the theft is it's a vehicle and it exceeds the value of $24,999.
It's a nice vehicle.
Yes.
Okay.
What was I? All right, Mr. Hawk, do you understand that you have the right to plead guilty or not guilty to the charge that you are pleading to today, which is theft by taking?
Yes, sir.
And do you understand that if you plead not guilty or remain silent or don't enter a plea at all, that the state is required to prove these charges against you at a jury trial?
Yes, sir.
Have you had an opportunity to review your rights with your attorney today?
Yes, sir.
Have you had enough time to speak with your lawyer about all of the charges in the indictment, including facts and circumstances related to those charges?
Yes, sir.
Would you like more time to discuss your case with your lawyer?
No, sir.
Are you satisfied with your lawyer's services?
Yes, sir.
Okay. And Attorney Wood, would you waive formal reading of the indictment for purposes of today's plea?
So waived.
Would you also waive any and all defects of the indictment for purposes of today's plea as well?
So waived.
Double checking, Judge. The state is unaware of any outstanding warrants related to this charge, Judge.
Okay.
Mr. Hogg, do you understand that the minimum and maximum sentence for the theft by taking charge today is minimum 2 years, maximum 20 years?
Yes, sir.
And do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Your Honor, that is 3 years to serve 6 months. Those 6 months reduced to time served, and the balance of that, which is 2.5 years, probated. Do you understand that to be the recommended sentence today, Mr. Hawk?
Yes, sir.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, sir.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge today?
Yes, sir.
Do you understand that if there are multiple charges to which you're pleading guilty today, that the court also has the right to run those charges consecutive, which means one after the other?
Yes, sir.
Do you understand that if the court decides to enter a sentence that differs from the negotiated plea that you're expecting today, that you have the right to withdraw your plea of guilty?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that if you're placed on a probation of any kind, that you cannot violate any criminal laws of any governmental units, those being municipal, county, state, or federal?
Yes, sir.
Do you understand that if you are placed on probation, you must follow all special conditions of that probation?
Yes, sir.
Do you understand that if you fail to follow the special conditions of that probation, that you will then be subject to revocation of that probation for the balance of your sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm at all?
Yes, sir.
Do you understand that doing so will result in new criminal charges for which you will face a sentence between 1 and 10 years?
Yes, sir.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir.
Have you ever pled guilty or nolo to a felony in the state of Georgia?
No, sir.
Have you ever pled guilty to a felony in any jurisdiction?
No, sir.
Has your lawyer explained the First Offender Act to you?
Yes, sir.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on the first offender probation, your first offender status could be revoked?
Yes, sir.
This means that you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in this indictment.
Yes, sir.
Do you understand that by entering a plea today, you're waiving any and all defenses, including any mental health defenses?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights? Those are the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if convicted of these charges at a jury trial.
Yes, sir.
Is it your decision to waive these rights, which means to not use them, and enter a guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea today?
No, sir.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charge of theft by taking in indictment 22 SC 182581?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, sir.
And do you understand that for a felony charge, you only have 4 years from today to file this habeas corpus petition?
Yes, sir.
Okay. Judge, at this time, the state will give a factual basis for today's plea. Were this to proceed to trial, Judge, the state would show that on June 16, 2021, between 11:45 and midnight, officers responded to a BP gas station at 6103 Old National Highway to a phone call from a victim, Mr. Jason Coleman, stating that his vehicle was taken at gunpoint. Mr. Coleman advised that he came to the BP station to buy a beer. When he exited the station, he got in his vehicle. He drove around to the side of the gas station to then put air into one of his tires. While he was there, he noticed 3 Black males. All of them were standing around the gas station. One of them approached him, that one being Mr. Coleman, asking, I'm sorry, not Mr. Coleman, Mr. Hawk, asking to charge his cell phone. His cell phone apparently had died at that moment. Mr. Coleman initially was reluctant. However, he agreed to do so. However, he finished putting air in his tire and met the young man across the street to charge the phone. At that point, he plugged in the phone in his car, waited a bit for it to get some juice, went to give the phone back to Mr. Hawk, and then he turned around toward the passenger side of his window and noticed that another young man had pulled out a gun, told him to give them the vehicle. They didn't take a wallet, they didn't take anything else, only the vehicle.
And what kind of car was it?
This is a 2017 Dodge Ram. Let me make sure that, yeah, it's a white truck, Judge. And at that point, the vehicle was taken by all 3 subjects. They left that location. Mr. Coleman said he ran to nearby bushes and waited to make sure they were actually gone. He didn't know if they might turn around and come back. He then proceeded to his house, which was a couple blocks away, and called the police from there. He stated he didn't feel comfortable or trust the gas station clerk, and so that's why he didn't call it at the gas station across the street. However, he met police at that gas station and spoke to them and told them exactly what happened. They reviewed the gas station footage, saw that he was in fact there, saw the 3 young men, one wearing a white shirt and red pants as described by Mr. Coleman to the police. That was the defendant, Mr. Hawk. Another was wearing a blue hoodie, and a 3rd subject was there as well. He couldn't describe him. A review of the footage, Judge, shows that he did exit the store and get in his vehicle. There's no camera near the air station, and so we don't have that interaction. But we did get footage of from a beauty supply store across the street where they did meet up. There's no video of the actual robbery, but that would be the testimony of Mr. Coleman were he to take the stand, and we would have the video evidence showing they were all there, and then his report of the events. Judge, that would be The first thing, the vehicle was later found by Covington Police. When it was found unoccupied, there was a red phone in the vehicle. That phone, a search warrant was secured for the phone, which traced it to a Sprint as the carrier. Phone records were secured. One of the most recent numbers dialed around the time of the event was called. That person who picked up the phone was Sierra Ashby. She is the sister of the defendant. Identified the defendant as the one whose phone, it was his phone that the number that was given by Sprint connected to the red phone. She identified that as being her brother's phone. She stated that he told her that he had lost the phone, but they showed her a picture of his brother from the video surveillance of her brother from the video surveillance, and she identified him from the BP gas footage as well. That was the basis. Warrants were taken out. He was arrested by South Fulton Police in August of 2021 around 10 a.m. And that's the basis for the plea today, Judge.
So what's behind theft by taking versus carjacking? There's some pretty good police work and some less good perp work by Mr. Hawk leaving his phone in the truck.
Yeah, Judge, there's no direct footage of the actual theft occurring using a gun, which is why those counts were no pros, but also.
Well, why else would Mr. Coleman have given up his truck? 3-on-1? I mean, is that?
Judge, that because there's no footage, we can't say for sure. We can only go off his testimony, but the state would foresee possibly some credibility issues. There's some footage of additional interactions that occurred.
Okay, it's more complicated than exactly what you shared with me.
Yes, Judge.
Okay, that's helpful to understand. Does Mr. Coleman know of this proposed resolution?
We have attempted to reach out to Mr. Coleman, but we've been unsuccessful.
Okay, an additional complication for the state.
Yes, Judge.
Any restitution?
Not requested by Mr. Coleman when we were initially talking to him and able to contact him, Judge.
And you're not opposing first offender for Mr. Hawk?
Correct, Judge.
Any idea who the other people were, other young men?
The police were not able to identify them, Judge.
They didn't leave their phones in Mr. Coleman's truck?
They did not.
All right. So one second, I'm going to ask a couple questions of a few other people, and then Ms. Wood can work through your end of things. Ms. Jackson, it's now afternoon. Good afternoon. How are you?
I'm great. How are you, Judge?
I'm doing well. Thanks for sticking with us through all this. Do you have any criminal history information for Mr. Hawk?
The defendant does not have any prior adult arrests on file.
All right. Thank you. Ms. Wood.
Thank you, Judge. As Mr. Hand stated, there is some things that he did not share in his version that I'm happy to put on the record. When I was reviewing the surveillance footage, there is some prior interactions of the front of the store that show Mr. Coleman with the three guys, and they're appearing very friendly. And so then that happened, and there's a couple of minutes that pass, they're all inside the store, and then they go out, the three guys go to the side, and then Mr. Coleman pulls his vehicle around. My client, Mr. Hawk, maintains he never had a gun, that one of his colleagues was conducting a sale with Mr. Coleman, and so that's why they moved to the side of the gas station to be out of view of the cameras. That would, support the reason as to why Mr. Coleman didn't stick around on scene to call 911.
Yep.
Further, that would be part of our argument at trial. So that was part of our negotiations, that there's these two guys that are still in the wind. Mr. Hawk is 18 years old. He was 17 at the time of this arrest. He lives in Snellville with his mother. He's in the 12th grade, Judge. He starts back online classes soon. So I'm very hopeful that he will finish his degree. And he is currently gainfully employed at Wendy's. He's been there the past 2 months. And so we are looking forward to him putting this behind him. And that's why we are asking for first offender treatment. And Mr. Hawk also wanted me to ask the court to consider suspending probation fees for a period of time, given that he's just recently employed.
Okay. Mr. Hawk, is there anything you want to add, or do you have any questions about anything we've discussed?
No, sir.
How long you been at Wendy's?
For about 3 months now.
Okay, and what's your shift? What's your current shift?
5 p.m. to 1 a.m. in the morning.
When you get back to school, school's going to be virtual, online?
Yes, sir.
Will you still be working?
Yes, sir.
Okay. All right. Well, Mr. Hawk, I find there is a factual basis for your plea to theft by taking. Your phone connects you to the truck, but it sounds like the story is a little more complicated than the initial police report would have suggested. I also find that your plea is knowing and voluntary. Knowing means you've understood everything, and I find that you do because you said you don't have any other questions. And voluntary means that no one's forcing you to enter this plea. It's what you've decided is the right way forward for you. Is that correct?
Yes, sir.
You want to be sentenced as a first offender? Do I understand that?
Yes, sir.
I need to make sure you understand the risks and the benefit of first offender. The main benefit is that this really is not a conviction. So when you go back to, when's your next day of work?
Tomorrow, but tomorrow.
All right. So if you go to work on Friday and your boss were happen to ask, like, hey, Mr. Hawk, are you a convicted felon? The answer would be no, sir, I'm not, or no, ma'am, I'm not. You will be on probation, but you will be what we call a first offender probation. And as long as you do well on probation and successfully complete it, then you will remain with no felony conviction, which will really help with school and work and other things you might want to do other than hang out with those guys in front of that BP station. But there's a risk to first offender. If it doesn't go well over the next few years, you get arrested again and there are new charges. Not only will you have to deal with that new case, but I could, if the state proved up the violation of probation, I could resentence you to this charge, theft by taking, and send you away for up to 20 years. That's the maximum. So even though your sentence right now might be time served, if you mess up this first offender probation, not only can your probation be revoked, but you can be resentenced as a felon. And I get to look at that whole range of 2 to 20 years. I'm not going to give you 20 years if what you get arrested for is shoplifting or something. But if you get arrested for a carjacking again, then you should expect that you'd get revoked for a whole bunch of time and resentenced as a felon on this case. So there is a downside. If you think you are not going to be finding yourself in a situation like this, first offender makes a whole lot of sense, but it does have some risk. Do you feel like you understand the benefits and the risks of first offender?
Yes, sir.
Do you want to be treated as a first offender in this case?
Yes, sir.
Okay, I will do that. And I will sentence you to a term of 4 years to serve 6 months. Those 6 months will be reduced to time served, so you're not going back to jail. I'm giving you a little more probation because first offender, that opportunity you're getting, I'm gonna want you to demonstrate a little bit longer because you're pretty young, that maybe you've gotten out of that lane you were moving in. And we'll see how that goes. It will be a special condition of your probation, Mr. Hawk, that in the next 12 months, you either get your GED or a high school degree. Whichever one, you're doing this online stuff, but you've got 12 months to get that high school degree or GED. And while you're on probation, you need to be working. How many hours a week do you get right now with Wendy's?
40.
40? Okay. You'll need to be working at least 20 hours a week. And if you are not for 2 consecutive weeks, then you will need to do 10 hours of community service for any following week that you're not working. So I want you to focus on working at least 20 hours a week. If you change jobs or whatever it is, you got 2 weeks to transition. If you are on that 3rd week and you haven't been working, then you'll be doing at least 10 hours of community service for each successive week until you get a job again. Any other conditions of probation you'd want to see, Mr. Hand?
Yes. One second, sorry, Judge. I wanted to.
Oh, and I will waive your probation supervision fees for the first 2 months that you are on probation.
Yes, sir.
Judge, the state requests a stay away at least from the incident location, which is the BP at 6103 Old National.
Do you live near that BP, Mr. Hawk?
No, sir.
Any reason you need to be around there?
No, sir.
All right, then it'll also be a condition of your probation that you are not at the BP at 6103 Old National Highway. Ms. Wood, any questions or other matters in connection with Mr. Hawk?
No, Your Honor.
Mr. Hawk, do you have any questions about the sentence that I imposed?
No, sir.
Okay. Well, I wish you the best of luck with Wendy's and staying out of the way of the folks you were hanging with in June of last year. Ms. Tucson, do you need any information from Mr. Hawk?
I can retrieve it from Ms. Wood, but I just gonna need a phone number to call him.
Sure.
The gentleman, because he said he was in Snellville, so he's gonna have to go to our Gwinnett office to report.
Great.
So I'll call and email his reporting instructions.
Great. Mr. Hawk, what's a good phone number for Ms. Tucson, who's with probation, to call you?
770 912 3803.
770-912-3803.
Yes, sir.
Is there an additional phone number in case?
Any other backup numbers?
No, sir.
That's it. Hope that works. So Mr. Hawk, Ms. Tucson will be calling you soon. It'll be this afternoon. Make sure you take the call and she'll let you know how and where to show up for probation, okay?
Yes, sir.
All right, I think that's it. Thank you, everyone.
Thank you, Judge. Bye, Mr. Hawk.
Thank you.
Oh, wait, one more thing. Yes, dang, how do you remember that? Two more things. One, I'm sentencing you pursuant to the Probation Options Management Act. And what that means, Mr. Hawk, is that while you're on probation, if you have a small violation, we call them technical violations, like maybe you miss one meeting, not a lot of meetings, but one. If you miss something like that, you and probation will work through it. If it's more serious, you get arrested again, you didn't get your GED, something like that, that comes back to me. Second thing, do you authorize my staff, Mr. Hawk, to sign your indictment indicating your first offender plea?
Yes, sir.
Ms. Wood?
Yes, Judge.
And Mr. Hand?
Yes, Judge.
Excellent. Done. Now you can go.
Thank you.
Bet.
Since I'm here, I'm just gonna say hello.
Hey, how are you?
Ms. Wood.
Hey, how are you?
How's everybody doing?
Good to see
We're
you.
doing great. What brings you by?
I just need to drop some petition off with
Ms. Tucson? Excellent. It's good seeing you. You surviving your assignment?
Yeah.
Good.
I have vet court, Adams, and all the repeat offender stuff. So. No, always fun.
Good to see you.
Good to see everyone get a job.
You too. All right, we have one more piece of business to take care of, I believe, before we break for lunch. And that would be Ms. Saxon. Come on up, please.
She is also from the trial calendar.
Yes, she is. Got my little list for the week after Thanksgiving, and Hawk just came off. Hawk. We'll see if Saxon comes off. So Duncan, that's Ms. Feely. Jones is still looking like it's going to work out.
Yes, Judge. I believe he's still on bed rest.
Oh, right.
Yeah.
Okay. TBD. All right. Okay. Let me write one thing down here. There it is. All right, Mr. Hand, are you ready?
Yes, Judge.
Ms. Wood?
Ready, Judge.
Okay. This is position 12 from our trial calendar, 21 SC 179333, State versus Ms. Saxon. Ms. Saxon is here in court with her lawyer, Ms. Wood. We have Mr. Hand here in court. Ms. Saxon, good afternoon.
Good afternoon, sir.
How are you doing?
I'm okay.
Good. Thanks for your patience. You've been here all day. It is time now for your plea. Ms. Wood tells me you're prepared to enter a plea. You've just seen the process with Mr. Hawk virtually. Mr. Hand is going to put you under oath in just a moment. Make sure you answer all of his questions and mine truthfully and completely. And also, please let us know if you have any questions of your own. If someone says something that you can't hear or you don't understand, or this just isn't going the way Ms. Wood told you it was going to go and you want to pause, let me know. You, Ms. Wood, can talk or I can answer your question, whatever will help, okay?
Yes, sir.
All right, Mr. Hand.
Thank you, Judge. Judge, I'll let you know from the outset, the downgrades, counts 1, 2, and 3 will each be downgraded to disorderly conduct, OCJ 16, 11, 39. And count 4 will be no prosecution.
All right, so 3 misdemeanors.
Yes, Judge.
Got it.
All right. Ms. Saxon, if you can for me, raise your right hand. Do you swear or affirm that the statements that you're about to give the court are the truth, the whole truth, and nothing but the truth?
Yes.
Okay, lower your hand for me. Please state your true and correct name for the court.
Kimberly Andrea Saxon.
And Ms. Saxon, are you currently taking any medicine or under the influence of any drugs or alcohol?
No.
Are there any medication that you would normally take today that you have not taken or been given?
No.
And how old are you, Ms. Saxon?
46.
And how far have you gone in school?
College graduate.
And can you read, write, and understand the English language?
Yes.
You understand that you have been charged with the following offenses. That's 3 counts of disorderly conduct, misdemeanor charges, and that would be for indictment 21 SC 179333.
Yes, sir, that's correct.
You understand that you have the right to plead guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty, remain silent, or refuse to enter a plea at all, that the state is required to prove these charges against you at a jury trial?
Yes.
Have you had an opportunity to review your rights with your attorney today?
Yes, sir.
Have you had enough time to speak with your lawyer about the indictment and the charges you're facing today, including any facts and circumstances regarding those charges?
Yes.
Do you need more time to speak with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Okay. Attorney Wood, do you waive a formal reading of the indictment for purposes of today's plea?
So waived.
Do you waive any and all defects in the indictment for purposes of today's plea as well?
So waived.
Justice Sage is unaware of any outstanding warrants related to these charges as well.
Okay.
Ms. Saxon, are you aware that the minimum and maximum sentence for each charge to which you're pleading guilty today are 1 day to 12 months imprisonment?
Yes.
And do you understand that you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? That is for count 1, 12 months probation, count 2, 12 months probation consecutive to count 1, and then count 3, 12 months probation consecutive as well to counts 1 and 2, and then we're not prosecuting count 4.
Yes.
So 36 months probation.
Yes, Judge. Additional conditions would be, Judge and Ms. Saxon, 300 hours of community service and an anger management course. Is that your understanding of the recommended sentence? Okay. Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge today?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutive, which means one after the other?
Yes.
Do you understand that if the court decides to enter a sentence that differs from the negotiated plea that you're expecting today, that you have the right to withdraw your plea of guilty?
Yes, sir.
Do you understand that if you are placed on probation or parole, that you may not violate any criminal laws of any governmental unit, which include municipal, county, state, or federal?
Yes.
And do you understand that if you're placed on probation, you must follow any and all special conditions of that probation?
Yes.
Do you understand that if you fail to follow any of the special conditions of that probation, then you will be subject to revocation of the probation for the balance of your sentence?
Yes.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that if you are currently on probation or parole, separate from this matter, that that probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Are you a United States citizen, Ms. Saxon?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? Those are a right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if convicted of these charges at a jury trial.
Yes, sir.
Is it your decision to waive these rights, which means to not use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No.
Is it your decision to enter into a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of 3 counts of disorderly conduct in indictment 21 SC 179333?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of this guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, sir.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file this habeas corpus petition?
Yes.
Okay. And at this time, Judge Estate will give a factual basis for the plea today.
Okay.
Were this to proceed to trial, Judge Estate would show that on March 10th, 2021, APD officers responded to a call for a dispute in progress in an apartment complex. Upon arrival, the officers met with 3 individuals. All of them were victims, Judge. One, Miss Amanda James, the second one, Miss Joanna Rodriguez, and the third being Mr. Marcus Walk. Miss Amanda James made the phone call. At the time, she explained to officers that she was in her apartment, which is across from the defendant's apartment, with Miss Rodriguez. So I'll just call them Miss James and Miss Rodriguez. They were in their apartment together. Miss Rodriguez came to her apartment because her unit is close by the defendant's unit. And at the time, the defendant was screaming and yelling outside her unit about different things. She didn't know what was going on, so she didn't feel safe going to her unit. So she went to Miss James's unit. Miss James looked out her window and saw the defendant throwing things on people's cars, on ammonia as well, on the porch. There's some ongoing dispute about keeping the area clean between their apartments. And that's why she was throwing the ammonia, presumably to clean the ground. But it was splashing all over property that was even outside Miss Rodriguez's apartment. Miss James told her, hey, you need to go see what's going on with your unit. She's causing a disturbance. Miss Rodriguez didn't want to go by herself, so Miss James accompanied her. She went toward her unit, and at that time, the defendant, Miss Saxon, came out of her unit yelling. Miss Rodriguez said that she thought that Miss Saxon stated that she had knocked on her door, and that's why she was yelling her at that moment. Miss Rodriguez said she had not. She had been at Miss James's. At some point, Miss Rodriguez turns around, and Miss James alerts her that Miss Saxon had gone back into the apartment and come out with a gun. It is an older AK-47 gun, and pointed it at Miss Rodriguez, Miss James, as well as Mr. Marcus Walk.
And where did he pop up from? I haven't heard his name other than
Marcus Walk. So he was standing near the base of the apartment.
Okay. He doesn't live with Miss James or Ms. Rodriguez.
He does not.
He just was there.
He just happened to be standing.
Okay.
And I believe the defense in the state would agree that there were multiple folks standing outside the unit. So he just happened to be one of the ones standing there. When he saw the AK-47, he then pulled out a gun that he had and pointed it back at Miss Saxon, telling her, if she shoot, one, to put her gun away, but two, if she shoots, he'll have to shoot as well. At that time, Miss Saxon's husband then brustles the gun away from Miss Saxon pulls her into the apartment, and that's where the gun was left. And so the police, upon hearing this, then separate the parties. The officers separate. They talk to the victims and Miss Saxon separately. They also talk to the husband. The state would anticipate that the defense would state that Miss Saxon saw a gun pointed at her from some unknown individual in the crowd of folks outside her apartment. She felt threatened. She went into her unit and then grabbed the AK-47, which I believe belongs to her husband from his, I believe, military service. It appeared to be a military type weapon. And that's why she came outside. Of course, she retreated and then came back with the gun. And the state believes that at a minimum, we would be able to show that there wouldn't be any sort of self-defense. However, the parties did discuss and reach the agreement for disorderly conduct at a minimum, which would be violent/tumultuous behavior by Ms. Saxon at the time. Since then, Mr. Marcus Walk has stated that he and the defendant have discussed this issue. He no longer wishes to move forward. The other two victims are not in that boat. However,
meaning they do want to move forward.
Yes. And so police obtained consent to remove the weapon from the household. It was taken, and that's a factual basis for the plea judge. And she was apprehended on scene.
Got it. Ms. Jackson, I've got a recidivist notice that tells me that Ms. Saxon has some forgery convictions from long ago, early 2000s, 2 out of Clayton, 1 out of Fulton. What do you have in terms of cycles in, say, the last 5 years for Ms. Saxon?
I'm sorry, Your Honor, I did not break it down that way.
Okay. No, well, you can tell me the total number of cycles. I just didn't need you to go, if you were going to specify any that were more than 5 years old. So you tell me how you broke it down, which is always helpful, and then we'll go from there.
Okay, they're all older than 5 years old. She has a total of 31 cycles. She's a multi-state offender. There are like 28 out of Georgia, 1 out of Florida, 1 out of Delaware, and 1 out of North Carolina. The last arrest was in June the 17th, 2009, out of Gwinnett County for driving while license suspended or revoked. You are correct. She does have felony convictions. 1 in 2007 out of Clayton County, 2 counts of forgery in the first degree. There was 1 in 2002 for forgery in the first degree, and 1 in 2001 out of Clayton for forgery in the first degree. There's 1 in 2001 out of North Carolina for obtained property under false pretense. And the defendant did receive first offender treatment in 1998 out of Douglas County for theft of services. That case was sealed June the 8th, 2019. Nothing in addition.
Thank you. Ms. Tucson, is Ms. Saxon on active probation in Georgia? Okay. All right. No? Okay.
As the older cases she did.
Sure. Got it. All right. Thank you both. Ms. Wood, help me understand what was going on here and what kind of support Ms. Saxon is getting so that this happens not again.
Thank you, Judge. As Mr. Hand stated, we would, if this proceeded to trial, we would be raising a self-defense argument. After reviewing the body cameras and all the discovery and speaking with Ms. Saxon, it does appear, Ms. Rodriguez, the neighbor below.
Yes.
Is that correct? Okay. There was a long-standing disagreement between Ms. Saxon and Ms. Rodriguez over the shared space. The apartment setup was that 4 apartments shared the common entranceway. There's a lovely note from Ms. Rodriguez's door towards Ms. Saxon to not knock here or come over, or you're subject to attack, injury, or possible death. Ms. Saxon is someone who likes for the place to be orderly and clean, and she felt that Ms. Rodriguez was not respecting the shared common space. I believe Ms. Rodriguez said in the body camera that
Ms. Saxon had a tendency to come off as a bit bossy judge. So there was a longstanding feud between the two. As Mr. Hand stated, the day of the incident, there was a lot of people out and about in the parking lot. It is Ms. Saxon's position that when the gentleman who is unnamed came up with the gun, that's the only reason she went upstairs to get her gun, because she did feel threatened. And as he said, it was an older gun. One of the officers on the body camera even refers to it as a Tommy gun. I am no gun enthusiast, but I did do a little bit of Google search, and it appears a Tommy gun is from the World War I era, Judge. You can see on the body camera that it is got like a wooden base, it had rust on it. So while that would still be an aggravated assault, I did want to put that out there, because when you say AK-47 or AR-15 or whatever, it sounds really intimidating. And so I just want to let the court know that it was an older weapon. Ms. Saxon and her husband, who is present here in support, by the way, since they moved almost immediately after that, within the next few months. So there's no issue with her being in that area. She actually doesn't even live in that county, or it's Fulton County. So she lives in Cobb County now. Otherwise, she has 4 children. 2 are grown, 26 and 24. She has 2 younger children, ages 7 and 4. She just is a recent graduate from Georgia State. She graduated with a degree in managerial science. She's looking to continue her education, and yeah, this is an unfortunate event that she's ready to put past her. And we would ask, Judge, that you would consider suspending the probation after a period of compliance, as you see fit.
Okay. Where was this apartment complex? And do we have a name for the apartment complex?
Hidden Pines.
Yes. Can I speak, Your Honor?
Yes, you're the next person I'm going to reach out to. So, Ms. Saxon, you are free to add anything you want that you think would be helpful for me to hear.
Okay.
And if you have any questions about anything that was said, now is a good time to ask them.
Okay, thank you, Haru. Your Honor, me and my husband lost his job with MARTA, and once the COVID started, everyone had to downsize. So we lost one home. We had to transfer to another place, a smaller place, the apartments, Hidden Pines on Martin Luther King. We thought that the area was regentrified, but it was not. So I was paying market rate. We're talking $1,200 a month. Rodriguez and all of the other people in the building were paying $75, $200. They were Section 8 tenants. Me and my husband did not know this when we moved in. We were there for maybe about 3 months in the building by ourselves. We moved because it was a brand new establishment. They started moving tenants in. It got really bad. Me and my husband, we went up. We have nice cars. We have nice clothes. We talk articulate. We had no idea that we were going to be around poverty-stricken people. We asked the leasing office, why are they paying this amount and we're paying this amount? Because we're going to work every day. We appreciate our things. They're smoking, playing music, drinking. This has gone on forever. I wanted to crank up the jewelry. I have to be honest. I'm a truth speaker. When I was young, I didn't grow up with my parents. I was a little hot girl. I grew up on this side of town. I know how these people are. And yes, I've had my run-in with the law in the 20s. I had a judge. I told him I would never get in trouble again. I would go to school, get my life together. And that's what I did. And then we had this bump in the road with the people who are supposed to be locked up didn't get locked up. Marcus owns a real AK-47. Miss Rodriguez, she was a problem, and we had our tits and tats. But that particular day, me and my husband were into it about the kids dropping apple juice in my car. I went upstairs, I got my ammonia bottle because that's what I clean with. I sprayed and a little bit got on her car. The neighbor, her friend, ran over there. She sprayed bleach on your car. It was just an accident. I ran upstairs, got paper towels for her, and she just went off on me. I went in the house. Next thing I know, I had a mob, Mr. Prosecutor and Your Honor, in my front door. My husband went outside to try to handle the situation. But in the heat of the moment, I see guns because this is the area that I live in, Martin Luther King. We've called the police several times about Marcus shooting his AK off in the middle of the night. Nobody did anything. But that particular day, yes, I felt threatened. I thought they were going to hurt me and my kids. It was a lot of people out there. You hear me? A lot of people, all of them had guns. I went and grabbed my husband's gun. I'm tiny. We keep it on the top counter. I climbed up, I grabbed it, I walked out my front door, and they scattered like roaches. That's literally what happened. And I went back in the house, I called the police, my neighbor called the police, but everybody ganged up on me. I'm the girl that goes to school every day. I go to Georgia State. She sits at home and watches TV. Of course, it's going to be a conflict. I understand that I need anger management because when you get mad, you can't go grab a gun. And I'm in my 40s. I'm almost 50 years old. I've gotten to argue with plenty of people. I've never went and grabbed a gun. So this situation is like a lot for me and my family to go from a state prison in Georgia to get out, to not get in any trouble, to make it to Georgia State, paying that tuition. Like, I didn't have anybody to support me. I've been married for 6 years now. My husband has supported me. He said that he would work. He's a commercial realtor while I finish school and go to law school. When I was in my 20s, I had a public defender like Lacey Wood. I promised her that one day I would work in the public defender's office as well. So honestly, I really want to crank the jury up because I just feel like 300 hours of probation, all of this punishment, and the real culprits are still walking around. Well, 2 of them are dead. You know, they're dead. They're not even there anymore. And I feel like I'm getting the bulk of the punishment. Do I deserve it? Yes, because somebody could have got killed. But honestly, I was trying to scare their asses. I was trying to scare them because every single day they were threatening me with their guns and what they were going to do to me and my family.
It sounds like it's good you guys moved out. When were you able to move out?
I think it happened in March. We closed on our home in August. That was my birthday present. And then we finally moved in October. And we're still there. Kennesaw is totally different from Martin Luther King. I mean, we've always lived in nice places. I'm from Southwest Atlanta. I grew up on Cascade. That's a nice area. But if you go a couple of blocks, it's just like the people that we've been listening to all day.
So now you're in Kennesaw.
I've been in Kennesaw. October would make a year. Yes.
Great. Okay. So over a year. And you just finished undergrad. Are you going to work for a while or are you going straight to law school?
I am practicing the LSAT. I got a little cocky when I graduated, I'm going to be honest. But those questions and that test is a little hard. So we're paying for me to take classes and hopefully, because you can only start law in the fall. So hopefully this August, I'll be at GSU Law.
And your husband, who was at MARTA, is now a commercial realtor, or he was also a commercial realtor for MARTA?
He worked at MARTA, but he's always done real estate part-time. But they weren't paying him anything. And I told him, you let me do my dreams, you do yours. And he's doing great in the real estate business. If you would like him to come up and speak, because he was there.
I'm just glad that he's doing well and is able to support you as you take your LSAT classes and then go to GSU for law school. There are plenty of judges here who went to GSU for law school. It's a great opportunity. And I hope that's something that you pursue. And it sounds like you have turned some important corners in your life, just seeing what was going on in your life around the 2000s.
Yes.
You were doing very different things than you are now.
Yes, sir.
So I appreciate you sharing all that. So you don't have any reason you need to be around. No, it sounds like, would you want to be around the Hidden Pines apartment complex on MLK?
I mean, to tear it down and build new construction, that would be about it.
Okay. Well, that would be more commercial real estate than law. So we'll leave that to your husband and his colleagues. Do you have any questions about anything? I appreciate you sharing with me and sort of getting off your shoulders your version. And I'm sure had I been there, I would have seen something slightly different from what you described and what Mr. Hand described, because each person is going to perceive it differently and feel it differently. And the threats you felt may have someone else thinking, well, I'm defending myself. And it was volatile. And I'm glad that when people scattered, it was a scattering as opposed to a shooting, because I get to hear too many cases where someone walks out with a gun in an effort to defuse, someone else sees that gun, and then the shooting starts. And then we're not talking about misdemeanors or community service. We're talking about, we'll see it in 20 years or 30 years. And that's not what happened here. It sounds like you are interested in having nothing like this ever come up again, which is good. That's where the anger management can come in.
I would never want to come in here, but to say hi to you.
Hey, to have me swear you in.
Yes, it's a scary place.
When you finish law school, you got to be sworn in. And that's one of the happy things that we get to do here in Superior Court. So maybe in a few years, we'll be doing that.
Yes.
Do you have any other questions?
No, thank
Okay.
you for allowing me to speak.
I'm happy to hear from you. Ms. Saxon, I find that there's a factual basis for your plea. That doesn't mean that I'm saying, what Mr. Hand said is exactly how it went down. As I said, it's got to be somewhere in between. And of all the people in the room, you and your husband were the only two there. So you're in the best position to say, here's what happened. But as I explained, you saw it through your lens of feeling like people were mobbing up on your front door. And your perception was, I accidentally got the ammonia on the other person's car. Someone else may have felt that that was purposeful because of all the back and forth there had been. And frankly, I don't need to resolve that, because what you're charged with now is disorderly conduct. And to your point, probably everyone could have been cited for disorderly conduct that afternoon, to include you. And here you stand. And it may have been because you had the biggest gun or who knows what. But I do find there's a factual basis. I also find that your plea is knowing and voluntary. Knowing means you understand what we've been talking about. And that is clear to me. You are smart, and you understand the things we've talked about. If you have any questions, you've asked them of Ms. Wood in advance. Anything else you want to ask about?
No, sir.
Okay. And voluntary means not that you're excited to be here, but that you've decided to pursue this reduced misdemeanor plea because you've decided that's the best way to resolve the situation you found yourself in after you've had a chance to consult with Ms. Wood, your husband, and anyone else you wanted to talk to. Is that also a fair statement?
That's fair.
Okay. Then I'll accept your plea and I will follow the recommendation. And so it will be 12 months probation, 12 after 12 after 12, so 36 total. You will need to, most importantly, complete an anger management course. You can find one. If you don't know where to find one, probation can help you find one. They may not be the ones who offer it, but they'll have a roster of courses that you could take. You need to take one of the anger management courses. It will be a special condition of your probation that you have no guns in your house during the course of this probation. So if there are any now, whether it's that big old Tommy gun or something else, they're going to need to not be in your house while you're on probation. You'll need to stay away from the Hidden Pines apartment complex on MLK. Don't show up with a wrecking ball. Don't show up with a contract because you made enough money as a lawyer, you're going to buy the whole thing. You need to stay away from Hidden Pines while you're on this probation. And you'll also need to complete, I'm going to make it 200 hours of community service. You don't have to do that day one or month one or anything like that. But the sooner you complete that, the sooner you'll be in a position to talk with Ms. Wood to say, look, I've done it with anger management. I'm in law school now. I've finished and that's not a requirement that you be in law school, but it's where you're going. And I finished my community service. Could we make this non-reporting or reduce the level of supervision? I'm very open to that. If in fact, what I hear from misdemeanor probation is that you've done all those things, I'll be very receptive to doing something like that. That's the sentence that I am going to impose based on all the things I've heard. The last thing I've got, and then I'll see if anyone else has anything else. Ms. Saxon, do you authorize my staff to electronically sign your name to the indictment indicating your plea to the misdemeanors?
Yes, sir.
Ms. Wood?
Yes, Judge.
And Mr. Hand?
Yes, Judge.
Mr. Hand, anything else in connection with Ms. Saxon's case?
Not from the state, Judge.
Ms. Wood?
No, Your Honor.
Ms. Saxon, you will get a call or an email or something either from Ms. Wood or directly from misdemeanor probation. That's a different group than Ms. Tucson works with felony probation, which is actually a big state agency and they're statewide. And Ms. Tucson could say, well, if you live in Cobb County now, here's where you report, is different for misdemeanor probation. So we will have misdemeanor probation contact you.
Okay.
Either Ms. Wood or you, and you'll need to connect with them. Don't play hard to find or hard to get because they'll reach out to me saying, we can't reach Ms. Saxon. She's not returning our call, and you'll be starting out in the wrong way. So connect with them. They'll let you know the steps you need to take. And if you've got any questions or concerns about that, reach out to Ms. Wood. Okay.
Okay.
All right. Ms. Saxon doesn't need to stay for misdemeanor probation. They don't do that anymore. Not today. Okay. Then you're free to go.
Thank you so much. I'll
bet.
see you again.
Good. You'll know where to find me. 8D.
Yes, sir.
All right. Good luck with everything.
Thank you so much. Okay.
All right. We are going to be on break until 2. At 2, we have, where are all my calendars? Motion, Ms. Feely, I guess Ms. Feely was here.
Still here.
That's fine. She's got motions at 2 with Mr. Shapiro. And then at 3 today, we've got bond hearings, but those are not public defender cases. So I think you may be done, Ms. Wood. All right. Thanks for those, please. I didn't get rid of it yet. Reminder, still standing for our November 28th actual trial time. For you, Ms. Wood, is Duncan. That's with Mr. Whitenauer.
Judge, that's diversion. I don't know what requirements as far as paperwork the court needs other than what I sent Ms. Nelson.
I sign an order that puts it on judicial hold and gives Ms. Nelson a tickler because it's diversion for 10 days, 1 month, however long it is. But that order I sign spells out the requirements of diversion and is basically put this on judicial hold. I've not signed that. If I had, it would be marked down on here. So Duncan, until that's signed. And then way down at the bottom, Mr. Ford, who I think called your offer ridiculous, or may even have been something I can't repeat on here. So my list tracks with yours. So there's still Mr. Ford. Got it. Okay. Super. Thanks for your help today.
We are going to take a free Tuesday. Is the day next week open?
Okay, thank you.
Okay. I'm presiding next week. I'm around. It's whatever she says. I'll be here anyway with this guy. All right. I'll get out of here. Thanks.
Are you covering for Mr. White now?
Yeah.
Okay.
You can hold on to those because I got the only thing I wanted was the paper that we heard that thing. So you hold on to that because that's losable, the little thumb drive.
Yeah.
But I've got a copy of the that Fourth Amendment waiver. So I'm good. Thank you.
Do I need to draft an order?
Well, essentially, normally it comes from DA.
I thought so.
So usually those.
What happened? Why you're all glad?
Did she send you the actual term?
Morris?
ADA White.
All right.
So whatever the terms are, he
right.
puts them in a proposed order,
Okay.
gives to the judge, they enter it. And I think you have like 48 hours from the entry of it to contact and see.
So do you want me to just ask him or?
Yeah.
Okay. I'll do that.
I mean, he's still online. I think he's sick, but
Okay,
he's
that's
still
fine.
online.
I will email him.
And if he can't, trust me, he'll forward it right. to
Okay,
you.
perfect.
He'll
Thank
definitely
you.
do it, yeah.
You trying to get out of going to trial, Mr. Ham, next week?
Huh?
You trying to get out of going to trial?
Why you say that? Why do you?
You getting rid of some cases.
Yeah.
That's
Trying to clean a little bit of.
You're doing a great job, both you guys. Everyone.
Thank you.
Excellent.
Trying to move some stuff along.
Yeah. Trying to make sure Miss Wood can enjoy her vacation. Mhm.
Yes.
Right, but let me know if Coleman changes his mind. I'd be happy if he did, but he, the witnesses also came in again yesterday and did the whole thing, so
Okay.
we'll see if they have to go. Because they're very, one is really traumatized by it.
Okay.
And so,
I understand.
yeah, but it's gonna be interesting to see how it gets received because, as you know, the facts are quite interesting.
So many questions.
Yeah.
No, absolutely. Okay.
Yeah. Oh, I need to give you, oh, Lord, I'm sorry. So yesterday when they came as well, they gave me screenshots of text messages.
Okay.
Before, I need to give you those.
Just send it to me.
Okay.
If you, do you have it like digital?
Yeah, I
Okay.
do. Yeah, they,
Yeah.
well, yeah, I do. They emailed it to me, so
Okay.
I'll turn it over.
Thank you.
See you.
Have a good one.
Uh-huh.
Close, families that may have closed. I'm getting ready to clean up our free call.
Our investigator to see if there's anything.
Okay.
Yes,
No,
I
we were in here yesterday, I'm like, they're getting ready to go to the free club.
Yeah,
Because
no, I
they've been here a while.
They've probably been sitting there for who knows how long. Okay, I will find out. Thank you.
Apartment complex.
For Saxon, it's hidden place.
Is it Hidden Pines?
Oh, hidden, yes, I'm sorry.
Okay.
That is what it is.
You kept saying Hidden Pines and my subdivision where I live is Hidden Pines, but not there.
Yeah, no, okay, yes, it's hidden pines.
You said at the Martin Luther King Drive location.
Yes, let me just double check. So it looks like it's off of MLK and it's, the actual address is 2315 Cushman, so C-U-S-H.
What is C-U-S-H?
Yeah, I was bringing it up here. I hope I'm saying, right.
C-U-S-H.
M-A-N,
Circle.
yes, 30311. Yes.
Thank you.
Thank you.
Oh, did you please go through?
Somehow, somehow. What do you have left?
I just have a 2 o'clock. I think. Little Shapiro's. No.
A little bit of left too.
I was just in the jury room kicking it with Marilyn for like an hour.
Yeah. Oh, that's a
There's the
thought.
really.
I don't have anything.
There's
You
plenty
can
of
put
bagels
away.
in
He
there.
sent me a picture of his plate. And I'm like, yeah.
I certainly am.
Yeah,
Yeah, I would.
I told him I stopped eating all of that. He was like, I couldn't resist. You guys, you see, you don't need me with him. I don't, you are right. 'Cause this
Yeah,
dude.
it has like
he's
frosting.
putting it away.
Oh.
I was like, how many sides did you make?
There's one knife that we've been using for everything. All right, I'm coming too. Yeah, if you're gonna do it.
Oh, does he really? That's what he said. He was pretty good, vending machines. Why don't he just go to the grocery store and buy snacks and have them at work?
I've done it before.
That's Dwayne, like he is a snacker the whole road trip. We take a bunch of bags of snacks. We still stop at the gas station, he will still go buy something else. I'm like, you have every candy bar, like, what is it?
It's just the road trip. It's exciting.
Yeah. And sent me 2 RVs today. It's coming soon. It is. Set my donut the correct way. Yeah, I guess I'm glad I saved mine. I told you. It's not such a bad day after all.
Just working away. Yes.
We're discussing cases about it. So we're definitely going to trial on the 12th. So. They are. We are. You see how long their trial calendar is? There's no way.
It's like 7 cases, isn't it?
On the 12th? Seemed a few pages today.
Well, look at you. No, I don't have a 12 with me because look at how much we're doing.
We still have a while left on there.
Look. This one's gonna go with that one. That's the guy that had a heart attack. That's gonna go to the version. So this one is the one that's only at least that was only.
Yeah.
Calling, so they got.
Miss Wood thinks that she might be one.
No, I don't know.
I don't know.
This is on the 20th, so that's after Thanksgiving. So that's gonna be free, that's gonna be free, that's the version. This is subpro, so that's being.
Yeah.
Come. It's called.
That's an aggravated assault, I think. Yeah.
You think that one's gonna be? Coleman. Is that against the woman? The one. Or.
He was ready to hear my guys. He was about to throw the fuck on him. Something about Atkins. Yeah. Oh, he got off. She said, I just knew that was gonna be a guilty verdict. Said he had the angels camped around him. Sure, yes. This might be going out on Kona after Thanksgiving. When these people come up here, see, this is the problem. All these people are out on bond. So they don't want to go. They don't want to go into custody. Well, they're going to have their Thanksgiving and somebody will go into custody. I'm gonna go into custody and eat this donut. I know. I'm gonna do some popcorn. I'll make some popcorn. Something. Do you think the judge said it as the judge was saying the plot thickens? I was saying it in my head. The plot thickens, you were saying it at the same time. So can they prove that they're lying? Juvenile. They have to juvenile. And you know, said it was only like, yeah, to Adam, said the juvenile saying that the defense.
I think we'll be now. I'm at 480. Can you get me voice? Hey, man, what's up, man? Me and Dean hit that motherfucker down at the same time. I'm gonna be on the I can do it, well, he started to ease up a little bit. Very good, perfect. Oh, what?
Kids, and I was saying that in my head. We had that little piece of information.
My wife was on the phone.
Okay, so the whole face of life.
We tell me, man, we went up to the guy. I got to put some that night sheet. We
He's just buying up time.
Four people, we got tickets for him, his wife, his son, and his son's girlfriend. The son's girlfriend, he called me after my wife. Yeah, we go. Hey, big look. That's what you get doing. What am I doing? I asked for some money. Why can't I just have move? Just hold on, man. Okay. I've been holding on 6 months now.
Yes.
Y'all bring us lunch back, right?
We're not gonna get lunch.
Yes, you are.
Wi-Fi radio. Jimmy 26.
How you doing? Let me go look at farmers real quick.
9-4.
Football match.
I'm just gonna hang around and walk around.
I feel so bad because
I love that you brought this, by the way. I always forget.
It's in my bag. That's why it's in my dirty.
They used to have a cute little case to carry mine around with.
It's 4:13 is the back. Have I today?
Like today?
No, I saw him like 2 days ago.
Oh, do you know if are any of these closed hours? Do you know? Hi.
Hi, how's it going?
Good, how are you?
Good.
I think we got all our hours out there, but she said that she's not to clean it up.
Okay, yeah, because our last one was Atkins and Reginald picked up Atkins.
That's what I thought. And yeah, Brian was on those.
Yeah.
I don't know who they are.
I've been here all day.
We have, but we have donuts in the jury room. so
Oh,
it's all good.
nice.
There's powdered sugar on my phone. Are you looking at the YouTube?
Yeah, they bring me most of them back.
Where's that? Oh.
Huh? He went up? Yeah, he keeping out. He keeping out. Keeping out. But I just heard that out of my own mouth. I was like, what the? Yeah. No, I didn't know that. I was like, I'm here. So they just had a meeting with the mayor. Yeah, Dean just said that. Yeah. Huh? Thanks, you back you. 28. Yeah, we got 15. Yeah, no shit. I know. Even the one, he said, even the one with break. Bring them back for some type of, I don't know. I don't know. Now, if they in prison already, they don't play in the rain there. For new charges. For new charges? Well, at least I like it, well. Oh my God, this will be so much good when I have one. I want to say the week after, but oh, let me check that. So he's bringing over 20. Bringing. That's going to be good. That's gonna be crazy as hell. Yeah, all the people there, all their family. We know they're gonna show up in droves, shoot. It's gonna have to be done down in, what is it, 1A? 1C. Yeah, with a big courtroom. And that still ain't gonna be big enough. So you're gonna have to use this courtroom too. He's gonna be back and forth. No, they'll put them on, Oh, you're talking about just the tank water? Well, yeah, tank wise. They probably gonna put the family down and see one and put TV in. Yeah. That would be. You can put 20, yeah. But then you got to put hell of security up here. Yeah, it ain't gonna be a lot going on there. I hope there ain't nothing going on there because we're gonna need everybody. They might get some folks from the DA's office. That's it. But then again, you might get it from law enforcement. Well, you know, it'd be everybody in law enforcement.
Everybody will be
Jail,
shut down.
SWAT, fugitive. I told Jackson, I'm not staying. I'm not doing May Devil because I'm here every morning at 7.
I heard they took you up.
Yeah. But Jackson told me, well, no, you ain't off yet. Shit me. So I can see. I'm going home. At 7 o'clock, you somewhere warm. I'm out here freezing.
Cold
man. And then they have to put this shit on too.
You gotta take a picture of it. She will come back and tell us. She know we have none.
This is about the 3rd or 4th time they've done me like this. Who was it? Was it Whaley? I think it was Whaley. I'm sorry, I forgot you ain't had no lunch. At this time.
See, the reason why we forget it was if you don't hear a roll call, then sometimes you don't display it. Yes, sometimes you don't hear a roll call, sometimes you don't be on display.
For me?
Yeah.
Well, I know. Well, yeah.
That's when you forget you sometimes.
Yeah. You know, complaining.
Don't call nobody.
Shit. You know, folk question you, what you doing? I'm working. What you doing? I'm working. In caps.
Girl, big on the 18th with 1 SB 140, in the courtroom 7 up,
What was it?
Mailbox is 05. That'd be one of those lieutenant, David Mathis.
Mathis is stuff.
What you want coming in and making all that noise? Why you coming in here?
I'm here for the 3 o'clock.
I'm just kidding.
I'm early.
Yeah, good solid hours too.
What's up?
Hey, how's it going? You're an attorney?
Okay. This is where I'm in.
Are you in the
I'm
right
used to you being in Kraus.
Do you
and
go
so,
to
like,
school here?
right? Like, right.
How many people got this week? So
Have you been over to see Christian at all?
No, I'm not.
I'll try and stop in there.
Since we're done.
It's from Coleman, by the way.
Yes.
Is it?
Not good.
Okay.
Came on one cup. That's how you feel about us? They got your whole cup to think about it. Nobody much stuff.
What are you here for? 414 motion.
Oh, okay. What time was that calendar?
2.
See, I supposed to left for lunch, whenever they got to you. I need longer
Can
than
you
15
send
minutes.
Google Docs in Gmail? Is it or only to Gmail accounts? I don't know. I keep going.
I never heard the measures of court.
What kind of order, man? See?
One second here. All right. Good afternoon, everyone. So we've got Mr. Tutman's 414 hearing. That's what I'm here for. Mr. Shapiro, that's why you're here?
That's why I'm here, Judge.
Excellent. And Ms. Feely, you ready to go?
Yes,
Anything we should discuss before Mr. Tutman comes out, or are you ready for him?
we're ready.
Let's get him. Miss Wood, was Ms. Saxon, she was saying something about like, show me the, it was jury, not jewelry. Like she was basically saying, I'm ready to go. When it finally clicked, it was like, wait a minute, you're backing out of this. Cause she talked herself up into says like, wait a minute, those roaches. And I'm like, I can't believe how she was talking about, but it, regardless of how that was happening, that's what she was basically saying is that, no, you know what? Now I want a trial.
Judge, I know that she got a little wound up. We went over extensively why this was in her best interest. And so I think she's satisfied. I think Ms. Feely saw her on her way out of the courthouse and she was happy with the outcome.
I think in the end, but when it finally clicked on me, what she was like, show me the jewelry. It wasn't jewelry, it was jury. Like, oh, we're heading in the wrong direction.
So this is going to be a pretty quick little hearing because we talked about the laws not really on our side. Do you want, I know you didn't want to keep it with you at the table. Do you want to read the motion? You're okay?
All right, Ms. Rivers, are you ready? All right, this is case 19 SC 165671, State versus Michael Tutman. Mr. Tutman is here. Good afternoon, sir.
Good afternoon.
He is here with his attorney, Ms. Feely. Mr. Shapiro is here for the state. Who's with you, Mr. Shapiro?
Just me, Judge.
Okay, all right. There's someone sitting at your table.
Yes.
This is serving judge.
Last I checked, not invisible. Okay. The state has filed a notice of intent to introduce evidence pursuant to 404 and 414. We need to have a hearing on what the evidence is that would support that. And I need to hear from both sides about the 403 concerns, if any, about admitting the evidence pursuant to 414. And if somehow it's not 414 and it's 404, I need to hear about the proper purpose for that. Was there anything else you thought we were covering today, Mr. Shapiro?
No, Judge.
Ms. Feely, anything else from your side?
No, Your Honor.
And do you feel that you've got all the discovery in this case?
I believe I do, yes.
Great, because this is a case that we need to get in front of a jury if that's where it's going to end up. Mr. Tutman's been waiting for a while on that. When you're ready, Mr. Shapiro, I'm happy to hear your presentation.
All right, thank you, Judge. So Mr. Tutman's case arises from the alleged molestation of 2 juvenile victims. Mr. Tutman is charged with a number of offenses. He has 13 counts in this indictment. Those include aggravated child molestation, aggravated sodomy, child molestation, enticing a child for indecent purposes, cruelty to children in the 1st and 3rd degrees, sexual battery of a minor, and sodomy. The purpose of the state's 414 motion is that the state seeks to introduce extrinsic evidence of an unrelated sexual assault that occurred against a third-party minor to provide the court with some context for that evidence. The case that's in front of Your Honor deals with 2 juvenile victims and arises from October of 2018, when Miss Siobhan Shelton arrived at the Atlanta Police Department headquarters to report that her 10-year-old son, whose initials are TT, as well as her 13-year-old brother, whose initials are TS, had been sexually assaulted by her cousin, who's the defendant, Mr. Tutman. The children disclosed the abuse to Miss Shelton after testing at Eggleston Children's Hospital revealed that both of the children had somehow contracted syphilis. When Ms. Shelton confronted the 2 victims in this case about that, they disclosed that the defendant, who they knew as Tay-Tay, had anally sodomized them. These acts occurred at 2 separate apartments where the children lived and where the defendant would often visit and spend the night. Both children underwent forensic interviews, which provided some additional details, including that the defendant had engaged in touching of the children's genitals, both over and under their clothing, that he had performed oral sex on the victims, as well as had them perform oral sex upon him, and that he ultimately had
Keep going.
Ultimately engaged in sexual intercourse with both of the victims. So those are the facts of the state's case in chief. The extrinsic.
Before you get to the other act, Mr. Tutman is a cousin of TT and TS, a cousin of Miss Shelton, or I've just made up the cousin part?
A cousin of Miss Shelton.
Okay. And Miss Shelton is the mother of TT and TS.
She is the mother of TT and the older sister of TS.
Okay. TT is her son, TS is her nephew, and Mr. Tutman is her cousin.
TS is her, I'm sorry.
TS would be her son because she's S.
No, I'm sorry. TT is her son.
Okay.
TS is her younger brother.
Younger brother. Yes. Okay. Got it. Not nephew. Cousin of. All right. And at some point, TT and TS were in the same household and apartment. And is your understanding that what is alleged to have occurred to them or been done to them, it was simultaneous, as in they were there together, or they would have been separate over the course of whatever date range is in the indictment?
It's the date range in the indictment, Judge, is March to November of 2018, I believe. And so this would have been several different occurrences over that date range.
Okay.
And for the most part separate, although victim TT did report that, victim TS reported that victim TT did see one of the acts that was performed upon him.
Okay, but their interviews, their forensic interviews weren't, I saw what happened to me also happened to whatever relationship they would have. I guess TS is the uncle of TT. So it would be, I saw Mr. Tutman do this to my nephew, one instance of that, but otherwise they didn't see what allegedly happened to the other. Did I ask that clearly?
Yes.
Okay.
Yes, Judge. So with respect to victim TT's forensic interview, he reported inappropriate touching, but did not actually disclose anything further than the inappropriate touching. However, he did state to the forensic interviewer and to investigators that he felt too scared to really discuss what had occurred. By contrast, victim TS provides a lot of additional details regarding the alleged abuse, including having seen an instance in which the defendant, Mr. Tutman, perpetrated some of the abuse against TT.
Got it. Okay. To the other act.
So the extrinsic evidence that the state seeks to introduce involves a unrelated third party who's also a minor victim. His initials are JH. The case began in July, excuse me. The case began in July 2015 when the victim's mother arrived at the DeKalb Police Department to report that her 9-year-old son, again, whose initials are JH, had been sexually assaulted. A forensic interview was scheduled as part of the DeKalb Police Department's investigation. During that forensic interview, the child disclosed that during a 3-week period in June of 2014, he had been staying at his father's residence in Decatur, Georgia, when he was introduced to a friend of his father's whom he knew only as Tay-Tay. On one occasion, Tay-Tay spent the night at the residence and was sharing a bed with JH. The child alleged in his forensic interview that at some point in the night, Tay-Tay began groping his genitals with his hand. He attempted to force Tay-Tay's hand off of him, but was unable to do so. The child, JH, stated that he felt too embarrassed to report the incident until he made an outcry to his brother and mother in 2015. Following the outcry, JH's mother contacted his father to confront him about the incident. The father identified Tay-Tay, as JH knew him, as the defendant, Michael Tutman. He also provided a photograph to JH's mother. JH's mother in turn showed the photograph to the victim, whom he identified as the person who had molested him. So that is
charges flow from that.
There is an indictment that is pending in DeKalb County. It went into bench warrant status, I believe, in 2016. We have reached out to the DeKalb ADAs to let them know that Mr. Tutman is here in Fulton County. However, when last I checked the status of that case, it was still listed as bench warrant status.
Okay. So they're staying out of our way for now. Okay. And did you say JH had a forensic interview? So that would be part of the evidence, if part of what you might choose to present if this came in.
That's correct, Judge.
Okay. And JH's whereabouts are known to your office now?
They are, Judge.
Okay. And you think it's 414 because the allegations of JH would constitute molestation, which then gets you aligned with the charges in this case.
That's correct, Judge. So obviously, as the court is aware, typically the state can't introduce evidence to show that a defendant has acted in accord with some character trait. However, 414 is significantly more permissive and allows that in any prosecution for the offense of child molestation, such as we have in this case, the state is able to introduce other acts where the accused has committed the offense of child molestation, and that they can be considered for their bearing on any matter that is relevant in the trial. Under that definition of child molestation in 414, that includes any conduct or attempt to engage in any conduct that would constitute child molestation under Georgia's statute. Also any conduct that would constitute enticing a child for indecent purposes. Mr. Tutman is charged in this case with both of those offenses. It also includes any conduct that involves contact between an accused body and the genitals or anus of another child. That obviously would include the allegations for all three of the victims. And then finally, contact between the genitals of the accused and any body part of the child, which would pertain to the allegations that were made by TT and TS. So all of the acts, including the extrinsic evidence, fall under the purview of 414 because they fall under that definition of child molestation. The framers of 414 intended that in instances such as this, where we have a prosecution for child molestation, the presumption is that that evidence is relevant and highly probative, and that it can be introduced again for its bearing on any relevant matter. Like all evidence, 414 is obviously still subject to Rule 403 balancing. That is that the court must make a finding that the probative value is not substantially outweighed by the danger of unfair prejudice. The state's position is that that is not the case here. Again, sexual propensity evidence is considered to be highly probative, and that is why we have rules like 413 and 414, because the framers of those rules believed that the probative value of evidence in cases such as this, there's a presumption that the evidence comes in and is admissible.
And it sounds like here, I know, do you have the John Connor case now, or is that still with Ms. McCauley? Or
no, Judge, it's my case.
Okay, I know in different case, but in that case, one, I don't remember if there's more than one, and all this is on hold while Mr. Connor's working through his health issue. There was a concern raised by the defense, one of the 414s, that we have a kid of a different gender, and we're introducing something that could bring in something controversial to the jury that would be unduly prejudicial because the alleged victims in the case in chief are female, and then all of a sudden there's a male victim, and that could change the dynamic in a way that could be unduly prejudicial. As I understand it here, the gender of the victims is the same across case in chief and the other act, and the allegations that JH would bring to bear, should he testify or it comes into the forensic interview, would be a degree of sexual contact that is less invasive and extensive than what in particular TS would say happened to TS.
That's correct, Judge. However, I think it is important to point out that victim TS describes in his forensic interview that one of the first incidents that occurs with him and the defendant is a very similar contact, that the defendant is essentially sleeping over at the house, sharing a bed with TS, and at some point during the night reaches over and begins groping his genitals. So I think also the similarity of the acts goes beyond even just the fact that they are sexual acts. Some of the sexual acts are very similar in nature.
Point well taken. I was actually focusing on something different, which is just from the 403 perspective. I was looking at it that way. We've got same gendered victims, and the allegations, if believed by the jury, brought by JH are less extensive than TS. And so we don't have a situation where you're trying to bring in 414, he killed the kid. There's a dead body involved, whereas the case in chief is only, in quotes, an act of molestation. So I think that inures to the benefit of the state that it's actually as described, a less severe, and then you've added and it happens to be really, really similar to maybe phase one of what TS will say he endured.
That's correct, Judge.
Okay, I follow that. Ms. Feely.
Thank you, Your Honor. I've read the state's brief. I've read the appropriate statutes, and I understand that this is a rule that is not super defense friendly. However, I will just offer that the state is proceeding by proffer at this hearing, and the similar victim, according to the police report I have, did not actually make an outcry in the forensic interview. Presumably they would be able to come in and testify to that instead, but this is all assuming that they would be able to get that victim to come in and actually say the things that they said apparently to another person, but not during the forensic interview. So we are asking the court to keep this out under 403. That's really, in these types of cases, as the court's well aware, the probative value is substantially outweighed by the huge amount of prejudice that bringing this in is going to bring up for the jury. And we're just here to try to get Mr. Tutman a fair trial. And this is extremely prejudicial to the point that it would be difficult for him to have a fair trial. So we would ask the court to keep it out under 403.
Okay. Thank you. Mr. Shapiro, now I'm a little confused on the other act, JH's situation, he did have a forensic interview or he did not? Oh,
He did, Judge, and as Ms. Feely was making her argument, I was sitting here trying to go back and we requested some additional materials from the DeKalb County Police Department in connection with trying to locate this victim and obviously understand the nature of their case. I know that the initial report was filed with our notice of intent to introduce this evidence. However, there may be additional reports and detectives' notes that I can, of course, provide to Ms. Feely that may clear up the confusion there. However, there was a forensic interview. We've requested a copy of it. We have not yet received it. However, what I do recall from the detective's case file was an anatomical drawing in which the victim, JH, identifies the body part that he alleges that the defendant touched.
And JH was how old at the time?
JH was 9 years old at the time of the offense, Judge.
All right, so he's an adult now. Assuming you can track him down, interactions will be less complicated than if you were working with someone who was now 10 and working through parents. So, okay. Understood. I will take this under advisement. I'll let you know, Mr. Tutman, up front that as your lawyer said, this is not a super defense-friendly statute. It doesn't quite presume that other acts like this could come in at your trial, but it makes it pretty easy for those things to come in. And the case law that has developed around it makes it clear to the judge that it is what they call a rule of inclusion. And so I need to have a real good reason, legal reason, not how I feel about it, but legal reason to keep it out. So I suspect that at your trial, if you go to trial concerning the allegations from TT and TS, the jury would also hear about JH. But given how that evidence would need to come in, i.e. likely testimony from JH, to that point that Ms. Feely made about a proffer, and I'm fine with the proffer now, we would probably need to have a conversation with JH under oath outside the presence of the jury so that we don't risk injecting something into the trial that in the end, the answer is, I don't remember it, or it didn't happen the way that was in the police report. That we'd need to find out in advance. And so whether we can do that before trial, so your opening statement can include those things, just that will be logistics that I'll leave up to the state. Obviously, I need to do my order first, and I'll do that. But I'm just to give you a preview, I sense that's where it will likely go. Let me see if we have a tentative, we don't yet, trial date. So I will get the order out soon. I need to do this one and Mr. Hill, and I guess the one from this morning. But I will try to get Mr. Tutman's case. It doesn't look like it will be on the January calendar because it's not published or anything like that, but Ms. Nelson she is somehow in Odyssey able to make it look like it's going to be on that calendar. And this isn't there, but I'll want it to be soon thereafter. So I need to rule on this first. Mr. Shapiro, anything else in connection with Mr. Tutman that we need to go over right now?
Nothing further from the state, Judge.
All right, Ms. Feely?
No, Your Honor.
All right, Mr. Tutman, I'll get this order out. You and Ms. Feely will talk about it and what's next. And then my goal is to get you on a trial calendar, if not the very first one of next year, the one right after that, so that we can get some closure here, okay? All right. Before you all go, and I don't know if you don't have either of the bond hearings?
Not that I'm aware of.
Okay.
The Pitts hearing is mine, Judge.
Okay, great. So you're here for that. And then D'Anthony Brown, I bet would be, since one of the offenses is affixing materials to windshield that reduce light transmission, probably Mr. Hand. But I want to talk about Mr. Connor, but we need Ms. Feely for that. So we can sit tight. Wasn't it good?
Oh,
Donut Dollies. We'll have to do that. That may need, instead of bringing in cake for birthdays now, we maybe want to bring in Donut Dollies.
no, I don't.
Nobody else.
Ignore the man behind the
Casper.
curtain.
That's right.
Judge, did Christopher Cooter or Getter ever appear?
Nope, bench warrant.
Thank you.
Yep.
I might go back. Okay. If you plan on going home, don't worry about it. I'll take one.
Ms. Feely, Mr. Connor, just wanted to get an update on him. I had a tickler on my calendar to say what's going on. And I know we were waiting on a health update. I have not ruled on the 413, 414. I can and will, but everyone had sort of said, just stop. Let's see. We've been close to maybe even a plea without needing to worry about that. But then things got complicated for him on the health front. Any update?
So I saw him earlier this week. And he is done with treatment as he had told us that was anticipated, and he's going in for another scan, but it actually looks like the treatment worked to the
Fantastic.
exactly. And he actually did look
Better.
clear and better. So I'm still hoping to work this out short of trial, but I think he could be ready to be on a calendar.
Okay.
Off judicial hold.
So, and we don't have to commit to it quite yet, but you think then maybe in a January, like the January calendar seems to be spoken for, but whatever comes after that January calendar, as in trial calendar, put him on that, or are you thinking a different initial destination?
I think we could that would be a good date for trial, but if we can get something worked out sooner, we can add him to a.
Okay. All right. Well, I know what will focus you on that is if he's on a trial calendar. So we'll get him on one. And I don't know how full the January one is. If it's too full, then it'd probably be the February one. Okay, great. Thank you for that update. And that's good news for him. All right. What we've got left are 2 bond hearings. And we can't, no one is late for them yet. They were at 3. I'd love to start early, but we need Mr. Kane, and I don't know if he is appearing virtually or in person. And then Mr. Matthews is handling the other one. So I'm going to go back and do some work. And once we know that Mr. Kane or Mr. Matthews are ready, we'll get going.
Thank you again for breakfast, John.
You're welcome. Thanks for coming.
And Judge, that's
You had a chance. Could have had, did you not get the email? But that's awkward. Let's not talk about it.
is left out of the grouping.
Yeah, no, Ms. Nelson was, I don't know, one of the staff was supposed to push it out to Team McBee, and you are on Team McBee. And you know what? There's actually, particularly if you like donuts, my favorite donuts in all of Atlanta, there are some left if you go through the jury room.
Judge, I
Yeah.
appreciate that.
Yep.
I'm sure she may have emailed me and I might have missed it. So.
Well, then don't go back in the jury room if you blew us up.
You good?
Yeah, it's the one where they found the guy because of his dogs. So. Be okay.
Okay. And Judge, can I be excused?
Yes, sir. Thanks.
Yeah, of course.
Yeah, thanks.
Hey, Mr. Kane.
How are you?
I am well. We can start early once you're ready. I just, my earlier calendar just wrapped up, so I'm not rushing you. We're not on for another 20 minutes. So why don't you chat with him, and then when you guys are ready, I'll just stay right here and sign some things.
All right.
Candy corn. Thank you, went into it going down.
Right.
Hi,
I'm Daniel Kane.
I'm Melissa Roth. Nice to meet you.
Melissa, nice to meet you.
Filling in for ADA John Weidenauer. He'll be the one that's actually assigned to the
Okay.
case, but
Good
I'm
enough.
handling the hearing for today.
Well, I'm glad to know John's on it. I didn't know who was assigned to it.
Yes, sir.
And you are Melissa Roth?
Yes, I am.
How long you been with the office?
I started here, August of last year. But I.
21?
Yeah, but I externed here when I was in law school.
Oh, great. How do you spell John's last name?
Oh, Lord.
We'll look at this. What is it?
WEITNAUER.
N-A.
NA.
UER.
Yeah.
I would have never gotten
I
that.
always have to like really concentrate on it.
Excuse me. So have you had hearings all day, Judge Bernie?
Yep. Been one of those days, but I was out yesterday in another jurisdiction, so we're catching up.
What were you doing?
JQC hearing on a judge.
That's interesting, huh?
It is. It's different. This one was complicated. Sometimes it's real simple. You know, you can't lie, cheat, and steal as a lawyer or a judge. And those are easy. This is one where there were mental health issues involved. And so all sorts of mitigation factors that we need to think about.
Who brought the complaint?
The sheriff of the county.
Yeah.
Because what happened was pretty serious.
And you were on a panel of judges that was considering the evidence.
So the JQC has two panels now. There's the investigative panel. It used to just be the Star Chamber and the people who investigated, also prosecuted, and also judged. But about 4 years ago, legislation was passed that broke it into two. So there's an investigative panel of lawyers, judges, and citizens who get the complaints and decide should there be charges or not. If charges are brought, then the formal charges, a lot like an indictment, are brought to the hearing panel. I'm the chair of the hearing panel. I have two co-panelists. One is a lawyer member, has to be a lawyer, and the other is a citizen member. And they're appointed by the governor and the Supreme Court, things like that. So we heard the case knowing only what was in the formal charges. So like a jury would. That's how it works now.
It's different. I've had the pleasure to file some JQC complaints. Just wrote out a little memorandum.
Yep.
And then I got a response, like, we've reprimanded the judge. It's basically the two I did, that's what they did. They just wrote me back and said, it won't happen again, and we've taken steps.
There are private reprimands that still happen, and those would all occur through the investigative panel. My panel would never learn about that because sometimes, let's say the judge just was a jerk to you, but it seems like it was an isolated incident. They may say to the judge, don't do that again, and it's in your file, but it's private.
Yeah, mine were legal issues like deprivation for some fundamental due process. I said, you can't do that, Judge. And Judge said, I'm going to do it. Tough, Mr. King.
Okay.
So I said, okay, do it. And we'll see.
So that judge may have been reprimanded. I don't know how long ago that was,
It was a while. It was
to over 10 years.
Yeah, so that would have been the old school, and it could have been Richard Hyde rolled up on that judge and said, don't do that again. It was a little freewheeling back then. But now.
So what do you think? Did the process work for you? I mean, your analysis?
So this is the fourth or fifth trial I've had, final hearing, we call it. It's working well. This just was a particularly complicated one because of these mitigating, not complicated legally, just working through all the steps this person has taken since the incident to get his life back into shape. And so he is anxious to return, and it's hard to reconcile what happened with this person who might be in some ways a better jurist because of it. But we don't look at it simply at the individual basis, but well, what about the institution? And how would someone coming into court think, knowing that, wait a minute, if I had done those things, I'm going to jail.
Right.
And this was a judge and the sheriff knew him. And so, hey, let's get you out of the way and you need to go get some help.
So was it where there was like an admission?
This happened to be an admission. Usually it is highly contested and we have Lester Tate on one side and Chuck Boring on the other. And but this is one where as
Chuck Boring, what's he prosecute them?
He is the director of the JQC.
I didn't know that.
Yep. But this was one where as part of the mitigation, the judge said, look, I admit everything I did, but here's why. And it's not because I'm a bad person situation.
Yeah, so the institutional consideration would be a tough one.
That's what we're struggling with.
Yeah.
Because oftentimes they contest the allegations. If the allegations are proven, it's pretty easy to say, well, first of all, you didn't admit you did these bad things. Now we found you did these bad things. You've offered no mitigation. You simply said either I didn't do them or they weren't bad. Well, we disagree with you. And so then a sanction flows from that.
Mm-hmm.
Everything has to be approved by the Supreme Court. So we will prepare what is effectively like a magistrate's R&R. We'll say, we think that this has been proven, clear and convincing is the standard, and this is what the sanction should be. Nice report, shoot it over to the Supremes, and they decide, yes, we adopt the R&R, we reject it, they do what they do.
Whatever.
Yeah.
It's interesting.
Can we see if he can see Mr. Pitts? Now that we got another person in here, thanks. He should be up. I think Deputy Gordon got everyone up. We did have one guy who was having an issue, but I think that they took him down. Yeah. Do what you do. Mr. Pitts. Should only be two people left up there, Pitts and Brown, but Pitts is the magic one right now. Do you want to speak to them in private?
And then bring him up.
Okay.
Hello? GCIC down. GCIC.
Is down?
It just says down on the radio.
The whole thing?
You said they check out. They check out. They have a pool.
Whoa.
Yeah, one in my office.
Yeah.
his memory. Okay. I did find it. 7 attempted calls to the victim. One that was actually made, these are from back, was made, was on June 9th, 2022. I just wanted to make sure you know.
No, I don't. I didn't know. I didn't know.
I did not specifically ask her that question. I asked her questions online.
So John, make that something. But just, I do not have the discovery.
Okay, it's one call, it's about 7 minutes, so I'll be sure it gets you.
Okay.
Are we ready?
Yes, sir. Shall I proceed?
In a moment, let's get everything on the record. Ms. Rivers, you ready? Ooh, let me also see what's happening. Good online. Okay. This is case 22 SC 182854. It's State versus Raquan Pitts. Mr. Pitts is represented by Mr. Kane, who is here in court along with his client. Hello, Mr. Pitts.
How you doing, sir?
I'm doing all right. Mr. Pitts, today we are going to talk about bond. Mr. Kane filed a bond motion on your behalf quite some time ago. So the fact that it's taken this long is not because Mr. Kane didn't file anything. It's because I have a busy calendar. But here you are, and we're going to work through it today. I will hear from Mr. Kane, and then Ms. Roth from the DA's office will present the DA's perspective about bond, and then I'll let you know what I'm going to do. Then I'll make sure discovery is flowing and that your lawyer has what he is entitled to so that we can make sure your case is moving along. Okay? All right, Mr. Kane, when you are ready.
Yes, sir. Good afternoon. Daniel Kane for Raquan Pitts. We have presented the court a petition for bond. Before the court is Raquan Pitts. He's currently incarcerated in the Fulton County Jail and has been for quite some time, I think around March of 2020, if I'm not mistaken. I'll give you some demographic background. Raquan Pitts is 22 years old. He's a resident of the city of Atlanta. He went to Frederick Douglass High School, completed the 10th grade. He was gainfully employed up until he was arrested at OSM. It's a warehouse, I believe, off of Thornton Road. He was a forklift operator, and I believe he can go back to work. His family lives here in Atlanta, his mother and his sister and others. The family is has a pretty strong nuclear bond, and they keep in touch with me.
There are, so you know, because you may not be able to see it, at least two Pittses on the phone. There's an Arthur Pitts and a Lena Pitts. And so proof that family is out there. They may not be here physically in court, but they're certainly plugged in.
And thank you for allowing me and the family to zoom in, because I spoke to Deidre last night, and she provided that information and I provided it to your family. So Raquan, Arthur Pitts is online watching this proceeding, and Lania.
And then my other sister.
And your other sister.
And there's a Jerica Glover as well. I don't know if that's a relative. That may be someone on the other side, but
I don't see. Oh, there's Jerica. Yes. Yeah, Jerica is a relative.
Okay.
I think she's a sister, isn't she?
That's the victim.
Oh, I'm sorry. Your sister, I'm sorry about Jerica. But your other sister called me last night. Anyway, so here's what we have. We've got 22-year-old petitioner, 10th grade Frederick Douglass High School, employed at the time of up to the time of his arrest. So late winter 2022, that puts him in jail like 6 or 8 months. Not a bad record. I think he has a simple assault conviction. I don't believe there's any felony convictions. This is a rather strange factual case. I'll kind of brief it for you. On or about the date alleged, which I'm not sure what the.
May 14th of this year. So I don't understand.
I don't know why March 1st I'm showing.
You had suggested Mr. Pitts had been in jail for a couple years.
No, not a couple years.
Oh, good.
I said March of 2022, and you're saying the date of offense? Yeah, it's May 14th, 2022. I'm sorry.
Okay. Maybe what you had said was March 2020. You had said something where my math was going, gosh, that's a couple of years that Mr. Pitts has been in. Either way, more than a day is a long time. So,
okay, so he's been in jail since May of 2000. Right. I'm not sure when he's been in jail, but the date of offense is May 14th, 2022. Yep. Okay, so here's what's going on. Jerica Glover is the mother of Raquan Pitt's child. So that's the child's mom. She was 18 years old at the time of this incident. She apparently went over to Raquan Pitt's home, which I think was also his parents' home. They have a child together, and there was some discussion about the child and or visitation. There is a wooded area near the parents' home. The parties are alleged to have, the parties mean Raquan Pitts and Miss Glover are alleged to have left the home and gone around the corner, parked the car, and then walked into the woods. It is the incident in the woods where it's alleged at times by Miss Glover that Raquan Pitts pulled a gun, discharged a firearm at her, which would account for this criminal attempt to commit murder and aggravated assault charge. And while Miss Glover and Raquan Pitts were in the wooded area, their newborn child, was in the car. So they walked out of the woods. There was no outcry. There was no rushing out of the woods. What happened was a disinterested third party from the neighborhood was walking and observed the child in a car. And that alarmed this individual, I call him a good Samaritan, and he notified the police, and the police came and they observed the child in the car unattended. So there's no adult, there's a kid in the car, and I believe it was a hot day or a warm enough day that there was concern, although one of the windows was halfway down in the car. That motivated the arriving policemen to investigate what is going on and why would the parties leave the child in the car. Now, there is some conflict here. Miss Glover apparently is accused. Miss Glover apparently may have been threatened with being arrested for child abuse or a child taken from her, and says, I was assaulted in the woods by this man and he discharged the gun. Police weren't sure whether she was telling the truth. They still aren't sure, but they went into the woods and they found a cartridge from a firearm, a spent cartridge. So that gave the police more credence to believe that what Jerica Glover was saying had some merit. So at that point, they arrested Raquan Pitts, I think for aggravated assault, cruelty to children. Thereafter, there was a monitored jail call between Raquan Pitts and Lillian Diaz-Ortiz. Incidentally, the court heard that bond petition several months ago.
This is the co-defendant who allegedly hid the gun.
Well, I don't know, hid the gun, but
she got the gun.
She got the gun. Yeah. So there's there's a conversation which I think was monitored. Should I continue?
Keep going.
Yes.
They've been muted.
So there is a jail conversation apparently in code between Raquan Pitts and Lillian Diaz Ortez to get the sneakers or something from the woods, or, you know. And the Fulton County District Attorney's investigator was monitoring the calls and obtained a search warrant for Lillian Diaz Ortez's home, went there, and the specific identifiable contraband was this firearm, and the firearm was apparently surrendered by Miss Diaz Ortez. Okay, so that's what we have. So we have a petitioner who doesn't have a really serious record. We have ties to the community, don't have a history of violence, no history of flight. He can stay with his mother, and he can go back to work if the court deems a bond appropriate. So that's it. Thank you.
So the dollar amount you're not recommending, you are saying though he ought to be eligible. I was just, as you were wrapping up, toggling over to see, it looks like no bond was the last entry. But that would have been 2 days or the day he was arrested, the 16th. So he's been in a no bond status throughout.
So we have May, June, July, August, September, October. Got
6 months.
About 7.
Oh.
Anyway, you know, these are working people without an awful lot of money.
Mhm.
You know, large bond amounts often amount to no bond. So I just asked the court to set a reasonable bond.
Understood. Okay. Thank you. Ms. Roth. And acknowledging that Ms. Glover is on, if she wants to be heard as well, she doesn't need to say anything at all, but if she wants to be heard or anything through, there had at one point been a victim witness advocate on. I don't see that person on anymore. However you want to work that.
Judge, I had spoken with Ms. Glover prior to today. I did not specifically ask her if she herself wanted to address the court. I did let her know I would relay what she had conveyed to me. Ms. Glover, do you want to address the court, or do you want me to handle it for you?
You can go ahead. What I told you.
Sure. Okay. So Judge, I will start with that actually. Judge, I did have a chance to speak with Ms. Glover yesterday. In speaking with her, I informed her of the bond hearing on today's date. I asked her what her position was on the defendant receiving a bond. At that time, she indicated to me that she did want the defendant to receive a bond. When I asked her about her reasoning for that, she indicated she wanted him to be able to see his daughter, and in discussing that with her, I talked with her. I said, I've looked over the facts of this case. That gives me some concerns for your safety. Do you have concerns for your own safety? She indicated that she does have safety concerns for herself and her daughter. She indicated at one point she has concerns regarding the defendant's stability. And if Your Honor was to grant a bond, she said that she would want childcare exchanges to go through a third party and any visitations with their daughter to be supervised based on those concerns that she has.
Is their daughter the child who was left in the car?
Correct.
They have one child together. That's the daughter who was left in the car.
I know the child they share together is the one left in the car. Is that the only child you share together, Ms. Glover?
Yes.
Judge, in further speaking with her, Ms. Glover indicated that her aunt actually spoke with the defendant's sister. And part of that was because Ms. Glover wants her child to know that part of the family. And while the defendant has been incarcerated, she has been working to ensure that her child still has visitation. And I know she even asked me about setting up some sort of visitation for their daughter to be able to see her father even while he's in custody. It's my understanding she was told that the defendant's family indicated to her that they did not want to see her daughter unless and until the defendant was out of custody. In speaking with her, it was clear to the state that Ms. Glover was feeling extremely guilty based on the family situation. It's my understanding the defendant's grandmother is not in good health. Ms. Glover was also concerned about not wanting her daughter to be cut off and having those last days with what would be her great-grandmother. Ms. Glover also indicated that she thought family therapy for the three of them would be beneficial if Your Honor was to grant bond in this case. Ms. Glover had also been informed that by the defendant's family that the defendant had attempted to commit suicide several times while in custody, and they indicated to her it was based on him not being able to see his daughter.
Was there not a condition? I guess Mr. Pitts didn't have a bond, so there's not a condition telling Mr. Pitts's family, leave Ms. Glover alone, because that's effectively contacting Ms. Glover on behalf of Mr. Pitts, which is not what should be happening.
So Judge, that would be the state's position, right? Is that Ms. Glover is being emotionally manipulated by the defendant's family in order to influence her position on bond. And I think the fact that even though she's saying she wants him to receive a bond, the fact that she still has these safety concerns should speak volumes to the court.
Does Ms. Glover have family in the Atlanta area, or is she in perhaps some way more dependent on and connected to Mr. Pitts's family?
Judge, I do not know that. Ms. Glover, do you have family in the area?
It's really just me, but I do have an aunt who I stay with currently, and that's really about it. That's like my only support system is my aunt and myself. My dad just passed away in June, and yeah, so no, but yeah.
Thank you. Judge, as far as the facts of the case, for the current case, I don't have a lot to dispute with defense counsel. One thing I would add, though, is when Ms. Glover and Mr. Pitts came walking up out of the wood line, both of them were immediately detained. I know defense indicated, well, there was no outcry. They were both immediately detained based on their child being in the car. At that point is when Ms. Glover let officers know what had happened in the area of the wood line. She also indicated that she was walked out to the wood line at gunpoint. And when they were out in that location, Mr. Pitts aimed the firearm at her and shot once. She relayed to officers that she felt the bullet go past her head. And at that point, the gun jammed. And so she went to struggle with Mr. Pitts over the firearm. He was able to rack it and fire one other shot. And sometime after that is when they came up out of the wood line.
Did the shell casing that was recovered from the woods match the gun that was recovered from the co-defendants, Ms. Diaz-Ortiz's house?
I don't think there's a forensic report from the GBI yet.
Okay.
Judge, I know that we had been working on that. I don't know.
Not yet known.
I don't know if I have a definite answer for the court on that.
Okay.
Your Honor, regarding past history, the defendant does have one simple assault family violence conviction. That was from April 10th of 2019. Based on the final disposition, I believe that case involved his parents. Part of the probation terms were no violent contact with parents. And so that's why I say that, but I don't have the accusation.
Didn't involve Ms. Glover as the victim?
No, I don't believe so
Okay.
for that one, Judge. However, when this incident occurred, he had another case pending. That is 22 CR 000818A. That was down in state court. That case did involve Ms. Glover. That involved an incident date of November 27th of 2021. For that incident, police were dispatched and Ms. Glover indicated to officers that The defendant had dragged her, and she had her child with her at the time, on the ground. He took her phone and left prior to law enforcement's arrival. So he was facing charges in that case. And part of his bond in that case was that he had a stay away from Ms. Glover and the minor child as part of his bond. That bond order was issued on February 17th of 2022.
Okay, so that's not aggravated stalking? I don't see a charge here for that.
Judge, I do not see a charge for that
Okay.
either. But he did have that bond order. And so.
Can I have the state court number again, please?
Yes, Judge. It is 22 CR.
Yep.
30818A.
Thank you.
So Judge, the state would not necessarily argue that the defendant poses a risk of flight. However, the state would absolutely argue that he is a high risk of reoffending and a risk to both the victim and to victim intimidation. Regarding the risk of reoffending, again, that goes back to the fact that he was already out on bond when he committed this case. Additionally, while in custody, Your Honor, he obviously picked up the additional charge of tampering with evidence based on phone calls and enlisting his current girlfriend to tamper with evidence. And so even while he's been in custody, he's been actively picking up new charges. Regarding the risk to the victim and to possible intimidation, it's the state's position he does pose a risk of witness intimidation, even if he were not to reoffend as it relates to this victim. And perhaps, obviously the state is always concerned of an additional act of violence as it pertains to Ms. Glover. The defendant and his family are also clearly engaging in tactics to influence Ms. Glover, even as it relates to the bond hearing. Your Honor, while the defendant has been in custody, he has also made seven different calls to Ms. Glover. Only one of those was accepted. So the other 6 were unsuccessful or weren't answered. That call was from June 9th of 2022. In that call, the defendant briefly discusses a waiver of prosecution with Ms. Glover and the fact that the house was searched and a weapon found. During that conversation with her, for that part of the conversation, he is speaking in code. He says someone's house was raided, something was found, it was bad. He eventually asks Ms. Glover to go and speak with his mother in person. There is no indication as to what the purpose of her speaking in person with his mother would be. And he also, towards the end, asks if he can call her again. Your Honor, I understand part of defense counsel's argument was that he could go and live with his parents, but my understanding was from defense counsel's argument was also that he was living with his parents at the time of these offenses. And so based on all of that, Your Honor, the state is opposed to bond in this case.
All right, thank you. Ms. Jackson, can you share with me what you have on Mr. Pitts's criminal history, please?
Yes, Judge. The defendant has 4 cycles. The defendant's last arrest was February the 16th, 2022 for simple battery family violence. There was no disposition for that arrest and there were no convictions listed in the GCIC, Your Honor. Nothing in addition.
Thank you. And Ms. Tucson, is Mr. Pitts on any active probation in Georgia?
No, Judge, I don't see any prior record in portal for felonies.
Okay, thank you. Mr. Kane, anything you want to say as the movant
Yes,
in summation?
Yes.
Okay.
I think we're in agreement. The agreement is that Raquan Pitts is petitioning the court for bond. And Miss Jerica Glover apparently is petitioning the court that Raquan Pitts get a bond. So I believe the court can set certain conditions, and we know what they are: the stay away, the supervised visitation, the no contact only through a third party, do that through the police or through a relative. And I'm trying to do some math as learned counsel is arguing her case, Ms. Ross, and here's what I present to the court. Kidnapping, 5,000, criminal attempt to commit murder, 20,000, aggravated assault, 5,000. And then there's cruelty to children, 1,000, possession of firearm during commission of a felony, 1,000, obstruction, 1,000, and tampering, 1,000. So it's not a giveaway bond. It's certainly enough, I think, to secure. I don't know if family can make that, first of all, but I think it's enough that should satisfy the court's concern. And I just wanted to note that there's a lot of talk in the state's argument about the defendant contacting Ms. Glover, but Ms. Glover's contacted the defendant and his family, and I keep telling everybody to stop it.
Yep.
It's kind of on my orders, don't engage it. So anyway, I'd ask the court to set a reasonable bond. Thank you.
You're welcome. Thank you for sharing that. Mr. Pitts, I don't know the full history of your relationship with Ms. Glover. It sounds like parts of it were great. You have a kid. Parts of it weren't so great because you've had some issues. But I do know this. In February of this year, in fact, it was, what would that be, 2 to 11, 9 months to this day, February 17th of this year, Judge Lal signed an order granting you a $5,000 bond. And one of those conditions was no contact with Ms. Glover and your child. And then I know if we fast forward 2 to 5 is 3 months, less than 3 months, 3 days short of 3 months, I know you were with Ms. Glover and your child because you got arrested with Ms. Glover and the child was in the car. So the notion that if I were somehow to put in a bond, leave Ms. Glover alone, you'd follow my direction rather than Mr. Keynes, who's the guy you should listen to most of all, or Judge Law, I'm not convinced. I don't think it really matters what people tell you. You and Ms. Glover have a situation. It's good and it's bad. And Ms. Glover's going to want to see you. You're going to want to see her. And problems happen. And I'm not assigning blame to one or the other. I don't know what led to your case in state court in a simple battery. And I'm sure there are two sides to it. And there are probably two sides to this case as well. But it gets more serious. The situation in state court is a simple battery. Now we've got a situation where it sounds like a gun was discharged. There's a shell casing, there's a gun, the gun was hidden. It's getting more and more dangerous for you, for Ms. Glover, for your kid. And we're going to need to resolve these things once and for all. I think the safest thing for you and Ms. Glover, and really most importantly, your child, is for you to stay where you are until Mr. Kane and Mr. Whitenauer can sort out what they're going to do with these more serious charges. The state court case will follow right on behind that. But I agree with much of what Mr. Kane said, except that one little piece that I could establish a condition that would keep you and Ms. Glover apart. Because jail doesn't keep you apart. You're calling her. And she may be asking you to call her, but you're still calling her. You can talk to him in a minute. Let me finish. So at this point, I'm going to deny bond. And it's not often that I deny bond when the alleged victim is saying set a bond. But I have seen scenarios like this enough in my time as a prosecutor, as a judge, to know that not everyone involved is thinking rationally, and they're thinking maybe more emotionally. But these immutable facts, you had a bond, you were supposed to stay away, and then you didn't, tells me that it really doesn't matter what I put on paper, an ankle monitor, a curfew, or this or that. If your heart is telling you to be with Ms. Glover and her heart is telling her to be with you, that's what's going to happen. And it can't until we sort this out. You're welcome to talk to Mr. Kane now. I just needed to finish my part.
Speak to the court.
I never had ankle monitor before. I was wondering if I had ankle monitor, I'd say with.
Okay, so may I be heard?
Yes.
The amended request of Mr. Requan Pitts is he's never been on an ankle monitor, and therefore he could be monitored. Excuse me?
I'm gonna listen.
Pardon me?
I'm gonna stay away from the video.
Oh, there would be empirical data that he was staying away from Ms. Glover.
Got it.
So he's asking the court to amend its order to grant a bond with the condition of ankle monitor.
So should I grant a bond, you can be confident that it'll be an ankle monitor. It might be two, like one on each leg, but I'm not doing that now. If this case slows down because the state isn't ready with something, they can't get that shell casing tested, or Mr. Whitenauer is too busy doing something else, Mr. Kane comes to me saying, we've been ready and we can't move this case forward, then we should talk about bond again. And then, because the state has delayed things, hypothetically, they've delayed things, we can talk about bond because you will have been held for an unreasonable period because the state's not ready to proceed. They've moved relatively quickly with this case. If they continue to do so, then you're going to be where you are, and Ms. Glover is going to be where she is, and the two will not meet. It's in your best interest for you not to make any more calls to her, even if you hear she wants to talk to you. It is in your best interest if your family doesn't reach out to her. Even though Ms. Glover may say, I want my child to spend time with your grandmother. That's just not how things can flow until Mr. Kane has a chance to try to resolve your case with Mr. Whitenauer. So, Mr. Kane, I invite you to renew your motion if you are running into delays caused by the state. Otherwise, this case is moving along at a pretty healthy clip. Again, I had misunderstood you when you had told me, I thought Mr. Pitts had been in since May of 2020. And that's a very different situation. I don't mean to suggest that it's been a cakewalk for you and you've only been in jail for 30 seconds. You haven't. You've been in for a long time. But that is what I believe is the safest place for everyone involved, unless and until the case is resolved or the state for some reason slows things down. So I'll keep ankle monitors in mind. Ms. Roth, anything else for the state?
Nothing to add, Judge.
Mr. Kane?
Nothing further, Your Honor.
Do you have all the discovery you think is, you have reason to believe is out there?
No, but we're working on that. We have a sidebar conference that is coming, so we're
Good.
good.
Mr. Whitenauer is pretty good about sending those Dropbox links and whatnot. If you run into the issues like that, let Ms. Nelson know. And like I said, we'll tee up another bond hearing if they haven't done what they need to do.
Yes, sir.
Thank you.
Thank you. May I be excused?
You may.
Thank you. Okay, Rack One, you good? Good job.
I'm gonna email that. That is a John question.
Ms. Nelson, if you can hear me, can you try to track down Mr. Matthews? Because it's going to be hard to do the bond hearing without him.
Nice to meet you in person. Pierce. Oh, yeah, yeah. You have, what do you distances? Yeah, I was the attorney on that.
Oh, man, that was.
Yeah, I heard y'all resolved it though.
We did. So you had the car stop case with the
Yeah.
gummies in it? and all
Yeah.
that?
Yeah.
When are we gonna stop prosecuting marijuana, you know?
Well, that wasn't the issue in that case. It was the 15 financial transaction card.
Oh, the cards, yes, from the girl from rental car company?
Yeah. Yeah.
So the little rental car company, yes.
Yeah. So there was more. There was a
There
lot
was
more
more to it,
actually to that case. He wanted to forget about the financial cards too.
Well, he had witnesses that said that they were ortiz, but anyway.
Yeah.
It's good to
Nice
meet
to meet
you.
you. Is there, I know I'm sending you that jail call now. Is there additional discovery?
I don't
other
like
than
the gun.
ballistics? Okay, yeah.
Might as well just send me everything. I don't know if I have it.
Well, when I was looking at the certificate of discovery, it looks like he sent you everything that he had.
You know when? You know when that was?
Hang on one second.
If you can, just re-forward it.
So it was sent on July 11th. Yes.
Just forward it.
Yeah. It has all the prior reports. It's got.
Is all the what?
The prior reports.
The police report? I have that, so I must have received it.
Okay.
So tell John we met. that you'll give me the other.
Yeah, I'm
the phone
sending you the call right now.
But tell him that I'd like to work it out.
Okay, I'll let him know that you want to look it out.
And see where his head's
We're
at.
still waiting on ballistics and keep an eye
If we
out.
get something. we can-
Gotcha. Okay. All right, I'll let him know.
Okay, see you, Melissa.
All right, good to meet you.
At least your attorney showed up. I feel disrespected.
You feel slighted?
Yeah. Think you haven't seen this guy. You see that you said.
All this afternoon here now.
How many months ago was that? Jesus.
Do you typically have to be asked to be excused? Okay, got it. Thanks.
Mr. Hand, had you heard from
Mr.
Matthews?
No, Judge, I have not.
Okay.
Judge, my business is concluded. May I be excused?
Yes, ma'am. Thanks for your time.
Would you like me to try to reach out to him, Judge?
No, Ms. Nelson, you're welcome to. Ms. Nelson is as well. I just was curious if
If he had contacted me, no.
we had a sighting.
All right.
All right, Mr. Hand, it is 30 minutes after the time Mr. Matthews was supposed to be here. He is not, so we're going to wrap up. We're going to see Mr. Brown anyway on the 9th on a status conference calendar, and he's tentatively on the February trial calendar. Okay. It's a case that almost worked out before, but anyway, it's the kind of thing that we'll just push to the 9th of December when he's here for the status conference.
Okay. And I think I have another case with him that's on the trial calendar that you put back on.
Well, hold on. Let me just release folks so we can talk about that. Thank you, Ms. Jackson and Ms. Tucson. You guys are good to go. Appreciate your help today.
Thank you, Joe.